Hey, hi guys, this is Arpita Tulsyan here. I hope you all are doing good. So here we are with a super quick revision of CA Final Law, Company Law part. Economic Laws and Securities Law we have already uploaded and it is available on our YouTube channel. In this particular video, we are going to cover each and every chapter in detail from exam point of view. Do let me know if this lecture was helpful for you. As always, keep showering your love on us. And yes, for your November 22 examinations, if at all you want to refer the book along with this revision video, then yes, the 9th edition book is applicable for the November 22 exams, which is available on our website www.arpitatulsyan.com. So you can take it from there and refer it along with this revision lecture. Yes. So yes, you may continue with the lecture now. Thank you so much and all the best. Let's start with the super quick revision of the first chapter of company law, that is companies incorporated outside India, ranging between section number 379 to section number 393. First one, the most important thing, that is the definition of the foreign company, which is given in 242. It means any company or a body corporate which is incorporated outside India, which has a place of business in India, either by itself or through its agent, either physically or by electronic mode, and it should be conducting some or the other business activity in India in any other manner. If all these three conditions are fulfilled, then in that case, such a company will be treated as a foreign company as per the Companies Act 2013. Carrying on business by way of electronic mode, examples of that can be B2B transactions, B2C transactions, it can be telecommunication, telemarketing, relating to education, relating to information, IT, relating to research. It can be anything, irrespective of the fact wherever the main servers of that particular company is installed, irrespective of that fact. And one more deeming section which is given in section number 3, one more deeming provision which is given in section number 386. That is, if a company has a share transfer office in India or if a company has a share registration office in India, then even that will be deemed to be having or that will be assumed as a place of business in India or having a place of business in India. Right? Now, for making a particular company as a foreign company or treating a company as a foreign company, we have to make sure that the three provisions which were given in section 242 are getting fulfilled. The fact that the company has been floated or the company has been incorporated or the company has involvement from Indian citizens does not change the nature of the company. Even if the company has been incorporated by Indian citizens, then also the company will be treated. As a foreign company if it fulfills all the criteria of section 2 clause 42. Then going on to the main provisions now, section number 379. Section number 379 talks about the applicability. Now suppose if there is a particular company which has fulfilled the requirements of 242, then it will be treated as a foreign company, and section number 380 to 386 and section number 392 and 393 will be applicable to such foreign companies. This is what they say primarily. Okay, now if there is any such foreign company where more than or equal to 50% of the paid up share capital, that is equity plus preference, is held by one or more Indian citizens, or it is held by one or more Indian companies, or it is held jointly by both, means majority of the share capital is held by such Indians, then in that case the company will still be treated as the foreign company only, just that for the purpose of applicability of the provisions, the company will be treated at par with an Indian company, and if it is treated at par with an Indian company, then all the provisions pertaining to an Indian company will be applicable to such foreign companies as well. Then going on to the next very important section, that is section number 380. Section number 380 talks about whenever a foreign company wants to come in India, it wants to establish a place of business in India and wants to do some business activity in India. After that, it has to get itself registered with the ROC. Okay, now what is the procedure for registering itself with the ROC? First of all, you have to submit list of 8 documents to the ROC. First one, certified copy of the charter document or the statute, just like your MOA, AOA. In English. If it is not in English, then the certified translated copy has to be submitted. Then we have to give the address of the principal office, that is outside India. we have to give the address of the registered office in India. Then we have to give the name of the authorized person, name and address of the authorized person who is authorized to receive the or who's authorized to transact the business in India, or authorized to receive the documents or notices in India. Will give his details. Then fifth point, we are going to give the details of all the directors and the secretaries. Their full personal details will be given. Their name, their address, their passport number, their PAN. Then if it's a secretary, then the secretary's membership number, their email ID, their date of birth, father's name, mother's name, spouse name, and nationality, email address, etc. Everything has to be provided there. Then after that, 5 points done out of 8. Then after that, we are going to give the information about the past dates if we had ever opened a place of business in India. When did we open it and when did we close it? That details has to be submitted. Then we have to give a declaration which will be given by all the directors that they are not convicted from incorporating a company either in India or abroad. That declaration will be signed by the directors and the authorized person. And last, if there is any other information as may be required by the ROC, then we'll have to give those details. Okay, this was the list of 8 points. So now we are going to use form number FC1. We'll use form number FC1, plus we'll pay the fees, plus we'll attach this eight list of documents along with the form, plus we will give the attested copy of approval that we have obtained from the RBI as per the FEMA Act 99, plus attested copy of approval from any other regulator if at all it is required, and if not required, then in that case we'll give a declaration that no such approval was required. All these things will go and submit it to the ROC having jurisdiction over New Delhi, irrespective of the fact that wherever the place of business of this particular foreign company is situated. And anyone who had started the procedure of registering a foreign company as per the old law will have to continue in the old law itself. They need not transit themselves into the new law. Okay, and whenever we once we go and submit this to the ROC in form number FC1, this has to be done within a period of 30 days from the date of establishment of place of business in India. Means after establishment also you can go, but within a period of 30 days you have to take everything and you have to go to the ROC. And if there is any change in the details that we have submitted to the ROC, then whenever such changes happen, then we are supposed to file form number FC2, which talks about the changes in the data which we had submitted to the ROC, and that has to be submitted within 30 days from the date of such change. Whenever that change happens, from that day within 30 days we'll go to the ROC. And last point, that is whenever the place of business in India is to be closed. Okay, whenever a place of business in India is to be closed, then in that case, we are just supposed to give a notice to the ROC that, sir, we are closing down our place of business in India. And from that day, all our obligations of submitting the returns or submitting the information or documents to the ROC gets over then and there itself. This was contained in section number 380. Now going on to section number 381, which was very, very simple, talking about the accounts and audit of the foreign companies. So every foreign company is required to prepare their financials, their books of accounts, their balance sheet and the P&L in the prescribed manner, containing the prescribed details, and such documents should be attached as may be prescribed. Okay, then in the later part of the section, they'll also say that they have to try to prepare their accounts to the extent possible, or they have to try to prepare their financials to the extent possible in the Schedule 3 format. That has to be done. These financials has to be prepared in English language. If not in English, converted into English. This will be prepared and this will be submitted to the ROC in every year or in every calendar year. Every year this is going to be done, and this has to be done within a period of 6 months from the close of the financial year, whatever is applicable to them. If there is any sufficient cause for delay, then in that case, ROC can provide you an extension of maximum 3 more months for submitting these financials to the ROC. While preparing the accounts, we have to make sure that section number 128 to 138 provisions are fulfilled. These accounts should be audited by an Indian CA. While doing that, the provisions of section number 139 to section number 148 will be applicable. Along with these financials, we have to also attach the consolidated financials of the entire entity, plus we have to attach the details about the related party transactions, plus about the repatriation of profits and repatriation of funds to their home country. All these details will be taken up together, and then these will be submitted to the ROC within 6 months plus 3 months if it is required at all. Okay. Then along with this financials, you are also going to attach a form called as form number FC3, in which you are going to include all the details of all the list of place of businesses that you have in India as on that particular balance sheet date. Along with the financials, you will attach it, and the form that is that is attached along with is form number FC3. Then after that, going on to the next section, that is section number 382, which talks about display of name. Every foreign company, it has to display its name, its country of incorporation, and the fact that the company's liability is limited. Okay, that has to be displayed outside its place of business, and it has to be displayed in the letterheads, bills, documents, etc. When you're disclosing it or displaying it outside the place of business, then it has to be in English and plus one local language. But when you're putting it in the bills, letterheads, etc., then in that case, even if it is in English, that would be sufficient. Then going on to the next section, that is section number 383, which says 383 talks about service of notice or service of documents on the authorized person. So they are telling that if ROC wants to issue notices or if ROC wants to serve notices on this particular foreign company, then it will be deemed that it is properly done if it has been addressed. If it has been addressed to that particular authorized person and it has been sent to the address which was given to us at the time of registration, and that can be sent by, or that can be given by way of hand delivery, by way of post, or by way of electronic mode, that is by way of email. If it has been done by this way, then it will be deemed that the notice that has been served on the foreign company is totally validly served. Okay, it will be deemed as if it is validly served. Then after that, going on to the next section, that is section number 384, which is a reference section. 384 simply says that we had already studied it initially in section number 379, that to a foreign company, section number 380 to 386 and 392 and 393 would be applicable. But it's not that only these sections are applicable to a foreign company. Section number 128 to 148 is also applicable to a foreign company. If a foreign company issues prospectus, then provisions relating to prospectus is also going to be applicable. Provisions relating to inspection, inquiry and investigation, which ranges from 206 to 229, even that will be applicable. Provisions relating to annual return given under section number 92 will also be applicable to them. CSR provisions will also be applicable to them. So it's not that it is restricted only to 380 to 386. Because of section number 384, the scope of sections becoming applicable to a foreign company has increased. Okay, one important thing and one new thing to be done in this particular section here is every foreign company is required to submit its annual return, which is going to be in the format called as FC4, and this annual return will be submitted to the ROC within 60 days from the year end, and it will contain the required particulars as on a balance sheet date. So annual return of a foreign company goes in form number FC4. Okay, next section, that is section number 385, which simply talks about payment of fees to the ROC. Just like it is applicable for every Indian company, even for a foreign company, whenever it is filing any documents, whenever it is filing any returns with the ROC, whatever is the prescribed fees, it goes without saying, whatever is the prescribed fees by the ROC, that company is required to pay that. Next few sections are going to talk about the prospectus now, which is very, very simple. First of all, section number 387, which talks about dating of prospectus and the content which should be there in the prospectus. Okay, now these provisions will be applicable to every foreign company which is going to issue a prospectus in India. Okay, either it has been already incorporated outside India or it is going to be incorporated outside India. But if it plans to raise money from India, then the provisions of prospectus is going to be applicable. You cannot issue, distribute, circulate any prospectus in India unless it is dated and signed. That is very, very important. Okay, we will see who is going to sign the prospectus in section number 389, but signing of the prospectus is must. Now, matters which will be there in the prospectus. Now, we have got one section called as section number 26 in our Companies Act 2013, which talks about the matters to be contained in the prospectus. Those matters will be anyway there in the prospectus. Right. Along with that, there are 5 other things which are to be included in the prospectus specifically from a foreign company point of view. What all things are there? First of all, the law under which the company is incorporated. Then after that, we have to give 2 addresses. One is the Indian address where the documents can be inspected, and another thing is the address of the principal office in India. Suppose if you have multiple offices in India, then the principal office address has to be given. Then after that, the date and the country of incorporation, the home country, the main country. And last one, you have to attach the charter document, that is the instrument defining the constitution of the company. All these things have to come along with the prospectus. These 5 things which is given here, this is specifically applicable in case of every foreign company, right? Then after that, going on to the next section, that is section number 388, which says that every prospectus, just like it was applicable for Indians also, for Indian companies also, even for foreign company, the prospectus should compulsorily consist of experts' consent or experts' opinion, and that should not be withdrawn. Okay, so first of all, if the expert has not given his consent, you cannot issue prospectus. If the expert has given his consent, but before registration he withdrew his consent, you cannot distribute the prospectus, you cannot issue or circulate the prospectus. And the prospectus should compulsorily contain a statement that it has expert consent and that has not been withdrawn. Then it will be treated as valid, and then only you can issue, circulate, distribute that particular prospectus. Then after that, going on to section number 389, they say that before you come up with this prospectus in the open market, or before you come up with this prospectus in before the public, make sure that the prospectus, first of all, it should be dated and signed. Next thing, it should be registered with the ROC. It should be written on the face of the prospectus that this has been delivered to the ROC, so that public get a satisfaction that yes, at least it has been registered with the ROC. Now, along with this prospectus, when you are going and getting it registered with the ROC, you have to make sure that you submit some extra things to the ROC. 5 extra things are to be submitted to the ROC. Okay, what are those? First one is a repeated thing, that is expert's consent should be there. Next thing, the copy of contract or arrangement with the MD or manager that you have entered, that is with your managerial personnel. Then after that, any material contract entered during the last 2 years which is not in ordinary course of business. Then the copy of underwriting agreement and the copy of power of attorney if the prospectus couldn't be signed by the directors. These 5 things extra along with the prospectus will go and submit it to the ROC for the purpose of registration. Okay, and this prospectus should be signed compulsorily by chairperson of the company and by 2 directors of the company. Chairperson has to mandatorily sign. If the directors are not able to sign, by chance if the directors are not able to sign, then in that case they can issue a power of attorney in favor of any other person who can sign the prospectus. This was covered in section number 389. Now going on to the next section, that is section number 390. 390 talks about IDRs. Now every foreign company, maybe as per section number 242, or any foreign company incorporated outside India or to be incorporated outside India which does not fall under 242. If anyone wants to raise funds from India by way of IDRs, then 3 things are very, very important for it. It has to comply with all the CG rules. Okay, it has to comply with the SEBI ICDR regulations, and it will also have to comply with the RBI directions if at all given by the RBI. These are the 3 things. These are the 3 things that is going to be applicable in case of IDRs. And then they have just explained you the concept of IDR, where the foreign company wishes to raise funds from India. So with the help of a domestic depository, they issue IDRs in India which is denominated in Indian currency, and ultimately the capital flows from the Indian investors to the foreign company through the domestic depository. Then after that, the next section, that is section number 391. 391 talks about 2 subsections. First subsection simply says that any foreign company which is issuing any prospectus, or any particular foreign company which is going to issue its IDRs, in that case they will still be liable like if at all there is any misstatement in the prospectus, or if say for example they are fraudulently trying to induce people to invest the funds in the company, fraudulently trying to induce, then in that case they will be liable under section 34 to 36. 34 talks about criminal liability, 35 talks about civil liability in case of misstatement of the prospectus, and 36 talks about punishment for fraudulently inducing persons to invest in the company. So this section will be also applicable on the foreign company. This is what they are trying to say, right? And then section number 391 subsection 2, where they say that, say for example, if there's a foreign company which has raised some funds from India and now it has done some default in redeeming those securities, or either redeeming or for repayment of those securities, then in that case Indian Companies Act has the power to do the winding up of the Indian operations of such foreign company as per chapter number 20 of the Companies Act. This power has been given to the Indian government, or this power has been given to the Indian laws by way of section number 391 subsection 2. So that was section number 391. Now going on to section number 392, which is super duper important. 392 simply says that if you have contravened the provisions of this particular entire chapter, anywhere if you have contravened the provisions, then in that case you will be liable for punishment. The foreign company will be liable for fine, which is going to range between 1 lakh to 3 lakhs. In case of continuing offense, it can go up to 50,000 rupees per day. And in case of persons in charge, we will be liable for fine, which is going to range between 25,000 rupees to 5 lakh rupees. Earlier we used to have imprisonment here. Now the imprisonment provisions have been totally removed and amended. Then after that, going on to the next section, that is section number 393. Suppose if there is any particular foreign company which has contravened the provisions of this particular chapter, then what will be the effect on such foreign company? So all the agreements, all the contracts which has been entered into by the foreign company will still be deemed to be valid. Okay, we can sue them. They cannot institute any legal proceedings against us, and they cannot claim any set off in debts. They cannot claim any set off in the debts at the time of payment to any particular party in India. Then the last section, that is section number 393A for the chapter, which says that central government can anytime exempt any foreign company or would-be foreign company from any provisions of this particular chapter, from any sections that we have studied in this particular chapter, if it thinks that it is necessary to do so. And that can be done by way of passing a notification in the official gazette and by placing that notification before both the houses of the parliament. And wherever, as per rule number 12, wherever the central government is of the opinion, or wherever the ROC is of the opinion, or the Act is of the authorities under the Act are of the opinion that we are fraudulently dealing or trading in the name of a foreign company. Okay, we are not a foreign company, but we are fraudulently dealing or trading in the name of foreign company, then it can do the investigation under section 210. It can do the investigation under section 210 of the Companies Act 2013. This was all about the provisions of companies incorporated outside India. I hope you were able to recollect. Okay, so let's start with a super quick revision of the next chapter, that is NCLT and the NCLAT. We have got a few sections from this particular chapter. One is section number 407, and then we have got from section number 420 to section number 434. Yes. So now NCLT, NCLAT are basically your appellate tribunals. It talks about the authorities who are going to deal with appeals under the Companies Act 2013. Full form of NCLT is National Company Law Tribunal. NCLAT stands for National Company Law Appellate Tribunal. Yes. Now there are going to be certain authorities who are going to be there in this particular function. Let's talk about NCLT first. NCLT has got a head called as president. Okay, so we have got a president of NCLT, and within NCLT you have got two types of members. One is your judicial members and another one is your technical members. Okay, so head is called as president, then you have got judicial members, you have got your technical members. This was for your NCLT. Now when we talk about NCLAT, NCLAT's head is called as the chairperson. ठीक है, जो सबसे ऊपर वाला person हो गया उसमें वो chairperson हो गया. And फिर NCLAT के अंदर within NCLAT we have got our judicial members as well as our technical members, right? So this way, this is basically the composition of your NCLT and the NCLAT. Head of NCLT is president, head of NCLAT is chairperson. Both of them are going to have judicial members and technical members within it. Very clear with this? All these definitions are given in section number 407. Okay, now going on to the next series of section, starting from section number 420. Now 420, first of all, as you already know, as you have studied earlier also and in other laws also, economic laws, etc. also, first level of authority is going to be the NCLT, next level of authority is going to be our NCLAT, and in Companies Act also, the last level of appeal authority is going to be Supreme Court. Okay, so now I hope you are aware with the hierarchies now. First one is NCLT, next one is NCLAT, and the last one is your Supreme Court. Okay, so first the matter is going to go to the tribunal. Okay, if there are any two parties who are there in dispute, first the matter is going to go to the tribunal, that is to the NCLT. NCLT will pass the necessary orders, whatever is required in whoever's favor it can be. NCLT will give the reasonable opportunity of being heard to all the parties, and then it will pass an order. Okay, now suppose if NCLT is of the opinion that there is some mistake in the order passed by it, then it can rectify that mistake which is apparent from record. Either it can do on suo motu basis, or it can do when either of the parties tell the NCLT that there is some mistake in your order. Okay, for that, see the provisions that they have given. This is important. Such orders, means the order of NCLT can be rectified within 2 years by the tribunal due to any mistake apparent from record. It cannot change its opinion. Okay, but if there is any mistake which is clearly visible, okay, maybe 1 0 extra, 1 0 less, that kind of a mistake, then it can be done by the tribunal within a time period of 2 years. Okay, but if that particular order has already gone into an appeal before the NCLAT, that there is a possibility, right? One of the party has done a further appeal and the matter has gone to the NCLAT, then in such case, okay, that particular order cannot be rectified. Okay, no mistake apparent from record can be rectified at that level. Very, very clear with this. So first the order is going to be passed by the tribunal. Now suppose if we are not happy with the order which is passed by the tribunal, then in such a case we are going to take the matter to the NCLAT. Right, either of the party can take the matter to the NCLAT. We have to go to the NCLAT within a time period of 45 days from the date of receipt of order from the NCLT, within 45 days. But if there is any sufficient reasons that we could not go within a time period of 45 days, then it can be further extended by 45 days. Means you can get an extension of another 45 days, but only if there is a reasonable cause to believe that yes, the delay was due to some genuine reasons. Okay, we went to the NCLAT. NCLAT will give ROBS to all the parties and then it will pass the final order. It can confirm, modify or set aside the order which was passed by the NCLT, and all these, be it the NCLT, be it the NCLAT, these people have to try to do expeditious disposal of the appeal. Means as soon as possible, please solve this particular appeal, and that has to be done within a time period of 3 months. Okay, that has to be done within 3 months from the date of filing the appeal. Means whenever we take the appeal before them, they have to try to dispose it of within 3 months, and it can be further extended by maximum 90 days. But in that case, the president or chairperson, president of the NCLT, chairperson of the NCLAT, they can extend this period of 3 months by maximum 90 days by recording the reasons in writing. Okay, they have to record the reasons that why there is a delay and why extension has been provided. Very clear with this? Okay. Next, suppose if we are now not satisfied with either of the parties not satisfied with the order of the NCLAT, then we can finally take the matter before the Supreme Court, but only if it involves question of law. Okay, only if it involves a question of law, you can take the matter to the Supreme Court within a time period of 60 days, which can be further extended by 60 days if there is a sufficient cause. Okay, and we cannot tell that Supreme Court has to dispose of the matter within how much time. Okay, Supreme Court will take its own sweet time, but we have to go and file an appeal within a time period of 60 days from the date of receipt of NCLAT's order. Okay, so first was NCLT, next is NCLAT, and the last is your Supreme Court. Very, very clear with this? Yes? Okay, so till year, basically all your sections were super duper important. Okay, till section number 423, all the sections were very, very important. After this, right from section number 424 to the last section, these all are one-time read sections. We'll just have an overview of the important points given up here. Now, what they are telling us here is NCLT, NCLAT, they have got all the powers as vested in a civil court, but they are not bound by those powers. Means they just do not have only those powers. They can regulate their own procedure. Okay, so they have all the powers as vested in civil court, means they have all the powers as given in code of civil procedure, but they are not bound by it. Okay, they are not restricted by those powers only, and whatever proceedings are going on before the NCLT, NCLAT, those will be deemed as judicial proceedings as if it is going on in a court of law. Very, very clear with this? Acha, in NCLT, NCLAT, you know there is a head, like president is there, chairperson is there. You have judicial member, technical member, judicial member, technical member in your NCLT as well as in your NCLAT. Okay, these are the people who perform the core important functions. Now, within these judicial members and technical members, you can have even the employees, officers, etc., to whom we can delegate the work. Okay, and if suppose there is some mistake which happens by the president, by the chairperson, by the judicial member, technical members, and if they say that this was done in good faith or this happened in good faith, we did not intend to do it. Okay, then in such a case, no judicial action can be taken against them. Okay, no suit, no legal cases can be filed against the authorities if they say that mistake happened in good faith. Very, very clear with this? Okay, now whenever the case is going on before NCLT, NCLAT, etc., then they can also take the help of metropolitan magistrate, chief metropolitan magistrate, chief judicial magistrate, or district collector. Okay, we can take the help of these particular authorities, and the tribunals can tell them that you can go and do the please bring the books of accounts into our possession, or please do the inspection of so and so books of accounts. You can take the help. Okay, so tribunal can direct these lower authorities like CMM or CJM or district collector to assist them during the procedure. Okay, now whenever any particular case is going on before the NCLT or NCLAT, no civil court can have jurisdiction, means no civil court can interfere in between, no local courts, no small courts can interfere in between when the case is going on before the NCLT or the NCLAT. Okay, because they have been given specific powers to take up those cases, so civil court cannot interfere in between. I hope I am very, very clear with this. Yes. Acha, another thing. Now, suppose if there is any vacancy in NCLT or NCLAT in the position of president, chairperson, judicial member, technical members, then obviously we have to fill up the vacancy. Okay, then we have to fill up the vacancy, but till the time we fill the vacancy, till that time, the rest of the members can continue to take the decisions. ठीक है, अगर सपोज फिलहाल कोई जगह खाली है तो हाँ हम उसको फिलअप करेंगे, लेकिन फिलअप करने में भी टाइम लगेगा, तो तब तक के लिए एग्जिस्टिंग मेंबर्स कैन कंटिन्यू टू टेक द decisions. Means the NCLT work is not going to stop just because there is a vacancy in NCLT or the NCLAT. Okay, and as you already know here, only thing that you need to know, not very important, only thing that you need to know here is in section number 434, we already know that there was a cut-off date, that is 1st June 2016, it's written here, 1st June 2016. Before that, we used to have an authority called as Company Law Board. Okay, and after that, we have got these authorities like NCLT, NCLAT, etc. So, whatever matters were pending with the Company Law Board as on 1st of June 2016, all those matters got transferred to the NCLT. Okay, because CLB was dissolved totally, all those matters have come to the NCLT. But the matters which were reserved for High Court will stay with the High Court only. Earlier, we used to have an authority like Company Law Board and the High Court. Now, we have got the NCLT, NCLAT and the Supreme Court. So, whatever matters were there with the CLB, those came to the NCLT, but the matters which were specifically reserved with the High Court, for the High Court, those will be kept with the High Court only. And all new matters will now come in the new hierarchy, that is the NCLT, NCLAT and the Supreme Court. Okay, so only that much is to be remembered. right? And then at the end of the chapter, you have been given the important time periods, whatever we have studied here now, and then you have got the revision of the important pointers. Anyway, we have revised all the important pointers. So yes, till section number 424, 423, everything is important. Okay, right from beginning of the chapter to section number 423, you have to mandatorily cover. I hope I am very, very clear with this, everyone. Yes. Chalo, let's start with a super quick revision of this chapter, compounding of offences, adjudication and special court, which is going to range from section number 435 to 446b, and then 454 and 454a. These are the sections that we are going to cover in this particular chapter. First of all, types of offences. There are going to be two types of offences. One is compoundable offences and the other one is non-compoundable offences. Compoundable offences are those offences where the person who has filed the complaint, that person agrees to have the charges dropped against me, is willing to let the charges drop against me. There, the types of compoundable offences are fine only, imprisonment or fine, or imprisonment or fine, or both. Then there are going to be the next type of offences which talks about the non-compoundable offences, where imprisonment is going to be mandatory, where no relief can be provided to me on the face. That is imprisonment only, and the other one is going to be imprisonment and fine. These are the two types of offences which we have. After that, going on to the next main section, that is section number 435, which talks about establishment of special court for the purpose of determination of offences, or for the purpose of speedy trial of offences. Central government establishes the special court. Special court is established for all the type of offences except for one offence that you have to remember, that is except for section number 452. For that purpose, central government establishes as many special court as required for the purpose of specific jurisdiction. Special court is going to have judges within that. Where there is a case where imprisonment is of 2 years or more, at that time the cases will be handled either by a session judge or by an additional session judge. When in case of other cases, the cases will be handled by the metropolitan magistrate or judicial magistrate of first class, and these people will be appointed by the central government in concurrence with the Chief Justice of High Court for the respective jurisdictions. This is how the special courts are established. Okay, now going on to section number 436, which talks about doing the trial, means how the trial is done by the special court. So first of all, whatever offences were written in the previous section, that is section number 435, that is all the offences under the Companies Act 2013 except for 452. All these will be tried by the jurisdictional special court. Jurisdictional special court means that particular special court wherever the registered office of the company is situated. If suppose in that particular area we have got more than one special court, then to which special court the case is going to go, that will be determined by, or that will be specified by the High Court of that particular jurisdiction. Then after that, whenever any particular person, we have a doubt on a particular person, or when we suspect a particular person that he has done so and so offense, then first of all that person is forwarded to the magistrate. Okay, which magistrate? That person can be forwarded either to the judicial magistrate or to the executive magistrate. When he goes to the judicial magistrate, magistrate can keep the accused person with him for a maximum period of 15 days, and executive magistrate can keep him for a maximum period of 7 days, maybe for the purpose of questioning and to gather information about him. And once his work is done, that can be maximum within 15 days or maximum within 7 days. Once everything is done, then after that, that person is forwarded to the jurisdictional special court. Special court is going to have all the powers. Special court is dealing with the criminal offences, etc. also. So it is going to have all the powers as vested in the Code of Criminal Procedure. And then when this person is thrown before the special court on the basis of the police report which would have been filed by the magistrate, on that basis special court will take the cognizance of the offence, and now it is going to start the trial of the offence. Now there are two types of trial. One is summary trial and the other one is regular trial. If suppose originally there is an offence for which imprisonment does not exceed a period of 3 years, then in that case we can start trial of such cases. We can start the trial of such cases in a summary manner. and it will be called as a summary trial only if the final imprisonment, the final punishment that you have given in such cases does not exceed a period of 1 year. So original imprisonment should not exceed 3 years, and the final imprisonment should not exceed a period of 1 year. If this is fulfilled, then we can say that yes, the case was completed in a summary manner. If this condition does not get fulfilled, then we automatically fall under the regular trial. Then after that, just like earlier, High Court used to exercise its powers on session courts. Similarly, High Court is going to exercise its powers and jurisdiction even on the special courts now. Okay, that is given in section number 437. Going on to the next section, that is section number 438. Whenever we talk about these proceedings which are going on before the special court, which code is going to be applicable, that we have already studied. That is code of criminal procedure is going to apply whenever any trial is going on before the special court. The person who does this trial or the person who judges or the place where it is done is called as, that special court is going to be deemed as court of session, or the court of metropolitan magistrate, or the court of judicial magistrate of first class. So special court is deemed as this, and the person who is conducting the prosecution before the special court, that person is called as a public prosecutor. He's got all the rights, powers, privileges, etc., which is vested in a public prosecutor. Going on to the next section, that is section number 439, which is important. Now they say that all the offences under the Companies Act 2013, all the offences are non-cognizable and bailable. Non-cognizable means arrest cannot happen without an arrest warrant, and that person can also be released on bail. Okay, except for one offence, that is Serious Fraud Investigation Offense, the offense which is determined by the SFIO under section 212 that we are going to study in the inspection, inquiry and the investigation chapter. Except for that, all will be non-cognizable and bailable. Everything will be non-cognizable and bailable. Now they say that whenever you want to give cognizance of the offense, against, whenever any offense has been committed by a company, whenever any offense has been committed by any person in charge, etc., then in that case, cognizance, the court or the magistrate will take the cognizance only when there is a written complaint which is given by any of the four persons, either by the ROC or by the shareholder or the member, or by the company, or by any person authorized by the central government. If these people go and give the cognizance, then only that offense will be the trial of that particular offense will be started. And when we talk about offenses done in respect of securities, that is, if there is any offense done in respect of issue or transfer of securities, or where the company has declared the dividend but not paid it, then in that case the courts or the magistrate can also take the cognizance when it is when the cognizance has been given by a person who has been specifically authorized by the SEBI. This person is an extra person who can give the cognizance. Now, whenever ROC is giving the cognizance, or whenever CG authorized person is giving the cognizance, then in that case, their physical appearance before the court is not mandatory until unless the court specifically asks them to be present in the court. Means they can send any authorized person on their behalf. And the entire section is not applicable when the company wants to proceed against its officers. Okay, if company wants to proceed against its officer, then this section is not going to be applicable. However, if the company wants to proceed against the liquidator, then it can proceed, because liquidators are not the officers of the company. And suppose if we want to, suppose if in case of a government company, if we want to file any complaint against the government company, etc., then in that case cognizance can be given. Cognizance can be given by, it can be given by your CG authorized person. It can be, in case of securities, it can be given by SEBI authorized person. The words ROC, members and shareholders have been totally omitted from that four list. From the four persons list, the word ROC and members and shareholders is totally omitted. Those are not allowed to give cognizance in case of a government company. This was all about your section number 439. That is offences under the Companies Act. Just remember this much: offences under the Companies Act, except for 212, will be non-cognizable and bailable. Non-cognizable means arrest cannot happen without an arrest warrant, and bailable means that person can be released on bail or bond. Going on to the next section, that is section number 440, which says that till the time the special courts are established, till that time the session court or the judicial magistrate or the metropolitan magistrate will continue in that particular area. There is no problem in that. Then going on to the next section, that is section number 442, which talks about mediation and conciliation. Whenever there is any dispute between the company and between the authorities. Who are the authorities here? Central government, ROC, NCLT, NCLAT. Then in that case, instead of going for the appeal, we can even plan to go for mediation or conciliation. Now this mediation, and for this we are not supposed to go under the Arbitration and the Conciliation Act. The provisions have been provided under the Companies Act itself. So central government is going to maintain a panel of experts, that is mediators and conciliators, and that panel is going to be called as Mediation and Conciliation Panel, which is going to have respective number of mediators and conciliators who are ready to take up the cases, so that there is a speedy resolution, or so that there is a speedy solution that the company or the person in charge of the company is going to get. So either the authorities will tell us that please go to the mediation and the conciliation panel, or we can even suo moto go and make an application to the authorities. Sir, you will take a hell lot of time, so instead of that, please send the case to the mediation and conciliation panel. Once the matter is referred to the mediation and conciliation panel, they will take a time period of 3 months to determine the case. They will give their recommendation to the authorities, and then the authorities will simply do the work of approving that particular decision. This way we are saving on some time. In respect of the authorities. Otherwise, they were required to do the entire appeal, entire procedure thing. But now they are not required to do the entire thing. They are just supposed to approve the decision of the mediation and conciliation panel. Okay. Then after that, going on to the next section, that is section number 443, which talks about CG appointing company prosecutors. Now, whatever the offences trial thing was happening, that was happening before the special court. And the person who conducts the prosecution before the special court, that person is treated as what? That person is treated as a public prosecutor. Okay, the person who has got the knowledge of company law matters, that person is deemed as the company prosecutor. I mean, public prosecutor is there. By qualification, this person is a public prosecutor only. But since he has got the experience and the knowledge in the fields of company law matters, this person will be treated as company prosecutor. So CG can designate or CG can notify such numbers of company prosecutors or such number of prosecutors who can act as company prosecutors whenever the case goes before the special courts. And they have got all the same powers. They have got all the same powers as vested in a public prosecutor. Then after that, going on to the next section, that is section number 444. Section number 444, appeal against acquittal. Okay, for this, just try to understand the term called as acquittal. Acquittal means a clear verdict or a clean verdict. Suppose if the court has passed an acquittal order for me, means the court is telling that I am not guilty, I am a clean person. The court has passed such kind of judgment. Now suppose if there is any court except for the High Court. Okay, if there is any court except for the High Court which has passed an acquittal order for the company or for the person in charge for the company, then in that case, the revenue, who is the other party, the ROC or the central government, whoever is the other party, can I say they will be aggrieved because the court has treated me as a clean person. So now they can appoint company prosecutor to file an appeal against this acquittal order. They will now proceed to file appeal against this clean order. So CG can do so. CG can appoint company prosecutors who will be filing an appeal against my order now. But the appeal cannot be filed against the order which has been passed by the High Court. So if acquittal order has been passed by the High Court, then CG cannot appoint company prosecutors for that. But if the acquittal order has been passed by any other authorities, then CG has got the powers that it can appoint company prosecutor to proceed against me in form of an appeal. Then going on to the next section, that is section 445, which is very, very simple. Any person who was wrongly accused, or who was, without reasonable cause, if any particular person was accused and now the special court has passed an acquittal order in that particular in that particular person's case, then in that case, the person who is now released, that person will be liable, that person will be eligible for certain amount of compensation. Maybe he can say that I incurred a lot of cost during this particular proceedings, or there was a loss of goodwill, I lost my market share in the market, and for whatever reasons he states, he will be eligible for compensation. But what is the amount of compensation, within how much time will it be paid, etc., that will be determined under section 250 of the Code of Criminal Procedures 1973. That is not determined under the Companies Act. Companies Act simply says that yes, you can pay as per that particular law. Then after that, going on to the next section, that is section number 446, they say that whatever fines are collected by the court, okay, whatever fines are collected by the court, either by the session court, special court, or whatever, that fine is going to used, that is going to be used for meeting the expenses of the proceedings. That is one thing. And another thing is the person, the whistleblower person who gave the information about this particular offense, on the person who said that so and so offense is being happening, if that comes out to be true, then in that case we are going to reward that particular person out of the fines that we have collected. Then going on to the next section, that is section number 446A. 446A talks about the factors that we are going to use, or that we are going to take the help of while determining the level of punishment. Okay, while determining the level of punishment or penalties under section 454. Like less amount of penalty or punishment should be imposed, or high amount in case of range. So that depends on size of the company, that depends on nature of this particular company, that depends on how much loss has been caused to the public interest, how much gain have we made out of this by doing the contravention, and the repetitive nature of default. On this basis, we are going to determine whether penalty should be levied on the lower side, or penalty should be levied, or penalty or punishment both, should it be levied on the lower side or should it be levied on the higher side. Then after that, going on to the next two sections, that is next section, that is section number 446B. 446B talks about lesser penalties, only monetary penalties in case of contravention, in case of certain companies. Okay, in case of certain companies, that is 4 types of companies: for OPC, small company, then startup private company, and for producer companies. If these people do any kind of contravention under the provisions of this particular act, for which a penalty has been provided in the law, then in that case, just because these people are small, their penalty will be reduced to half. Okay, straight away their penalty will be reduced to half, and that too subjected to a cap limit of maximum 2 lakhs in case of a company, and maximum rupees 1 lakh in case of person in charge. This is the amount of penalty that is going to be levied in case of these 4 small persons. Then after that, going on to the next section, that is section number 454, which is very, very simple, which talks about adjudication of penalties. Whenever any contravention happens under the act, then the penalty is applicable. This penalty is determined by the adjudicating officers. Adjudicating officers are nothing but the CG officers, not below the rank of certain registrars under the central government. And for every jurisdiction, we are going to have respective number of adjudicating authorities. Okay, adjudicating authority comes into picture. He gives us, there is a particular procedure to be followed as per rule number 3. After that, he is ready with his order. He imposes the penalty, plus he tells us to rectify the default. Okay, he'll tell us to pay the penalty also, plus he'll tell us to rectify the default also. Okay, exception for the purpose of section number 92 and section number 137 for these: annual return and filing of FS with the ROC. For this, if suppose we rectify the default within 30 days of issue of notice, then in that case they can relieve us from imposing the penalty. That is, we can be relieved from the imposition of penalty. AO gives the ROBH to the parties concerned there, and then only it is going to impose the penalty. If we are aggrieved by the order which is passed by the AO, then we have a right to go and file an appeal before the regional director within 60 days. Within 60 days from the date when we receive the AO's order, and will pay the required fees for the appeal, whatever is applicable, and then the final order is going to be passed by the regional director. It can confirm, it can modify, it can set aside, etc. These orders can be passed by the RD, and this is going to be full and final. Suppose if we do not listen to the AO's order, or suppose if we do not listen to the RD's order, then in that case that turns out into or that results into an offense. Okay, that turns out or that results into an offense. Then after that, there are certain procedures that we have to follow, that the AO has to follow while imposing the penalty. Whenever the AO imposes the penalty, he has to give us a show cause notice. Okay, show cause notice can be of any period ranging between 15 days to 30 days. Within this much time we'll have to reply. Okay, within this much time we'll have to reply. Whenever we receive it, whenever we receive the AO's notice, from that day, within a period of 15 to 30 days, whatever is written in the notice, we'll have to reply back. In this notice, this is going to be a show cause notice. So it is going to be written that give us the reasons why penalty should not be imposed on you for so and so default. Okay, it has to be a speaking notice here. Full detailed notice is going to be there. Then after that, we are supposed to reply to that particular notice in electronic format in whatever was the time period. Within that much time, we'll have to reply. And suppose if there are any sufficient reasons, then I can be granted an extension of a maximum period of 15 days. If AO is of the opinion, after receiving the reply, if AO is of the opinion that I should be physically called, means I should be called in the office and then some questioning etc. has to be done, then AO will issue me a notice within 10 days of my reply that okay, I have received your reply, but we need to meet on so and so date for the purpose of discussing on this particular matter. Either you can come or you can send your authorized representative, or you both can come to represent the case before me. And finally, after that, after this electronic reply and plus after the physical appearance, if required, AO is going to pass the final order. If physical appearance was not required, then whatever was my last day to reply to the show cause notice, from that day within 30 days, AO has to pass the order. And if physical appearance was required, then whenever I received AO's notice for the imposition of penalty, when I received the show cause notice from the AO, from that day within a period of 90 days, the AO will have to pass the final order. Okay, once the final order thing is done, then in that case, whatever is the order which is passed by the AO, that has to be dated, that will be signed, plus it should contain the reasons that why physical appearance was required. Copy of orders will be sent to everyone. It will be sent to the parties, it will be sent to the central government, and it will be put on the website of the MCA. Okay, AO has got these powers that it can call any particular person, it can summon any person, it can ask for evidences from some person, and on that basis, it is going to take the decision of imposition of penalties. If suppose the penalty is going to be in a range, then in that case, AO can use those factors given under section 446A to determine what quantum of penalty can be levied, and whatever are the penalties that are collected, okay, through the MCA portal, that gets credited to the Consolidated Fund of India. Then after that, going on to section number 454A, which talks about penalty for repeated default. Suppose if there is a company or any officer or any person in charge, etc., if they have done any particular default, or if they have done any kind of contravention under the law first time, then a particular amount of penalty was imposed on them. If suppose they do it again, if suppose they do the same thing again within a period of 3 years, then second time they'll be liable, like second time or subsequent times done within these 3 years, they will be liable for a penalty of 2x. Like whatever is the new amount determined for this penalty, that into twice the amount will be levied on them. This is the punishment given for subsequent defaults, or this is a punishment given for repetitive defaults. This is how the chapter goes. I hope you are very, very clear till here. Okay, so let's start with the super quick revision of prevention of oppression and mismanagement, which is going to range between section number 241 to section number 246 of the Companies Act 2013. First of all, two very important terms in the chapter. First one is oppression and the second one is mismanagement. Whenever the affairs of the company are being conducted in such a manner which is prejudicial to the interest of the members, then that particular act will be treated as oppression. And suppose if the affairs of the company are being conducted in a manner which is prejudicial to public interest, or which is prejudicial to the interest of the company, or whenever some big material change has taken place in the management of the company, and because of which there is a possibility that the affairs of the company can be conducted in a prejudicial manner, then in that case that can be treated as mismanagement. Operation and mismanagement is going to go hand in hand. We are going to use both the terms together in the chapter henceforth. Now, if suppose the shareholders feel, if suppose the members or the shareholders, if they feel that there is operation or mismanagement happening in the company, then in that case, they have got the right, okay, they have got the right to go and make an application to the tribunal. They have a right to apply to the tribunal, which comes up in section number 241, okay, which comes up in section number 241. So, either the members or the central government can go and make an application to the tribunal under section 241. In subsection 1, the members have the right, the required number of members as given in section 244 have a right to go and make an application against oppression or mismanagement as defined above. They can go and make an application to the tribunal. Okay. Alternatively, as per subsection 2, even the central government has the right to go and make an application to the tribunal, and it will tell the tribunal to pass the necessary orders if it is of the opinion that any of the 4 circumstances exist. First one, if there is any particular person in the company who was there in the management of the company or in the conduct, who was engaged in the conduct of the affairs of the company, if they are found guilty of fraud, misfeasance, persistent negligence, etc., then we can go and make an application. The CG can go and make an application to the tribunal. Or if the company's business is not being carried on as per the sound business principles or prudent commercial practices, or if the company is being carried on or the affairs of the company is being carried on in such a manner which can cause serious injury to the trade or the industry to whom we belong. And the last one, the business has been carried on to defraud the creditors or the members, or which is prejudicial to the public interest. If any of these circumstances exist, then the central government can go and make an application. Central government can go and make an application to the tribunal to pass the necessary orders. Okay. Now, in such cases, what does the central government do? Central government, if suppose central government is able to identify that so and so person is responsible for this act, then the central government will initiate a case against that particular person. It will give the case in the hands of the tribunal and will tell the tribunal to record a decision, or to take a decision that whether this particular person is eligible to hold the office in the company's management or not. And then this becomes a proper case. The person against whom we have filed the case, that person becomes a respondent, means he becomes one of the party to that particular case, right? And whenever the central government goes and makes an application to the tribunal, that has to be properly dated, signed as per the code of civil procedure, and it should contain all the facts that why, as per the central government, it feels that there is oppression and mismanagement happening in the company against the members of the company. Okay, so conclusion of 241 is either the members will go and make an application to the tribunal, or the central government, if any of those 4 circumstances exist, then it can go and make an application to the tribunal. Okay, now they had given certain specific pointers there. Suppose if, first of all, the member should be aggrieved. The person who is going and making an application under section 241, that person should be aggrieved in capacity of a member only and not in any other capacity. Example, if he is a director in the company, then if he is aggrieved in the capacity of director, then 241 is not applicable to him. This was even decided in the case of Rao versus Rajeshwari Ramakrishnan. Then after that, similarly, suppose if the company is not declaring the dividend, it is simply accumulating the profits, it is not declaring the dividend, that does not amount to oppression. This was decided in Thomas Wettam case law. Then after that, similarly, if the company is suffering losses, if the company is continuously suffering losses, merely if we just put an allegation that the company is suffering losses, it cannot be called as oppression. This was decided in the case of Ashok Beetlenet Company Private Limited. Similarly, suppose if the company has issued new shares in the public, and because of which the holding or the percentage holding of the existing shareholders has reduced. Just because new shares have come up in the market, because of that, my shareholding or the old shareholder shareholding has reduced. That does not lead to oppression in the company. The company has full right to issue new shares to the public, right? Similarly, the number of people who can go and make an application, or the members who have got a right to apply under section 241, that is not only available to majority shareholders or minority shareholders or something like that. No, we cannot confine it to majority or minority. The number of members who can go and make an application, that is specifically provided for, in section number 244. So we cannot say that this right is available only to majority ones or this right is available only to minority ones. No, how many of them can go and apply, that particular number is given under section 244. Okay, then after that, in section number 241, we had a right to apply. We went and we made an application to the tribunal. So now the ball is in the court of the tribunal. Now the tribunal will check the application. It will see whether actually the affairs are being conducted in a prejudicial manner. And if the tribunal is of the opinion, that yes, there is oppression and mismanagement in the company, but it is not proper to wind up the company. It is not proper. It would be unfair to wind up the company for such thing. So the tribunal will try to resolve us. Okay, the tribunal can pass certain necessary orders. The tribunal has those powers. Ma'am, what kind of orders can the tribunal pass? So tribunal can tell us how the business is to be conducted in the near future. Then it can, do the reduction in the share capital. It can tell us to do the buyback of shares. It can tell us to change the shareholding pattern. It can put restriction. It can put certain restriction on transfer of securities. It can terminate certain people from the company. It can modify the agreements. Which is entered between the company and its managerial personnel. It can set aside any property transactions which were done during the last 3 months. It can remove any managerial personnel. It can, if any managerial personnel has earned some gains, some wrongful gains from the company by doing some default, we can recover those gains from the managerial personnel. We can tell the company to report to the tribunal from time to time, or we can appoint some person who can keep an eye on that particular company to who can ultimately report it to the tribunal. And if required, if we need to punish the company for the wrongful things that it has done, then some penalty or fine can be imposed on that particular company by the tribunal. By doing this, tribunal is hopeful. By doing this, the tribunal is hopeful that yes, we will be able to revive the company, we will be able to resolve the company. Okay, so tribunal is going to pass such orders. Whatever is the order passed by the tribunal, that we'll have to go and submit it to the ROC, just like we always do. We'll go and submit it to the ROC within a period of 30 days. And if suppose because of the order of tribunal, if we need to do certain changes in the MOA AOA, then we'll have to do those changes. And then the altered copy of the MOA AOA also should be submitted to the ROC within a period of 30 days from this particular change. Okay, and then remember, CG had filed a case against that particular person under section 241, that whether this person should be continuing in the company or not, whether that respondent should be continuing in the company or not. So tribunal will take a decision for that particular person also, that whether he should be continuing in the company or no. If you do not comply with the tribunal's order, example, they had told you to change your MOA, AOA, you did not change it, or you are acting against the tribunal's order. If you are basically not complying with the tribunal's order now, then in that case, that will be treated as an offense. On the company, there will be a fine ranging between 1 lakh to 25 lakhs. On the defaulting officer in charge, the fine that will be applicable will range between rupees 25,000 to 1 lakh. Okay, so these powers were exercised by the tribunal under section 242. Now going on to section number 243, where suppose if the employment agreements are altered, or if suppose any particular person is terminated, or his terms of employment are modified, then in that case he won't be eligible. Okay, such people won't be eligible for any compensation for loss of office. Whatever are his due amounts, that he can take, but any extra compensation will not arise. Okay, any claim for compensation is not going to arise. That is one thing. Suppose if members made an application to the tribunal and the tribunal passed an order under section 242, then in that case, the MD, manager or the director, whoever were removed, they cannot act in this particular company in these same positions for a period of 5 years. If they want to come in the company before a period of 5 years, no problem, take the approval of the tribunal and then you can come. Okay, and then when the CG told the tribunal that please decide whether this person is a fit person or not, whether that respondent is a fit person or not. If that person is removed, then there is a big restriction on him that he cannot act in any company's management. He cannot act in any company's management for a period of 5 years. If you want to again come before a period of 5 years, then in that case you can take the approval of the tribunal. Okay, and just remember one thing, 243, section number 243 is going to override the entire company law. Okay, 243 simply says that no compensation will be paid, even though it is written in the MOA, AOA, even though it is written in any particular law, even though it is written in any particular contract that we will pay you compensation. But no, if 243 becomes applicable, then only 243 will be applicable. Basically, 243 is going to override everything. If you are held default, if your agreement has been set aside, then you won't be eligible for any compensation for loss of office. Acha, still if any person knowingly acts directly or indirectly in the management of the company during those number of years when there was a restriction on that particular person, then he will be liable for a fine up to rupees 5 lakhs. Now that means he has done a offense now. Then after that, going on to the next section, that is section number 244, which pertains to section number 241. In 241, we were going and making an application to the tribunal. Right? We were going and making an application to the tribunal for oppression or mismanagement. So how many of them should go and make an application? Okay, in case of members, in here there was only members. So in case of members, in cases where the company has share capital, so at least not less than 100 members or not less than 10% of the total number of members or 1/10 of the total number of members, whichever is lower, or member or members holding at least 1/10 of the issued share capital. Okay, not paid up share capital. This is issued share capital of the company, and yes, these shares must be fully paid. When the company is not having share capital, then it was very, very simple. At least 1/5 of the total number of members should go and make an application for the purpose of section number 244. Joint holders of shares will be counted as a single person. If some person wishes to withdraw their consent after the petition has been filed, then we just have to check the status on the date of filing the petition. Later, even if some people withdraw their consent, like if 100 was required but 5 of them has withdrawn after the petition has been filed, that is going to have no effect at all. Okay, this was even decided in the case of Rajamundry Electric Corporation case. Then after that, the next one is when the members are going and making an application, it's not necessary that everyone should go to the office of the tribunal to make this application. One of them, after taking the consent from everyone, or an authorized representative on behalf of all these people, can go and make an application to the tribunal. That is allowed. And last and the most important point here is, suppose if you are not able to meet the requirement of section number 244, that is the minimum number of members, but you are able to satisfy to the tribunal that, sir, actually oppression and mismanagement is there, then the tribunal can waive off these conditions and it can accept your application. Right? This was given in section number 244. Now going on to the last section, that is section number 245, which talks about the class action. So class action is such a thing which option is available, where the option is available to the members and the members or the depositors if they feel that something prejudicial has happened against the interest of the company or against their own interest, and they are aware about the cause. So they go and make an application to the tribunal to pass the necessary orders. Okay, they will be very specific about it. They will go to the tribunal to pass the necessary orders. Okay, which type of orders can be passed? 3 type of orders we can request the tribunal to pass. First one, to restrain the company from doing any ultra-virus act, from going against the MOA, AOA, from going against the provisions of this act or any other law, or to restrain the company and its directors to act on any void resolution, or from taking any action contrary to the resolution which has been passed by the members. We are trying to stop the company from doing all these wrongful activities, or you are requesting the tribunal to pass an order to declare a particular resolution as void, or to claim the damages, or to claim certain damages or compensation because of whom we might have suffered some amount of losses. So we can claim damages or compensation from the company, its directors, from the auditors of the company, or from the consultants, expert advisors of the company on whose advice maybe we relied, on whose report maybe we relied, and we suffered some amount of losses. So in this case, in section number 245, we are going to the tribunal. Okay, some number of members and depositors will be going to the tribunal and requesting the tribunal to pass any of these orders. Okay, now how many of them should go and make an application to the tribunal? That is another thing. First, let's do it for the members. Okay, for members, again, two bifurcation: company having share capital, company not having share capital. If the company is not having share capital, then it is same as before, that is 1/5 of the total number of members. If the company is having share capital, then again at least 100 members or 5% of the total number of members, whichever is lower, or members holding at least 5% of the issued share capital if it is an unlisted company, and 2% of the issued share capital if it is a listed company. So this way, these many number of members have to go and make an application to the tribunal. And when we go to the depositors, then in that case, 100 depositors or 5% of the total number of depositors, whichever is lower, or depositor or depositors to whom the company owes at least 5% of the total deposits. These many of them can go and make an application to the tribunal under section 245. Once they go and make an application, tribunal is going to check whether the application was done in good faith, if it involves any personal interest or no, and it will try to check whether all the evidence, it will first gather all the evidences and it will check whether all the evidences are correct or no. If all this is okay, then after that the tribunal is going to give a public notice on all the members and the depositors that so and so case under section 245 will be initiated now. Similar applications will be consolidated into one. Same cause of application will be rejected if we have multiple ones, and whatever are the costs for doing the section 245 will be ultimately recovered from the company or the person who is ultimately held liable. We are going to recover it from that particular person. Right? Then the tribunal is going to pass the necessary orders. The order which has been passed by the tribunal, that will be binding on everyone. If we do not comply with that particular order, then that will lead to an offense and we will be punishable with fine. Company will be punishable with fine which ranges between rupees 5 lakh to 25 lakhs. Person in charge will be liable for a punishment where fine will be there ranging between 25,000 to 1 lakh, and imprisonment up to 3 years will be applicable on that particular person. This is going to be applicable if we do not comply with the orders of the tribunal which was passed under section 245. If someone is going and filing frivolous application or vexatious just for fun, then in that case, first of all, the application is going to be rejected, and after that we can even impose cost on that particular person up to rupees 1 lakh for doing this frivolous activity. The entire section number 245 is not applicable for banking company because they say that if something like this happens, then you can go under the Banking Regulation Act or as per the provisions of the RBI laws and not as per the Companies Act. And again, here when you are going and making an application, then in that case, like the required number of members or depositors are going and making an application, then in that case, one of them on behalf of them or an authorized representative on behalf of so many people can go and make an application, and that's absolutely fine with the tribunal. This was all about the important provisions of your section number 241 to section number 245, and 246, the last section, that has to be referred after doing winding up chapter. So these were your most important provisions out of prevention of oppression and mismanagement. Just two different case laws here. One is the case law about majority rule. So it is an established fact that in a particular company, always the majority shareholders or the people who are holding majority of the shares, they rule the company. This was decided in Foss versus Harbottle rule case law. And the last one, that is where the shareholders are denied, inspection of books of accounts. So there's no mistake of the company if they are denying the shareholders to inspect their books of accounts, because shareholders do not have a right to inspect the books of accounts, they have the right to inspect the registers. So if they are denying me to inspect the books of accounts, then I cannot say that this is an oppression. So this is not an oppression. If this is not an oppression, then this particular chapter is not applicable. This was decided in the case law called as Lalita Rajya Lakshmi versus Indian Motor Company. And this was all about your prevention of oppression and mismanagement, and I hope this is very, very clear. Okay, let's start with the super quick revision of inspection, inquiry and the investigation chapter, ranging between section number 206 to section number 229. First of all, there are going to be two sections, section number 206 and 207, which is going to discuss about, or which is going to talk about inspection and inquiry, the powers of which have been given to the ROC primarily. Starting with section number 206. In section number 206, ROC has got the power to call for information, to inspect the books of accounts and to conduct the inquiries from the companies and its person in charge. For that purpose, ROC can do this particular inspection and inquiry on the basis of information available with it, or on the basis of scrutiny of the documents which we would have submitted with the ROC. On this basis, ROC can either call us to furnish certain information, or ROC can call certain books of accounts from us and conduct the inspection. For this purpose, ROC need not give us the ROBH. It can simply issue a notice on us to furnish the information, documents, explanation on certain matters. Then after that, once the ROC issues this first notice to us, it is the duty of our company, it is the duty of our officers, including the past officers of the company, to furnish the necessary information, to the ROC to the best of their knowledge. Whatever information is available with them, to the best of their knowledge, they have to furnish this information to the ROC. Okay, suppose if once the ROC issued the first notice, after that, if the ROC is of the opinion that we did not submit the information, or the information submitted by us was inadequate, or if suppose the ROC wants to know more about the affairs, it wants to gather more information about our affairs because it thinks that unsatisfactory state of affairs exist in our company, then in that case, ROC even has the powers to issue additional notice on us. ROC even has the power to issue additional notice on us, but here, before issuing the additional notice, it has to make sure that it records the reasons in writing with itself, that what was the need, that why did it issue the second notice to us. Then after that, ROC has also got the powers to do questioning to that particular persons in the company, meaning ROC has also got the powers to conduct inquiries into the affairs of the company by questioning some people. This can be conducted on three bases. First one, suppose if investors' grievances are not addressed at all, or say for example, if ROC has some information in its possession, that inquiry should be conducted, or if some person has gone and made a representation to the ROC that the business in this particular company is being conducted in a fraudulent manner or is being conducted for a fraudulent purpose. Then in that case, ROC will first inform these people, the company or the person in charge, that so and so complaint has been received against you. Maybe someone has made a representation against you, or some investor has made a complaint that investors' grievances are not addressed. Then in that case, ROC will inform about the grounds to the company or the person in charge, and only after that it can conduct the inquiries. And if some people are held guilty, like if we come to know that yes, these people are guilty of some particular things, then this will be treated as a fraud and they will be punishable under section 447. Till here, whatever we were doing was, powers was available with the ROC. Now, even the CG can interfere in between, even the central government can interfere in between, and it can direct the ROC, or it can appoint any inspector for conducting the inspection and inquiry in case of any particular company. Or the central government can even pass any general order, or it can pass any special order on the statutory authority, and it can authorize the statutory authority, example SEBI, RBI, etc., to conduct the inspection of books of accounts of a particular company or some class of companies. If suppose we are not listening to the orders which have been passed by the ROC, by the inspector, or we are not furnishing the information which they have asked for, then we will be liable for some amount of punishment. This was given in section number 206. Going on to the next section, that is section number 207. In section number 207, it is going to be a repetition and it is going to be a continuation of section number 206. That suppose if any documents, any information, any papers, etc. were called under section 206, the last section, then it becomes the duty of a company, of the employees of the company, of the officers of the company to produce such information, to furnish them with all the statements, explanation, etc., and to provide them with all the necessary assistance, to cooperate with them and to provide the necessary assistance. And these officers or the ROC inspector, the ROC or the inspectors, they have got all the powers as vested in civil court. So they can, you know, call for evidences, they can examine us on oath, they can summon us, they can tell us to discover and produce all the books of accounts, documents, etc. All these things, all these powers are vested with the ROC or the inspector who was conducting the inquiry and inspection under section 206, right? And whenever they are doing inspection, they have got the right that they can put the identification marks on the books, and while returning the books, they can with themselves, since they are going to return the original books, they can keep the copies of the books of accounts with themselves. This was told in section number 207 till here. In section number 206 and 207, your inspection and inquiry gets over in all respects. Now going on to the next section, that is section number 208, which talks about report on inspection. Once the inspection and inquiry was conducted under section 206, after that the ROC or the inspector, whoever was there, that person will have to make a report about their inspection and inquiry, and they'll have to submit it to the central government. And that report may include a recommendation that whether further investigation, detailed investigation into certain matters is required or not. This is not mandatory. This recommendation is not mandatory. It may include in its report. Okay, this report we went and submitted to the central government, and suppose if as of now practically the powers of central government have been delegated to the regional directors. So the report is practically gets submitted to the regional director. Anyway, in the law it's still written as the report will be submitted to the central government, just like it's written here in the first point. Okay, after that, going on to the next section, that is section number 209, very important section, which talks about search and seizure. If the ROC or the inspector, while doing their inspection and inquiry, if they are of the opinion or if they have reasons to believe that the books of accounts of the company are likely to be destroyed, altered, mutilated, falsified, secreted, destroyed, etc., then in that case we would not like to leave the books of accounts in the company. So ROC or the inspector has the power to enter and search the places wherever the books of the company has been kept, but this it can do only after obtaining an order from the special court. And after that, once it has obtained the order from the special court, after that it can seize such books, papers, documents, etc. When we are seizing the original books, we can allow the company to keep the copies or the extracts of such books of accounts. We can keep it with us. The ROC or the inspector are keeping it with themselves for a period of 180 plus 180 days maximum. And now when we return it after that 180 plus 180, if any, then at that time we can put the identification marks on it, and now we can keep the copies or the extracts of the books of accounts, right? Then going on to the next section, that is section number 210. From here starts your investigation. Okay, from here starts your investigation. So now in section number 210, we are going to study the basis, on what basis further investigation can be conducted into the affairs of the company, and this is being ordered. This is going to be ordered by the central government. So there are 4 bases on which the central government can order for investigation. First one, on the basis of report submitted under section 208, or if the company, if the shareholders pass a special resolution that, sir, please conduct investigation, or if the central government thinks that it is in public interest to carry on that investigation, or if any order has been passed by any court or tribunal, then it becomes, in the 4th point, it becomes mandatory for the central government to conduct the investigation. And for physically doing the investigation, for actually doing the investigation, the central government is going to appoint inspector. Either it can be a single inspector or there can be multiple inspectors who can be appointed for the purpose of investigation, and they are going to report to the central government. Right? In the second case, where the shareholders were passing a special resolution and they were requesting the central government to conduct the investigation, in that case, central government may ask these people to pay a security deposit up to rupees 25,000, about which we are going to study in a further section. Okay, so now once this is done, after that, going on to the next 2 similar, next 2 group of sections, that is section number 211 and section number 212. Okay, section number 211 talks about, and 11 and 12 talks about your SFIO, that is Serious Fraud Investigation Office. In section number 211, we are going to constitute this SFIO, and the investigation is going to happen in section number 212. in section number 211, SFIO is first of all constituted by the central government only. It is going to do investigation into the serious frauds of the company. SFIO is going to be headed, okay, it is going to be headed by a person called as director. This director is not below the rank of joint secretary to the government of India and having knowledge in the field of corporate affairs. Okay, and then within that we are going to have people like we are going to have experts from different fields like banking, taxation, accounts, finance, IT, capital markets, law, etc. We are going to have different experts, and the respective cases will be handled by respective experts as required by that particular case. So this way the SFIO is constituted. Okay, now after that, within this SFIO, you have first had the directors, within that you had the experts, and within that also you are going to have some number of officers and employees who are actually going to do the groundwork. So their appointment, their terms and conditions, their salary and allowances, their service conditions, etc. will be as may be prescribed. We do not have those provisions for us. Then after that, let's conduct the investigation. Now, investigation will be conducted by the SFIO. So, if once the central government is of the opinion that yes, investigation is necessary and that too there exists a serious fraud in the company. If there exists a serious fraud in the company on 4 bases, okay, on 4 bases, central government can delegate this matter. Central government can delegate this matter to the SFIO. First one, again on the basis of report under section 208, or if SR has been passed by the company, or if the central government is of the opinion that it should be done in public interest, or if it receives a request from the central government or the state government department to conduct this investigation because they are of the opinion that serious fraud exists in the company. Then in that case, central government will assign this task to the SFIO, and then the required, like to SFIO means it is going to give it to the director, and then the director is going to prepare its team that who all experts will be proper to conduct this particular investigation. Now, first of all, once the case comes to the SFIO, SFIO says that I will work solely or I will work exclusively, means if any investigation is going on, then that shall pause, or if any investigation, any other investigation was going to be started against this particular company or was going to start against this particular company, then that shall not start at the moment till the time the SFIO is working in the company. Okay, after that the SFIO is going to conduct its investigation. It is going to submit the report to the central government within whatever is the time period specified. That the people who are working under the SFIO, they are just deemed as inspectors. Okay, they are experts, but ultimately they are deemed as inspectors. So they have got all the powers of inspectors that we will study in section number 217. And whenever the SFIO comes for the purpose of investigation, again it becomes the duty. Again it becomes the duty of the company, of the officers of the company, including the past officers of the company, to provide them with all the necessary information as asked for. Okay, now here, since we are held guilty of this particular serious fraud under section 212, then in that case we become guilty under section 447 of the act, that is fraud. And all these offences shall be cognizable and non-bailable, just like your PMLA. Okay, just like your PMLA. So here that person cannot be released on bail, and that person can be arrested without even an arrest warrant. Okay, now that person cannot be released on bail, that is the by default rule, but there are certain exceptions in that. First point was same as that of your PMLA, that is the public prosecutor should be given an opportunity to oppose the release, and if he opposes, but still the special court is of the opinion that this person will not commit any new offence while on bail. This is one circumstance. If the special court is satisfied, then that person can be released on bail. Or if there is any woman, or if there is any person who is under the age of 16 years, or if there is any person who is sick or infirm, then if the special court directs, then even these people can be released on bail. Okay, now here, since it is a case of fraud, the code of criminal procedure becomes applicable. So the matter is going to go to the special court, but special court will have to go and give the cognizance to the special court. So who can give the cognizance to the special court? The main head who was working under this particular section, that is the director of the SFIO, or any person authorized by the central government. That person has got the right that please go and give the cognizance to the special court, so that now the punishment etc. can be announced by the special court. Okay, then similarly in the directors, in this director of SFIO, we have got different types of directors. We have got different levels of directors. So the director not below the rank of assistant director of SFIO, that person has the reason, that person has the powers that he can go and arrest any particular person. We anyway do not require an arrest warrant. We just have to inform that person about the grounds, that why are we arresting you. We will just inform that person about the grounds, and we can simply go and arrest him. Once I go and arrest any particular person, after that I will inform it to the SFIO that sir, I have arrested, or the director of the SFIO that sir, I have arrested so and so person. Okay, once that person is arrested, after that that person is presented before the special court within 24 hours excluding the travel time, before the special court or before the judicial magistrate or before the metropolitan magistrate. We present that person there. Suppose if the investigation is going on for a long period, then in that case SFIO may also be required to submit an interim report to the central government if required. Otherwise, once the investigation is completed, we are going to submit a final report anyway. Okay, now if you want to go and obtain this copy of the report, you cannot obtain it from the central government. We'll have to go and make an application to the court, that is to a special court, and only from there we can obtain the copy of this particular investigation report. Okay, once the report is once the central government and once the court receives the report, after that we are going to start the prosecution against the employees, officers, or any person who was involved in that particular serious fraud. And if there is any person, if there is any director, officer, employee of the company who has earned some undue profits or undue gains from the company, then in that case we will take the help of the NCLT for the purpose of disgorgement. That is, we will recover the undue gains that they have done from the company. Right, and there's one responsibility of the SFIO, that whenever the SFIO is working, it can seek help from the other authorities, any central government department, state government department, or any other law, or from police authority, etc. We can take help from them. And plus, once the investigation is completed, now we have a whole lot of information available with us. So even we are responsible for sharing this information with the other authorities. Sharing of information, disclosure of information, just like we had studied it in our PMLA chapter. And one extra point here coming up here is, suppose if the arrest is done in case of a government company, or if arrest is done in case of a foreign company, then arrest can be done only after taking a written approval from the central government. That is one thing. And suppose if the arrest pertains to government company, then in that case we are supposed to inform the MD or the person in charge of the government company that so and so person has been arrested from your company. And suppose if the MD or person in charge itself is arrested in case of that government company, then we will go and intimate it to one of the ministries called as administrative ministry. To his secretary, we will go and inform that we have arrested the MD or person in charge of so and so government company. That was one extra requirement there. So this was all about your section number 212. This was all about your section number 212. That is where the investigation was conducted by the SFIO. Then going on to section number 213, where the investigation is going to be ordered by the tribunal. Okay, now there are four bases again. Okay, there are four bases where the investigation can be ordered by the tribunal. First one, if the business is being conducted to defraud the creditors, members, or the business is being conducted for unlawful purpose or fraudulent purpose, etc. Or if the company itself was formed for a fraudulent purpose right from beginning. Or if the promoters have been found guilty of fraud, misconduct, misfeasance, etc. And last, if the members are not given all the information which they should have been given. If any of these bases exist, then in that case, either the tribunal can suo motu order for investigation, or any person can go and make an application to the tribunal for conducting the investigation under section 213. This any person includes members, it can include creditors, it can include any particular person. So now, once if these four bases are established, then after that, the tribunal is going to give a ROBH. Tribunal will conduct the investigation. It will pass the order, and it will give an ROBH, and then it will proceed for the prosecution if any particular person is held guilty. Now, how many members should go and make an application? In case of the numbers have been given only in case of members. If the company is not having share capital, then same as our operation and mismanagement, that is 1/5 of the total number of members. 1/5 of the total number of members can go and make an application. If the company is having share capital, then in that case, 100 members or members holding at least 10% of the total voting power, these many of them can go and make an application to the tribunal for the purpose of making an application under section 213. And if any person, if suppose we come to know that yes, the business was conducted in a fraudulent manner, or if the company was formed for a fraudulent purpose, or if the promoters etc are guilty of this, that is if you fall under the first three bases, okay, if you fall under the first three bases, then in that case it will be treated as a fraud and you will be liable under section 447. This was all about your section number 213. Let's go to the next section, that is section number 214. In section number 214, they are telling that there are two places. Okay, one was in section number 210 where the SR was passed by the shareholders and they requested the central government to conduct an investigation, which we had studied in section 210, or if the order has been passed by the tribunal, under section 213. In these two cases, the central government, even before appointing an inspector for that particular purpose of investigation, it will tell the applicant to pay a security deposit of up to rupees 25,000. If suppose this investigation results into prosecution, means if it is a good case, means if it turns out to be the claim of the shareholders etc turn out to be correct, then in that case they will get the refund of the security deposit that they would have paid. Okay, now this up to rupees 25,000, this ranges on the basis of the turnover of the company. Suppose we'll go and check the turnover for the last year. If the turnover for the last year was up to rupees 50 crore, then in that case the amount will be 10,000. If it was more than rupees 50 crore but up to rupees 200 crore, then it is going to be 15,000. And if it is more than rupees 200 crore, then the security deposit is going to be of rupees 25,000. Okay, so this amount will have to pay as security deposit. Suppose if it results into prosecution, we'll get this money back. If it does not result in prosecution, then gone, that will be forfeited. Then after that, going on to the next section, that is section number 215, which was a very simple section, which simply said that body, corporate, firm, associations, etc. cannot be the inspector. So inspector ideally should be an individual person, the person who is going and doing the groundwork, who is going and doing that inspection, inquiry, investigation, etc. Then going on to the next section, that is section number 216, investigation into ownership of the company. This can be ordered. This can be ordered by the central government, or this can be even ordered by the tribunal. That's written at the end. By default, generally it is ordered by the central government. If central government is of the opinion that we need to find out the true persons who are owning the company, then in that case, we can do investigation into ownership of the company to find out three things. First of all, the persons who are financially interested in the success or failure of the company. Then the persons who materially influence the policies of the company or who control the policies of the company. And the last one, we were checking the beneficial owner of the shares of the company, or the people who are having beneficial interest in the shares of the company. So to check about these three things, we can do the investigation. That investigation happens under section 216. Okay, so this can be ordered either by the central government, or the tribunal can also direct the central government to conduct the investigation into ownership of the company. And at that time, everything, the scope, etc. will be decided, and that can even be limited by the central government. This was all about your section number 216. Going on to the next section, that is section number 217, which is a one-time read section. 217 simply talks about the powers of the inspector. Now, whichever type of inspector is appointed, maybe for the purpose of inspection, inquiry, or for the purpose of investigation, or for the purpose of SFIO, or in any of the sections, if there is any inspector that is appointed, if he comes in the company, then it becomes our duty. Okay, it becomes the duty of the company, it becomes the duty of the officers of the company, past officers of the company, employees of the company, agents of the company, etc. to provide the necessary information. To, for first duty is to preserve the documents, then to produce those documents before the inspector, and then to provide all the necessary assistance. That is our duty, we have to do it. Okay, now once they are coming in our particular company for the purpose of inspection, inquiry, investigation, then they can ask for the necessary information. While doing my investigation, they can even go to any other company my related companies, and they can conduct their investigation, etc. also. But before doing that, the inspector has to take the prior approval. The inspector has to take the prior approval of the central government. And suppose if SFIO was going on in my case and now it wants to switch on and do the investigation of the other company, then we'll have to the inspector will have to take the prior approval of the director of the SFIO before it gets into the books of accounts of the related companies of my company. Then these people, these inspectors have got all the powers as vested in a civil court. So discovery of documents, examination of any person on oath, taking evidences on oath, etc. These powers are available with the inspector. And if you do not obey, a general punishment has been given. If you do not listen to the directions which have been given by the inspector, then in that case it will be treated as an offense and we will be punishable. Okay, then whatever, after doing the inspection and inquiry, the inspector has the powers that it can take down the examination notes. It will read it out before me. I will have to sign it that yes, he asked me this and I gave so and so answers. And these examination notes can be used as evidence against me in the court of law. If again I do not listen to certain things which have been instructed by the inspector, then in that case again that will be treated as an offense and I will be liable for some amount of fine. Now, suppose if the inspector is of the opinion that so and so information is not available in India, then in that case we can use the same concept of PMLA, that is sending a letter of request to the other country. Suppose if we are of the opinion that the information is not available here in India, but the information will be available outside India, then through the central government, we can issue a letter of request to the other country and we can seek the information from them. And similarly, vice versa thing can also happen. Suppose if they send us a letter of request, then it becomes our duty to furnish them with the required information within the specified time. These were the powers of the inspector under section 217. Going on to the next section, that is section number 218, which talks about protection of employees during investigation. Now, it can so happen that during investigation, the company would remove its employees, or it can dismiss its employee, or it can punish them, or it can reduce their terms of employment to their disadvantage. Then in that case, they are telling that the law says that the company cannot remove its employees directly. The company will have to first make an application to the tribunal seeking their objections, that whether do you have any objections if we remove so and so employee, and the tribunal is supposed to reply within a period of 30 days. If suppose the tribunal says that okay, it replies within 30 days and it says okay, remove so and so employee, then that particular employee can be removed. That employee can be removed. Suppose if the tribunal says no, you cannot remove, then in that case by default the company cannot remove that employee. Suppose if the tribunal does not reply at all within a period of 30 days, or if it replies late, then that is treated as no reply. If that is treated as no reply, then in that case the company wins. The company wins means the employee can be removed in that case. In the first two cases where the tribunal's reply was received, either yes or no, whoever is the aggrieved person can go and file an appeal before the NCLAT within a period of 30 days from the receipt of the NCLT's order, and the final decision, the decision of the NCLAT is going to be full and final. No appeal in that case is possible. Beyond that is possible. Okay, no appeal beyond that is possible. And in the last case where the tribunal could not reply at all, or where the tribunal did not reply at all, then in that case there is no appeal possible and the company wins in that particular case. Then going on to the next section, that is section number 219. 219 was talking about investigation into the related companies or other persons. In this, we are going and doing the investigation in 4 persons. First of all, we can go to the subsidiary of this company, to the holding company of this company, or to another subsidiary of our holding company, either present or past subsidiaries or holding company. Next, we are going to such a company where we have got a common MD or manager, means any person who is or was a MD or manager in our company is controlling another company as MD or manager. So we can go and do the investigation into such other company also. Next one, we are going and doing the investigation of such a company whose board of directors is accustomed is required to act as per the directions given by the directors of our company. And the last one, we are going and doing the investigation of the company's MD, manager, employee, be it past person or be it the present person. We can do all these 4 things. Okay, we can do all these 4 things, but only after taking the approval of the central government. Because whenever we want to jump to any other company, from our company, if we want to go and do the investigation of some other company, then always the prior approval of the central government will be required. Otherwise, the inspector cannot act in that behalf. Then going on to the next section, that is section number 220, which talks about the search and seizure. Okay, now here the search and seizure that is happening, that is being conducted by the inspector during investigation. Okay, in 209, the search and seizure that happened, that was during inspection and inquiry. So here, if the inspector is of the opinion that while doing the investigation, if it comes to know that if we leave the original books of accounts in the company, then that can be altered, falsified, destroyed, mutilated, and all those secreted, etc., then in that case, inspector has the power that it can enter such places, it can search the place where the books of accounts have been kept, and then it can seize the books of accounts after allowing the company to keep the copies of the same. These have to be returned back to the company maximum till the end of the investigation. Means here there is no that 180 plus 180 time period is not available. And once we are returning it back, then in that case we can put the identification mark on it, and we can now keep the copies of the books of accounts or extracts of the books of accounts. So till here the investigation part of the chapter gets over. Going on to the next section, section number 221. 221 talks about freezing of assets in case of a company. Now suppose if the tribunal is of the opinion, that we can sell off our assets to defraud the creditors, members, etc., then the tribunal has the power that it can pass a freezing order on us for any particular period, but not exceeding a period of 3 years, if it is of the opinion that it is necessary to do so in the interest of the company, in the interest of the shareholders, in the interest of the creditors, then it can definitely do so. Tribunal generally does this when an order has been passed in the 5 circumstances, or tribunal passes an order in the 5 circumstances. Suppose if central government has told the tribunal to do so, or suppose if tribunal itself conducted certain investigation under section 213, it ordered investigation under section 213, and then it is of the opinion that we should pass the freezing order, or if someone has come and filed a complaint for that oppression and mismanagement under section 244, or if the application has been made by a creditor whose outstanding amount is more than or equal to rupees 1 lakh, or if complaint has been filed by any other person. Means basically, if central government has told, or if tribunal has told, or if some members or creditors have come and made an application, basically that way. So the tribunal can pass a freezing order under section 221, and if we contravene this freezing order, then we will be liable for certain amounts of punishment. Then similarly, going on to the next section, that is section number 222, where the tribunal imposes a restriction upon our securities. Okay, if the tribunal is of the opinion, if suppose tribunal is of the opinion that it needs to find out, okay, you remember we did the investigation under section 216 about the ownership of the company. So after doing that investigation, suppose if we are of the opinion that we need to find out more about the shareholding pattern, about the shares in the company, about the securities in the company, then, and if the tribunal is of the opinion that we cannot find out more information until and unless we put the restriction on the securities, so in that case the tribunal can impose the restriction on the securities for any period, but not exceeding a period of 3 years. Okay, this generally the tribunal does whenever the investigation was done under section 216, or if suppose someone goes and makes a complaint to the tribunal that, sir, you should be checking the securities of the company, then in that case tribunal will exercise its powers under section 222. What all powers does the tribunal have here? It can tell us that if you were going to issue new shares, then just stop for the moment. You cannot transfer any shares. If you transfer any shares, then that will be treated as void. You cannot exercise any voting rights in respect of the shares. No dividend or any capital repayment should happen except in case of liquidation. No new shares is to be issued. No buyback, etc. should be done. No reduction in share capital, etc. can be done. These restrictions can be put up by the tribunal, but for a maximum period of 3 years. And if we still contravene the orders of the tribunal, okay, if we still contravene the orders of the tribunal, then in that case, again, that will lead to an offense and we will be liable for certain punishment. Okay, then after that, going on to the last few sections, that is the miscellaneous provisions, starting with section number 223, which talks about inspector's report. Now, in whichever section the inspector was appointed, the inspector might be required to submit the interim report to the central government if required, and if not required, then once the inspection, inquiry, investigation gets completed, then in that case, the inspector is going to submit the final report. This report has to be in writing. If the members, creditors, or any affected person, if they want the copy of the report, then we can go and make an application to the central government and we can obtain the copy of the report. But the section is inapplicable to SFIO, because we already know that in case of SFIO, if we require the copy of the report, then we'll have to go and make an application to the special court, and then only we can take the copy. Okay, this report, the report of the inspector, has to be properly authenticated with the seal of the company. If suppose seal is not possible, then in that case it has to be certified by the public officer, just like we discussed about the gazetted officer. And this report, the inspector's report, can be used as evidence against us in any particular court of law, in any legal proceedings. That was told in section number 223 about the inspector's report. Now, once the inspector's report goes to the central government or to the special court, in that case, now we start taking action. Okay, now we start taking action against the defaulting persons. Basically, 5 actions can be taken. First of all, prosecution will be instituted. Means now punishment will be imposed on that particular person. That is one thing. Second thing is, 2 options are possible. Either you solve it as if it is a case of oppression and mismanagement, means you provide the relief from oppression and mismanagement, or if nothing works, then in that case we are going to do the winding up of that particular company. Okay, next one is we are going to recover the damages and compensation from the person because of whom we suffered this losses. Maybe the shareholders, creditors, or other people would have suffered some amount of damages and compensation. So we will recover it from the defaulting person. Then after that, the costs. The cost of the investigation, which was initially borne by the central government or by form of that security deposit, that will be recovered from the persons who have been held guilty. And the last one, if suppose if any officers of the company have involved themselves into earning any undue advantage or undue gains, undue profits, then now we are going to take the help of tribunal and we are going to do the disgorgement of such gains. These are the 5 actions that we are taking on the basis of the inspector's report, because now the case has totally got over. Then going on to the next section, that is section number 225, about which we have already discussed, that whenever the investigation expenses were borne by way of that security deposit under section 214, that was initial thing. Now suppose if that investigation had led into prosecution, then now we are going to get it reimbursed. Now we are going to get it reimbursed from the people who are held guilty, who are prosecuted, who are liable to pay the damages. We are going to get it recovered from those people. This was there in section number 225. Now going on to section number 226, where they say that suppose if investigation proceedings are going on against a particular company and some shareholders, maybe they come and, or the company, they come and make an application for voluntary winding up, or if they file a petition for winding up before the tribunal, voluntary winding up under IBC or normal winding up under the Companies Act, or if some group of shareholders come and make an application for oppression and mismanagement, then even though they want to run away from this investigation proceedings, then to voluntary winding up, oppression, mismanagement, these processes cannot stop. These processes cannot stop the investigation proceedings. Means the winding up order is going to be effective only on the basis of the conclusion of the investigation. So the company cannot run away. The company cannot run away from the investigation proceedings, meaning that investigation proceedings are going to override the liquidation proceedings. Then after that, going to the next section, that is section number 227, which talks about obligations of the legal advisors and the bankers to share information with the authorities. So the Companies Act says that legal advisors are not bound to provide any information to the ROC, inspector, central government, or any particular authority except the name and address of their client. And when we go to the bankers, if suppose these authorities go to the bankers to seek some information about the person on whom investigation is going on, then in that case the bankers also can provide the information only about this particular person and not about any other person or not about any other body corporates. That is the restriction that has been put on the legal advisors and the banking companies by the Companies Act section number 227. 7. Then going on to the next section, that is section number 228, which was talking about inspection, inquiry and investigation in case of foreign companies. So whatever we have studied in the entire chapter, right from 209 to section number 229, each and every provision becomes applicable to the extent possible, obviously, to the extent possible, each and every section becomes applicable to the foreign companies also. And last, section number 229, which says that whenever the inspector, ROC, central government, etc., whenever they called for any information from you, and if you submitted false information knowingly, if you submitted false statements, or if you provided some information which you knew that this is wrong, then in that case, that will be treated as a fraud. And if that is treated as a fraud, then we will be liable under section 447 of the Act. And this was all about the provisions of inspection, inquiry and investigation. I hope you are very, very clear with that. Okay, so for the miscellaneous provisions chapter, what I have done is the entire video on this miscellaneous provisions chapter is available on our website for free. You can just go to our website arpitatulsyan.com, and there, by going to free resources, there will be a tab called as free notes. In that, there is a folder called as miscellaneous provisions, and in that all the lectures on this particular chapter is available, and that too amended, because Nidhi company has got a lot of amendments, so the entire chapter has been put up there, so you can directly refer it from our website. Those are available for free. Yes. Chalo, let's start with a super quick revision of compromises, arrangements and amalgamations, ranging between section number 230 to section number 240 of the Companies Act 2013. First of all, two types of reconstructions. First one is your internal reconstruction and the other one is your external reconstruction. In internal reconstruction, there can be two types of concepts involved there. One is compromise and the other one is arrangement. Compromise is such a thing, or it is such kind of settlement where the person is willing to forego a particular amount, where he is letting go some part of his debt. And arrangement means there is some kind of exchange of position. Example, maybe the creditors would get converted into equity shareholders or something like that, but there they are not, in case of arrangements, they are not letting off any of their debt go. Then next one, in case of external reconstruction, you have got your mergers, amalgamations, etc. Now when we talk about types of amalgamations as studied in our IPCC, we have got two types of amalgamation. One is amalgamation in the nature of merger and the other one is amalgamation in the nature of purchase. When we go to amalgamation in nature of merger, then in that case, if the five conditions which are given in the definition, if that gets fulfilled, then in that case it will be called as amalgamation in the nature of merger. First one, there should be transfer of all the assets and liabilities. Second one, the transfer should take place at the book value until unless it is required to bring in consistency with the accounting policies. Then shareholders holding at least 90% of the face value of the equity shares, excluding the cross holding in the other company. Those many number of shareholders should become the shareholders of the new company. Then the consideration that you are going to pay to the shareholder should be by way of shares only, except that for a fraction of shares you can pay the amount in cash, and the business is going to be carried on in near future. If these five conditions gets fulfilled, then we call it as amalgamation in the nature of merger. Otherwise, it is going to be called as amalgamation in the nature of purchase. Okay. Then after that, going on to the main provisions, that is starting from section number 230, which is the one of the most important sections of the entire chapter. Section number 230 talks about compromises or arrangement, and it is going to also talk about the procedures of the amalgamation, which we are going to study later on. So now there can be a compromise between a company or a creditor. There can be a compromise or arrangement between a company or a member. So either the company or the creditor or the members, these people can go and make an application to the tribunal that they wish to enter into such compromise or arrangement agreement, and they are requesting to the tribunal. They are simply requesting to the tribunal to allow them to call a meeting of the members or the creditors, as the case may be. So here we are just going and making an application to the tribunal that please allow us to call for a meeting. Then after that, when we when we go and make an application to the tribunal, we have to take mainly three things along with us. First one, the financial details of the company, that is all the material facts about the company, its financial position, its liquidity position. We'll take all the information about that. Then along with that, if suppose in our compromise or arrangement we have proposed about the scheme of reduction in share capital, then we'll take the details of that. And suppose if we have proposed the scheme of corporate debt restructuring, CDR, then we'll be taking that scheme along, which has to be certified by at least 75% of the secured creditors in value. Whenever you have your corporate debt restructuring in your scheme, then in that case 5 more details are to be submitted. First of all is going to be your creditors responsibility statement, that they are also going to that they are just a declaration that they are going to safeguard the interest of the other creditors also. The next one, the steps taken to safeguard the interest of other creditors. Then after that, the post reconstruction liquidity report has to be post restructuring or reconstruction, whatever liquidity position you anticipate, those details have to be given. Then after that, if suppose if there are some RBI guidelines which have to be followed in case of doing this corporate debt restructuring, then we have to give a declaration that even those have been followed, and then we have to submit a report by the registered valuer. These are the 5 extra things that we have to submit whenever our scheme is going to involve corporate debt restructuring. Then after that, once you have called the meeting, once you have taken the permission from the tribunal for calling the meeting, plus once you have submitted these 3 plus 5 is equal to 8 documents to the tribunal, then after that, assuming that the tribunal agrees and it allows you to call for the meeting, then after that the notice is going to be sent to everyone. It is going to be sent to the members, it is going to be sent to the creditors, to all the debenture holders, then at their individual addresses it is going to be sent. Along with this particular notice, you will give the details of compromise or arrangement, that the details of the scheme basically, then what effect it is going to have on the members and the creditors, what effect it is going to have on the management of the company, and then the copy of the valuation report which was given by the registered valuer. This you will attach along with the notice that you're sending to each and every one of them. This is one thing. And just sending them the notice is not sufficient. We'll have to even advertise about this particular notice. First of all, advertisement will be placed on the website of the company, if the company has any website. If the company is a listed company, then we are also going to forward it to SEBI and to the recognized stock exchanges so that they can put it on their website. Plus, we have to put it in 2 newspapers also, which is going to be in form number CAA2. The last point on the last page, the thing that we studied about creditors responsibility statement, that was in CAA1, and this advertisement in newspapers is going to be in CAA2. So this way you're supposed to do the advertisement of the notice that you're going to give to each and every one of them. Then plus in the advertisement you will be writing that suppose if someone wants a physical copy of that, then that details will be given in the advertisement, that yes, the physical copies of this particular notices and the attachments along with that will be available in the company till so and so date, within so and so time, etc. So if anyone asks for the physical copy, then we will have to provide. Okay, then in that case we will have to provide those copies. Then after that, in the notice, we will give them 2 things. We'll give them 2 options, or we'll say them about 2 things. First of all, that they are supposed to vote. Okay, they are supposed to vote within a period of 1 month. Either they can come in the company and vote whenever the meeting is going to be held, or alternatively, they can vote by way of postal ballot. And one more point that we're going to study later on is, if suppose here itself 90% of the creditors give their, if at least 90% of the creditors give an affidavit that they are okay with the scheme, then the tribunal can even dispense of calling with their meeting. Means the tribunal will say if at least 90% of the creditors have given their approval, then in that case we need not even call their meeting. Okay. And another thing is, if someone wants to raise objection against this particular scheme, then in that case, in case of members, the members holding at least 10% of the shareholding, and in case of creditors, people holding at least, or the creditors holding at least 5% of the total outstanding debt, these many people can raise the objection, and if the objection is raised, then we'll have to again reconsider the scheme, and then only we can proceed ahead. Acha. Once you have given the individual notices to the members, creditors, SEBI, put it in the paper, put it on the website, etc. Once everything of that sort is done, then after that, we are also supposed to give the notice to all the statutory authorities who are applicable to the company. It can be the central government, it can be the income tax authorities, it can be the ROC, it can be the stock exchanges, it can be RBI, it can be competition commission, whoever is applicable to you. We are supposed to give them the statutory we are supposed to give them the notice, who are our statutory authorities, and we'll tell them that if you have any objection, then in that case you can raise this objection within a period of 30 days. If the objection is not raised, then it will be assumed that you are okay and we'll proceed ahead with the scheme. Okay, and this notice to the statutory authorities, this is given in form number CAA3. This is given in form number CAA3. Then after that, once this is done, once all the statutory requirements etc. are done, then after that we are going to call that meeting in which we are going to take the voting. In that we are going to take a dual majority. How do we take the dual majority? First of all, here we'll consider only those shareholders or the creditors who are voting in the meeting. Means first of all, they should be coming to the meeting. After coming to the meeting also, they should be voting either in favor or against, but we are going to consider only those people who are voting in the meeting. In that, first of all, by way of we'll see the in case of numbers, we'll check the simple majority, that is more than 50% should be more than 50% of the people who are voting, those people should be voting in favor. That is the first thing. And the second one is the people who are voting in favor should be holding more than or equal to 3/4 in value of the shares of the people who are totally voting. Okay, so the people who are voting either yes or no will do the aggregate into 3/4. These many of the shareholders or these much of the value of the shareholder should be saying yes. If both the above conditions are fulfilled. Just observe one more thing. In the above point, it was more than 50% because we wanted a majority. Okay, and below it is at least 3/4. So more than or equal to 3/4 or more than or equal to 75%. So just keep that in mind. Once both these conditions are fulfilled, then it is deemed as if the scheme has been sanctioned. Once the scheme is sanctioned, then after that the matter goes to the tribunal. Tribunal will approve it. Tribunal will pass an order for it. It will write various things in its order that how the implementation etc. is supposed to be done. Okay, and finally the exit offer. If suppose there are any dissenting shareholders, creditors etc., then in that case to them we are going to give an exit offer. What exit offer is to be given etc., that was already written in the scheme and that will now be approved by the tribunal here. Plus we are also supposed to file a statement or a certificate rather of the auditor that whatever accounting treatment they are going to give to this particular compromise or arrangement, that will be in accordance with the accounting standards as prescribed under section 133. This we have to give just for the purpose of compliance. And once the tribunal passes any particular order, once he passes the previous order, then in that case it is assumed that the order is final. We'll go and file it with the ROC as always within a period of 30 days. Okay, once we do that, then ROC also records that internal reconstruction or whatever compromise or arrangement happened in this particular company's case, and now the scheme is altogether sanctioned. Okay, then after that, suppose if there was any buyback involved. Okay, suppose if there was any buyback involved in this particular scheme, then that buyback has to be as per section number 68. But suppose if there is any reduction of share capital involved in the scheme, then that will be as per the scheme and not as per section number 66 of the Companies Act 2013. Okay, and the next one is suppose if the company whose internal reconstruction is going on, if that company is a listed company. Okay, and suppose if later on this compromise or arrangement gets converted into amalgamations, means the internal reconstruction gets transferred into external reconstruction. Maybe we had planned for internal reconstruction but that could not work, so we went for external reconstruction. Then in that case, whatever takeover, mergers, amalgamation, whatever happens, that will be as per the SEBI provisions. Means it should also fulfill the SEBI regulations or SEBI requirements if that company is a listed company. Right, and in the entire section, wherever the powers were delegated to the tribunal, suppose if this company would have been a government company, then in that case, instead of tribunal, the word or the authority who is going to come into picture is the central government. This was all about your section number 230. Now 231 is very, very simple. 231 simply says the post thing, okay, means it is going to be a provision which is going to be applicable once the scheme is sanctioned. Once the scheme is sanctioned, after that we'll have to look after the implementation of the plan. We'll have to see whether the plan is getting implemented properly, and we are going to give directions for that. Okay, who is going to give that? Obviously, the tribunal is going to give that. Tribunal is going to have the powers to supervise the implementation and to give the directions for proper implementation of this particular thing. And if the tribunal thinks that, if it thinks that no, it is not possible to implement this even after putting efforts, etc., then in that case it can pass an order for winding up. It will simply wind up there. And here also, instead of tribunal, the authority who is going to come up here is central government if the company is a government company. This was section number 231. Okay, this was section number 231. Now going on to the next section, that is section number 232, which is going to talk about mergers and amalgamation. That is mainly we are going to talk about external reconstruction here. So suppose whenever there is any transfer of assets or liabilities, and there is a merger of two or more companies are coming together, and if there is transfer of assets and liabilities, then section number 232 will be applicable. Many of the procedures are going to be similar to that of section number 230, the first section. Okay, the first section that we had studied in this particular chapter, that is section number 230. So here also, we go and make an application to the tribunal that we are planning for this merger and amalgamation of two companies, and there is going to be transfer of properties which is going to be involved there. For that purpose also, okay, we are supposed to give the notices to everyone, just like we gave it in section number 230 subsection 3, and we'll give the notices, we'll put it in the newspaper, we'll give the advertisement, we'll put it on the website, SEBI website, etc. Then after that we'll give them the opportunity to raise objections, just like we had done it there. Then after that we are going to give the notice to the statutory authorities also, just like a section 230 subsection 5. And after that we are going to take a dual majority, just like we took it in section number 230 subsection 6. So the provisions from section 230 subsection 3 to 230 subsection 6 is going to remain the same. It's just that mainly there is going to be change in the documents. Okay, there is going to be change in the documents that we are going to submit to different people. There we had submitted all the documents in relation to internal reconstruction. Here we are going to submit the documents in relation to your mergers, amalgamations. Okay, so now there is going to be a draft scheme regarding your merger and amalgamation that is going to be prepared. Then after that there is going to be discussions about the exchange ratio. Then after that the next one is going to be the valuation report. Then after that we are going to go and submit all these things to the ROC also, because now the companies are changing, the nature of the companies are changing. And one different thing which is coming up here is we are also supposed to prepare a supplementary accounting statement. Okay, we are also supposed to prepare a supplementary accounting statement if suppose my financial statements are older than 6 months. Okay, then just to bring it to the current date, we are going to prepare a supplementary accounting statement. All these things are supposed to be submitted. All these things are to be supposed to be not submitted actually. All these things must be circulated whenever we are calling for the meeting. Okay, so this will be put up on the website. This will be given to the members, creditors, debenture holders, etc. You gave all these things, you called for the meeting, you took the dual majority. Then after that the tribunal is going to pass the final order. It will write in that what exchange ratio is approved, how the transfer of assets and liabilities is going to take place, at what values it is going to take place, what are we supposed to do with the dissenting shareholders, what are we supposed to do with the NRI holders, what about employees, how are they going to transfer from one company to another, what about the legal proceedings of the old company, will it continue or will it get lapsed when it gets converted into a new company, and all those things, right? About these things it will be written in the tribunal's order. A few specific things which can be provided in the tribunal's order is, suppose if the transferor company was a listed company and the new company, that is the transferee company, is an unlisted company. Transferee means the continuing company. Then in that case, if suppose the older one was a listed company and now we are an unlisted company, then because of this, the transferee company does not by default become a listed company. For becoming a listed company, it will have to go as per the SEBI provisions, etc. for listing. Okay. Similarly, now if the shareholders of this listed company, if they are dissenting from the offer, then in that case they will be paid. They will be paid cash, right? They will we'll ask them to exit from the company. We will pay them cash as per a predetermined price formula, and this price should not be lesser than the price as fixed by the SEBI. Because they are the shareholders of which company? They are the shareholders of the listed company. So SEBI is also going to have an intervention there. Similarly, suppose if the transferor company had paid fees on the authorized share capital, and now after merger or amalgamation, if suppose there is some extra fees which is becoming payable on the authorized share capital of the transferee company, then the fees paid by the transferor company will be set off against the eligible fees for the transferee company. So the fees paid by the transferor company can be set off. Right, all these things will be provided in the tribunal's order, and once the tribunal's order is passed, then it becomes binding on everyone. Plus, similarly, just like we had done it in section number 230, auditor's report has auditor's certificate has to be submitted, or the company auditor's certificate has to be submitted, that whatever the accounting treatment is going to be given, that will be in accordance with the accounting standards prescribed under section 133. Once this is done, now the actual process is going to start. The transfer of assets and liabilities will take place. We'll go and submit the copy of order with the ROC within a period of 30 days. A particular date will be fixed as if this is the date of your merger and amalgamation. That date is called as an appointed date. Okay, merger amalgamation is an ongoing process, so a particular date has to be fixed on which date we are going to pass all the entries and all, which is going to be called as an appointed date. And then about its implementation, how the plan is getting implemented, etc. For this purpose, we are supposed to submit a form called as CAA8. Okay, it is nothing but a compliance form actually, CAA8, to the ROC for every financial year till the time the process does not get completed within a period of 210 days from the end of each financial year. And this has to be certified either by the CA, CS or the cost accountant. They have to certify it, and if any of the provisions are contravened, then this is the amended penalty that is going to be applicable there. Then again, here also in the entire section, in section number 232, wherever the company is a government company, then in that case, instead of the term tribunal, we are going to use the authority called as central government. So 232 was more or less similar to section number 230. The major differences here where the documents that we are circulating along with the notice, there is a change in the documents, and a few extra points which are coming up here. One was regarding that listed unlisted company, and the other one was about that authorized share capital. Right, the fees on the authorized share capital. These are the 2 to 3 different points which are just coming up here in the section number 232. Then going on to the next one, that is section number 233, which talks about fast track merger. Okay, now this fast track merger can be adopted, not mandatory, but this section can be adopted by certain specific companies. It can be 2 or more small companies, or it can be whenever there is a merger between a holding company and its wholly owned subsidiary, then in that case, this section can be used, and the central government can prescribe more list of companies in this list of section number in the the companies to whom section 233 can apply. For this, the central government can prescribe more number of companies. Now here they say that comparatively we take lesser time for these small companies. Comparatively, they have provided for such a procedure which can take some lesser time for this particular merger and amalgamation. So for this purpose, what are we supposed to do? First of all, we are going to invite objections, suggestions from ROC, from the official liquidator, and from all the people who can get affected because of this particular order, that is your members, creditors and all those people. We'll give them 30 days time that if you have any objections to this particular merger amalgamation, then please raise it. Okay, then once we start receiving it, after that we call a general meeting. In the general meeting, the shareholders do the necessary things and they approve it by a voting of means at least those many number of members should be voting who are holding at least 90% of the total number of shares. Okay, at least these many people should be voting in favor of that. Then after that, we are also supposed to file a document called as declaration of solvency with the ROC, that even after doing this reconstruction, we are going to be solvent. Then after that, you give 21 days time period to the creditors. Then you call the meeting of the creditors. In that case, the scheme is going to be approved. In that case, the scheme is going to be approved by creditors who are holding at least 9/10 in the value, 90% of the value of the creditors. Once this is done, means already the members and the creditors have approved the scheme. Then after that, we take the final scheme. We take the final scheme in form number CAA11. We take it with 3 people. 2 of them are common, that is the ROC and the official liquidator, and you also take it to the central government within a period of 7 days. Once you take it before them, then CG is just going to sit and observe first. ROC or the official liquidator, they will see that do they have any objections or suggestions. If they do not have, then no problem, they'll just tell it to the CG and the CG will register the scheme. Suppose if they have objection, if the ROC or the OL have any objection, then they will communicate it to the central government. Okay, if not communicated, then obviously it is going to be assumed as if they do not have any objections. Now the objections went to the central government. If central government thinks that yes, the scheme is actually not proper or it is not in the public interest, etc., then central government will go before the tribunal, and now the tribunal will decide what to do. Okay, now the tribunal is going to decide whether some changes can be done, or if fast track merger is not possible, then in that case it will make the previous section, that is section number 232, become applicable. Okay, so this way, suppose if everything is okay, then CG passes the order. If suppose the CG thinks that no, something is not okay, then CG places the matter before the tribunal. Okay, these were the major provisions. Now whenever this thing happens, then after that we have to go and intimate. Okay, we have to go and intimate to the ROC of the new company, ROC of the transferee company. Then we will communicate it to both the companies, and plus we will even communicate once it is communicated to the ROC and to the company, then the ROC will register the scheme. It will take the record of the scheme, and now it will give the confirmation to the ROC of the transferor company, that is the ROC of the old company, that yes, the scheme is registered and now I am going to be the ROC of this particular transferee company. Acha, once all these things happens, means now the scheme is approved, the scheme is registered, and now the transfer of assets, liabilities, what to do with the legal proceedings, what to do with the employees, etc., all these things will be determined. Okay, once this is done, after that again the same point relating to authorized share capital, fees on the authorized share capital, that same point is going to be applicable, that is set off is going to be applicable there. Then after that, central government also has got the right that whenever it wants to include any particular company in the list of section number 233, it can do that. Okay, whenever it wants to provide similar provisions for fast track compromises, it can do that also. As of now, we are studying it for fast track merger. If it wants to put the provisions for fast track compromises, then it can even prepare those provisions. As of now, nothing has been prescribed, but central government has got the powers that it can do so. Okay, and one more very, very important thing, very, very conceptual thing. Section 233, the section that we are studying, this section is not a mandatory section. Means if you are a small company, or if there is a merger or amalgamation of holding and it's wholly owned subsidiary company, then in that case, it is not mandatory that you have to follow section number 233. You can even go and follow section number 232 as well. Okay, so it's not mandatory that if you are a small company, etc., then 233 is applicable. You have got the option between section number 233 and section number 232. Okay, then after this comes section number 234, which talks about merger of Indian companies with a foreign company. Here the definition of foreign company is not restricted to section 2 clause 42 that we had studied in the first chapter of company law. Here foreign company means any company which has been incorporated outside India, whether having a place of business in India or not. Right now, whenever this thing happens, that an Indian company is getting merged with a foreign company, or a foreign company is getting merged with an Indian company, then first of all it is termed as cross-border mergers. And whenever this thing happens, then ROC will come into picture, central government will come into picture, plus even the role of RBI comes into picture, because this even FEMA provisions become applicable there, and this becomes such a type of transaction where foreign currency can be involved. So central government will prepare the rules for that. We do not have the exact rules, what are the rules for this merger, but central government will prepare the rules for that, and that will be approved by the RBI that will be done in consultation with the RBI provisions. And then in that case, suppose if an Indian company is getting merged with a foreign company, means foreign company becomes a bigger company here, so it is going to pay the consideration to the shareholders of the Indian company, which can be in form of cash, which can be in form of IDRs, and vice versa. Suppose if an Indian company is taking over a foreign company, or if a foreign company gets merged with an Indian company, then we become a strong company. We give the shares. We'll either issue our shares to the shareholders of the foreign company, or we'll give the cash, or we can even give the global depository receipts to them. So consideration to them can be paid by way of cash, can be paid by way of depository receipts, or partly by one and partly by the other. Right, this is just the overview. This was just the overview that how merger or amalgamation happens whenever any foreign company is involved in the league. Then after that, going on to the next section, that is section number 235, which is a very simple section. Whenever any merger or amalgamation etc. takes place, then there, along with transfer of assets and liabilities, there is going to be transfer of shares also. That is, whenever the transferee company comes into picture, it basically cancels the shares of the transferor company, and it issues its own shares to the shareholders of the transferor company. It issues new shares to the shareholders of the transferor company. So for that, first of all, it gives a time period of 4 months. Okay, overall, it gives a time period of 4 months to the shareholders of the transferor company to accept this particular offer. If this offer is accepted, by the shareholders holding at least 90% of the value of the shares, then in that case we proceed ahead. Then in that case, it is assumed that we have got the majority and they are okay with the transfer of share scheme that we have framed. So we gave them 4 months time period. After giving this 4 months time period, we assume that at least 90% of them say yes. Then within a period of next 2 months, okay, next 2 months, the company is going to give a final notice to the dissenting shareholders. Within the period of 2 months, after this 4 months, we give a notice to the dissenting shareholders that you have got another period of 1 month. This is what we tell them. Okay, we give them the notice within a period of 2 months, and whenever we give them the notice, we tell them that from today you have got a period of 1 month to either accept the swap ratio or accept the transfer of share scheme that we have put up, or you can exit from the company. We give them 1 month time period to them. And then after a period of 1 month, suppose if whatever option they choose, on the basis of that we are supposed to do the treatment. Suppose if they decide to accept the shares of the new company, we will issue them the shares as per the swap ratio or as per the exchange ratio that we had decided. Suppose if they decide to exit from the company, then in that case, whatever was a predetermined formula at which we were supposed to give them the cash, at that price we will give them the cash within a period of 60 days. Right, this is all that we had studied in section number 235. That is 4 months, 2 months and 1 month, and after that we are going to do then the payment within a period of 60 days. This is what we had studied in section number 235. Then after that, going on to the next section, that is section number 236. In 236, there was about this minority and the majority shareholders. Now, suppose if in a company you have got a majority shareholders, a group of majority shareholders who are holding at least 90%, of the issued share capital, then they form the majority. The rest of them becomes your minority shareholders. Now, there can be two things. Either the majority shareholders will give a notice to the company that we wish to acquire the shares of the minority shareholders, or even the minority can come upfront and they can say that, okay, you can acquire our shares anyway. The decision making is going to be happening by the majority shareholders only. So here the majority shareholders can acquire the interest of the minority shareholders. Again, it is not mandatory for the minority shareholders to give up their shares. Okay, it was just an offer. The minority shareholders can even decline it. Okay, then whatever the consideration at which the shares are going to be acquired from the minority shareholders, that will be determined by the registered valuer, and whatever is the amount that will be put in a separate bank account. Okay, this everything will be done by the company itself. Here there is no second company involved, so the transfer agent is going to be the company itself. Company is going to put the money, company is going to keep this money deposited in a separate bank account. This account will operate for a period of 1 year generally, and the disbursement has to be done within a period of 60 days. Okay, initially within a period of 60 days the disbursement should happen, but max to max it should be done within an overall period of 1 year. Suppose in case of death, etc., then in that case, suppose if there is a death of the of a minority shareholder, or if there is any insolvency case, then in that case, instead of 1 year, it can be kept open. The scheme can be kept open for a period of 3 years there. Once all these things happen, the amount is paid to the minority shareholders, we take their shares, and the shares go to the majority ones, and they become 100% holder of the shares of the company. Suppose if the shares were held in the physical format, then we will do the changes in the share certificate. Suppose if the shares are held in the dematerialized demat format, then in that case, the transfer of shares will take place from one demat account to another. Right now, suppose if in minority, the minority part that we had, that is less than or equal to 10% of the issued share capital of the company. Suppose if in minority, if we have got a majority, in minority, if you have got the majority, means the shareholders holding at least 75% of the minority shareholding, that person is at a stronger position to do the bargain with the majority shareholders. So if he does any bargain and he gets a good claim from the majority shareholders, then whatever is the extra premium that he is getting over and above the decided amount, then that amount has to be shared with all the minority shareholders. That will just not be taken by the majority person who is sitting in the minority. It will not be taken just by that person. It has to be shared with all the minority shareholders. We have also got an example on this in the textbook. You can simply refer this example once. Then after that, going on to the next section, that is section number 237. 237 talks about the case where the merger or amalgamation happens or is done by the central government in public interest. That is, whenever the central government is of the opinion that it is advisable to do the merger of these two or more companies, or it is advisable to amalgamate these two or more companies, then it can do so by passing a notification in the official gazette, and after that providing for the merger or amalgamation of such companies. Now, whenever such a thing happens, again there is going to be transfer of assets or liabilities. Again, the legal proceedings of the old company will now continue against the new company. Similar like your mergers and amalgamation. But before doing that, central government has to make sure that whatever is the proposed scheme of merger or amalgamation that is given to all the companies who are involved in this particular merger or amalgamation, they should be given an opportunity to file an appeal. Till the time the appeal is not disposed of, till that time central government cannot pass the final merger or amalgamation order. And whenever we give this draft order to the companies, after that, within a period of 2 months, central government should consider all the objections, suggestions, etc., and then only it should proceed for passing a final order. Once it passes the final order, after that it is laid down before both the houses of parliament, it is put up in the official gazette, and then only it becomes applicable. All the people in from the old company will now get into the new company. They should be given nearly similar rights which they were having in the old company. Suppose if they are not given similar rights, then in that case they will be eligible for compensation. Now, suppose if they are aggrieved with the compensation, then in that case they can go and file an appeal before the tribunal within a period of 30 days. Means whenever the scheme was published in the official gazette, from that day, within a period of 30 days, they can go and file an application. They can go and file an appeal application with the tribunal, and then the tribunal's decision on this is going to be full and final. Okay, so here basically this is nothing is happening voluntarily here. Everything whatever is happening here is compulsory thing, where the central government is of the opinion, after giving an opportunities definitely to both the companies, that yes, the company should be amalgamating there. Okay, then after that, the next thing is section number 238, which pertains to, or which is in continuation of, or which pertains to section number 235. Actually, this section is applicable before we do section number 235. You remember in 235 we did that 4 months, 2 months and 1 month thing which was coming up there. So in that case, whenever you frame that transfer of share scheme and you or give it to the shareholders of the company, etc., before giving it to the shareholders, make sure that you have registered it with the ROC. Okay, now there are going to be 3 things which is very, very important here. First one is it should contain the details. The scheme should contain the details that how did you arrive at the swap ratio. That is the first thing that you have to check. Next thing is you have to kind of give a declaration of solvency that even after paying to the shareholders of the transferor company, you will be having sufficient cash in the company. And third one, this particular scheme or this particular circular has to be registered with the ROC, so that it gives a sense of faith in amongst the shareholders of the company that yes, at least ROC has checked this particular scheme or ROC has checked this particular circular. Suppose if the ROC thinks that no, something is not good in that, then the ROC can refuse. It can refuse to register this particular circular, and it will intimate the companies within a period of 30 days that your circular or your scheme is utter nonsense, so please change it. Okay, now suppose if I think that no, the ROC has falsely rejected it or falsely refused it, then in that case we can go and file an appeal to the tribunal against the ROC's refusal. Right? And suppose if the directors of the company or the management of the company, they do this, means if there is a contravention of section number 238, that is they were required to go and register it with the ROC, but if they did not do it, then in that case they will be liable for a penalty of rupees 1 lakh. So basically, before you come out with the transfer of share scheme before the shareholders of the transferor company, before that you have to make sure that you go and register it with the ROC. Then after that, going on to the next section, that is section number 239, which talks about preservation of books of accounts of the company. Now, the books of accounts of the transferee company is going to continue in the future. So, what about the books of accounts of the transferor company? You have to maintain it as per the normal provisions of the Companies Act 2013. And before disposal, we have to make sure that we take the prior permission of the central government before its disposal. Central government will appoint some person who will do the inspection in this particular books of accounts. If it wants to find out that if any fraud, misfeasance, or if any offense has been done in the company prior to this merger, amalgamations, etc. So only after taking the prior permission of the central government, we can dispose of the books of accounts of the transferor company. And the last section, that is section number 240, which said that even if merger amalgamation happens, suppose if before merger or amalgamation, if there were any offences which were committed, then the officers of the company, that is the management of the company, will still be liable. They will still be liable for the offences which were done prior to that mergers or amalgamation. They do not get relieved from the liability once the merger or amalgamation happens. And then we had got the two case laws here from the old law. One was that suppose in case of whenever in the old times, whenever the exchange ratio was decided, no person can go and raise objections in regards to those exchange ratio before the court unless that person is able to prove that there is this exchange ratio is grossly unfair. Till that time, the court is not going to interfere in between. And similarly, whenever any valuations happen, just like earlier valuations were done by chartered accountants, merchant bankers, etc. Now it is being done only by the registered valuer. So earlier, whenever the valuations, etc. were done, if the valuation was done by a reputed firm of chartered accountants, and if it was approved by majority of the shareholders, then a few minority shareholders cannot raise the objection. And even if these minority shareholders raise the objection, then that objection will not be considered. These were the two case laws. These were the two case laws that we had taken up in the from the old law, that is Companies Act 1956. And in the penalties, section 232 penalty is specifically important just because it has got amended this time. So you can just focus on this penalty of section number 232. And with this we are done. With this revision of chapter Compromises, Arrangements, Amalgamation. 5 forms that we used in the chapter: CAA1, which was the creditor's responsibility statement; CAA2, which was for giving the notice in the newspaper; CAA3, which was for giving the notice to the 30 days notice to the statutory authorities; CAA8, which was the compliance statement that we were filing it to the ROC within 210 days from the end of the financial year; and CAA11, where we submitted, in case of fast track merger, where we submitted the approved scheme to the central government ROC or the official liquidator. I hope I am very, very clear till here and you are able to recollect the provisions. with a super quick revision of winding up, which comes under chapter number 20 of the Companies Act 2013, ranging between section number 270 to section number 365, with many sections omitted from the act and many sections omitted in our syllabus. First of all, section number 270 says that if winding up of the company has to happen, then it is going to be done as per part 1, of this particular chapter. After that, part 1 starts from section number 271. There are 5 circumstances. This is an important answer. There are 5 circumstances in which the company can be wounded up by the tribunal. First one, if the company itself realizes that it has reached the winding up position and the company passes a special resolution, then the tribunal can wind up the company. If the company has acted against the interest of our country, against the integrity or sovereignty of our country, or it has hampered the friendly relations of our country with other countries, then in that case, winding up can happen. Third one, if application has been made by the ROC or by the CG authorized person to the tribunal that affairs of the company have been conducted in fraudulent manner, or for the company was formed for fraudulent purposes, or any persons who were involved in the management of the company are guilty of any misfeasance, fraud, misconduct, etc., then in that case tribunal can wind up the company. If the company has not filed the financial statements or the annual returns for the last 5 consecutive years, then in that case, the tribunal can wind up the company. And the last one, if the tribunal is of the opinion that there is some just or equitable grounds, etc. type of point. If the tribunal suo motu thinks that it is just and equitable to wind up the company, then in that case, the tribunal can wind up the company under section 271. Or the winding up can be done under any of these 5 circumstances. For this purpose, someone has to go and file a petition before the tribunal. Okay, either the company or the shareholders or the ROC or CG authorized person, or in case of that sovereignty integrity, it can be filed by the CG or the SG. These people can go to the tribunal and they can go and file a petition for winding up. Before ROC goes, ROC will have to take a permission from the central government. Before it goes and files a petition before the tribunal, it will have to go to the CG, take the approval of the CG, and then CG will make sure that company has been given a ROBH. Company has been given a reasonable opportunity of being heard before the ROC proceeds for winding up before the tribunal. All the details will be attached. Along with the application. And whenever the application is filed by the company or its shareholders, we have to make sure that along with that, the statement of affairs of the company is attached. Means whenever the company is going suo motu for its winding up, it has to attach the statement of affairs along with the application before it goes to the tribunal. Okay, and then this copy of petition which was submitted to the tribunal, whoever goes and files the petition before the tribunal, that person should also submit a copy of this petition to the ROC also, because the company is ultimately registered with the ROC. We have to submit this petition to the ROC, and then ROC will submit its views to the tribunal within a period of 60 days. ROC will submit its views that whether winding up should happen or whether winding up should not happen. This happened in section number 272. 5 circumstances were mentioned in section number 271. Now, after that, once the petition reaches the tribunal, then the tribunal will start taking action on it. It can pass different type of orders. Either it will dismiss the petition altogether, or it will make an interim order. Making an interim order means it can say that, okay, on so and so basis, we think that winding up should happen, but this is not the final one. And so in that case, it can even appoint a provisional liquidator. So that it can take the help of provisional liquidator and determine whether winding up should be done or not. Or it can modify the order. So basically it can confirm, it can modify, it can set aside, and whenever it is passing any interim order at that point of time, it can appoint a provisional liquidator as well. But whatever type of order it has to pass, tribunal, this is important, tribunal has to make sure that it passes an order within 90 days from the date of presentation of petition. Means winding up order has to be passed within a period of 90 days from the day when the winding up petition commenced, or the day when we presented the petition before the tribunal. Then after that, whenever the tribunal is of the opinion that winding up is happening due to insolvency, then in that case we will not do the winding up here. We'll take the winding up under IBC voluntary liquidation thing. right? And before tribunal takes any action against the company, it has to make sure that a reasonable opportunity of being heard is given to the company before any winding up order is passed. Then after that, you remember in section number 272, when the company was going and filing a petition, along with the petition, it submitted its statement of affairs to the tribunal. Now, when the petition is filed by any other person, be it by ROC, central government, state government, etc., then in that case, once those people go and file the petition before the tribunal will now direct me, that is the company, raise your objections and plus submit your statement of affairs within a period of 30 days. Okay, your extension can also be provided, but by default the time period is 30 days within which we will raise our objections and we will have to provide the statement of affairs. Suppose if we do not file the statement of affairs, we say that no, I don't want to file my statement of affairs, then I will not even be having the right to raise objections. If I am not listening to the tribunal, then tribunal won't accept my objections also. Okay, and at the top of that, we will also be punishable. The company or the directors of the company, etc., they will be punishable for not submitting the statement of affairs. Right? Then after that, whenever we are punishable here for not filing the statement of affairs or for not submitting the statement of affairs, we are liable for fine or imprisonment. Okay, that is applicable. And in case of imprisonment, the cognizance of offense has to be given. The cognizance of offense has to be given before the special court. So then only the special court will come into picture and it will determine the final period of imprisonment. Then after that, going on to the next section, that is section number 275, which talks about appointment of the liquidators. Whenever we pass the interim orders, the tribunal had appointed a provisional liquidator. Later after that, you can appoint the same person as the company liquidator, or you can take up a new person as the company liquidator from the data bank of the IBC, or you can take some person as an official liquidator from the government's database. Generally, official liquidator comes in the case of government companies. Okay, nowadays we appoint liquidators from the data bank of the IBC itself, that is under the IBC Act itself. And as soon as this particular liquidator is appointed, within a period of 7 days, he will have to give a statement about his conflict of interest and independence. If at all it is getting affected, then he will have to give that particular declaration. Now, suppose if he is involved, if this particular liquidator is found guilty of any misconduct, misfeasance, fraud, professionally he is incompetent to become a liquidator, or if there is any conflict of interest, or if there is any lack of independence, then in that case we can remove this particular liquidator after giving him a reasonable opportunity of being heard. Okay, and in such cases his work gets transferred to another liquidator. Similarly, when he resigns, or similarly in case of his death, and at that time also his work is going to get transferred to another liquidator. And if suppose because of this liquidator the company or any particular person has suffered any amount of losses, then the liquidator is going to be personally liable for all such things. But yes, before putting any claim on him or before removing him from his office, we are supposed to give him a reasonable opportunity of being heard. Then after that, once the tribunal passes an order, either the interim order or once it passes the final winding up order, then after that it is going to disseminate the information. Okay, the tribunal should disseminate the information that winding up is going to be started in case of so and so company. So it will tell the CL or the PL that you are being appointed as the CL or the PL, and plus it will intimate the ROC. Then ROC will go and intimate. In case of listed companies, it will go and intimate to the stock exchanges. In case of unlisted company, this particular fact will be published in the official gazette. As soon as this winding up order comes into picture, it will act as a discharge notice that okay, all the employees, all the workmen of the company can now leave the company because the company is going to get wounded up, except in the case where the business of the company is going to be continued. Okay, then you are supposed to form a committee called as winding up committee. Winding up committee is formed by the company liquidator, and for that purpose company liquidator will go and make an application to the tribunal for formation of a winding up committee within 3 weeks of the winding up order. Then this committee is formed. Okay, who all sits in this particular committee? So official liquidator, that independent person, is going to sit in the committee. One of the nominee of the secured creditor is going to sit in the committee, and any other professionals as required or as nominated by the tribunal. These people are going to sit under the winding up committee, and they are simply going to have a control. They are going to have a control over the company liquidator while performing the duties in relation to winding up. Okay, then after that they will start monitoring the company liquidator. Whenever the company liquidator is selling off the assets, paying off the liabilities, whenever they are settling of the claims, whenever they are preparing the statement of affairs, etc., at that time all these things will be done by the CL only, but this will be monitored by the winding up committee. And whenever the CL has to submit anything to the tribunal, whenever the CL is supposed to submit anything to the tribunal, before that a draft report will be submitted to this winding up committee, and then only the matter goes to the tribunal. Then after that, one thing that they are deeming under this particular chapter is, whenever any winding up order is made, it will be deemed as if it was done by way of a joint petition filed by the creditors or the contributories. Meaning that the winding up order should always favor the creditors and the contributories, because those are the people who are ultimately affected by the winding up. Okay, then another section number 279, which is important, which says that suppose if once the winding up commences in the company, then kind of moratorium starts. Any legal cases which we had initiated or which we wish to initiate or which someone had initiated against me, everything will come to an halt. You cannot proceed with that except with the tribunal's permission. So whenever you go and obtain the permission from the tribunal is going to provide you the permission within a period of 60 days. Means either it will say yes or it will say no within a period of 60 days. But this provision is not applicable. That is, taking the permission of tribunal is not required when the case is going on before the High Court or the Supreme Court, because they are higher in the hierarchy. Right? Because they are higher in the hierarchy there. Then after that, section number 280 was simply talking about the powers of the tribunal, that what all powers does the tribunal have. So tribunal has the powers that it can continue the pending suits which were going on. If it thinks that winding up is not required, then maybe it can go for some fast track merger or amalgamations, or it can go for some kind of reconstruction, that is internal reconstruction or external reconstruction. These all are the powers. Okay, these all are the powers of the tribunal which it will exercise under the Companies Act 2013. Then after that, once all these things happen, now the company liquidator is all set to start the liquidation. Okay, for this purpose, the liquidator is going to prepare full lekha jokha, full report about the company. Okay, what value of assets are there, how much liabilities is there, how much contingent liabilities can arise, what all suits are pending against the company or by the company, trademarks of the company, goodwill of the company, copyrights of the company, joint venture agreements that the company is having. Each and every detail about the company will be submitted by the company liquidator to the tribunal within a period of 60 days, so that even the tribunal is aware about the facts of the company which is undergoing this winding up. Okay, then after that, here we will come to know that company liquidator will come to know about the viability of the business also, that whether the business can be continued in the future, whether the undertaking can be sold as a going concern or not, or are we supposed to purely liquidate it. So through all this information that we submitted to the tribunal, we will get an idea about that. Now, once this report goes to the tribunal, even the tribunal acts on this report which was submitted by the company liquidator. So tribunal will come to know what is the quantum of this particular company. So how much time will the company liquidator take for, or he should take for from winding up to dissolution, how much time will be taken. And later on, yes, if a particular time period is determined by the tribunal, later this time period can be revised also. Then the tribunal can also take a decision, should we sell off the entire undertaking as a going concern? That is just like I gave you the example of slum sale. Can it be sold as entirely as slum sale, etc.? For this purpose, if required, we can appoint a committee called as, tribunal may appoint a committee called as sale committee, who is going to help the company liquidator to sell off this particular either undertaking or sell off the assets. Okay. Now, say for example, if on the basis of this particular report, if tribunal is of the opinion that some problem is there in the company and the company must be investigated, then in that case, tribunal can go to that section number 210 and it can make an application to the CG, and then CG will have to compulsorily conduct an investigation in case of this particular company. Okay, so basically here the tribunal is also taking steps in actively winding up this particular company, and if it thinks that investigation is required, then it can go for this investigation. It can make an application to the CG for getting this investigation done. Then after this, once winding up starts, now already the winding up has started, so CL will become active. CL or the PL, whoever was there in the company, either the same person or the new person who has come into the company, that person will take the custody of all the assets. That person will take the custody of all the assets of the company, all the properties of the company, all the books of accounts of the company. And another thing is, suppose if it is of the opinion, if suppose company liquidator is of the opinion that some assets of the company, some books of the company is kept with any employee, or it is kept with any shareholder, or if it is kept with any director officers of the company, then we will take the custody from them also. Because it is not the property of those people, it is the property of the company. So we will also recover it from them. So custody of everything comes in the hands of the liquidator. Acha, now after that, we have started taking the custody, we have started preparing reports. Now we also expect cooperation. Okay, we also expect cooperation from the officers in charge, from the promoters of the company, so that the company liquidator is able to discharge his functions effectively. Okay, if any particular person does not help the company liquidator, then the company liquidator will go and complain, or it will go and make an application to the tribunal. Then the tribunal will pass the necessary order on that defaulting person, and now that person will have to cooperate with the company liquidator. So basically we are taking the help of the tribunal if someone is not cooperating with me. This was the amendment. Then after that, going on to the next section, section number 285, which is very, very simple but important, because this is simple because we have already studied this in our IPCC. Whenever you are settling the list of the contributories, that is whenever you are settling the list of the shareholders, we have got two types of contributories, list A contributories and the list B contributories. List A means the present shareholders, list B means the past shareholders. First, we will try to recover the money from the present contributories, but their liability will be restricted only up to the unpaid amount. Okay, so that much amount we will recover it from the present shareholders. Suppose if we still have got the deficit, then in that case only we will go to the past contributories. Okay, but past contributories also only those contributories who have left or who have ceased to become our member during the last 1 year, or and it will be restricted only to their unpaid amount, and they will be liable only if the debt subsisted on the day when they ceased to become a member. Okay, the reason for which we are asking them the money, if that debt was not at all existing on the day when they left the company, then you cannot ask for any money from the past shareholders. Okay, now this is generally applicable when the company is limited by shares. So we are restricting the liability to the unpaid amount. What if the company is a guarantee company and plus it is limited by shares? Then in that case, we will take the guaranteed amount from them plus the amount up to the unpaid amount on the shares. This is the liability. This is the liability of the shareholders. Okay, this is the liability of the shareholders, or we can say this is the liability of the contributories that we are going to recover from them at the time of winding up of the company. Similarly, this was of the shareholders. Now when we go to the directors and the managers, by default they say that directors and managers will be liable unlimitedly. Right, as if they are the shareholders of an unlimited company. In that manner they are going to be liable. But again, if they cease to be the director or manager during the last 1 year, then only they will be liable. Okay, if they have left our company before that, then we cannot hold them liable. And suppose if the day when they left the company, on that day there was no debt outstanding, so we cannot hold that particular director as liable. Right? Then after that you constituted a committee called as advisory committee. As the name suggests, it is going to advise to the company liquidator on various matters put forth. before them. So advisory committee can have maximum 12 members, and in these members we are going to have the creditors and the contributories only. Okay, generally creditors and contributories sit in this advisory committee, or any other member as nominated by the tribunal. They have got full right to inspect the books of accounts and documents of the company liquidator which he is preparing during the time of liquidation. These people will be given weightage. Okay, we are going to consider their wishes. We are going to conduct the meeting of this advisory committee also. Okay, and this meeting is going to be chaired by the company liquidator. So basically, company liquidator is there. It has formed an advisory committee who is going to advise the company liquidator on various factors. Then after that, the company liquidator has to, on time to time basis, it has to submit the progress report. Okay, it has to submit the progress report to the tribunal about how the winding up is going on, and these reports are submitted on a periodicity of quarterly basis. That is, quarterly reports, quarterly progress reports are submitted to the tribunal, and then tribunal can take the necessary steps on the basis of the progress report that is submitted to it. Then after that, section number 290, which is very, very simple, which is very, very generic, which talks about powers and duties of the company liquidator. That company liquidator has got various powers. Now, suppose if it is of the opinion that business should be carried on for some time, then it will carry on the business. If it thinks that asset should be sold off, it will sell off the asset. If it thinks that some professional assistance must be taken, it will take that. If it thinks that after taking the approval from the tribunal, we should defend the suit, we should defend the case, it will do that. Okay, if it thinks that we should be raising funds for temporarily running the company, it can do that. If it thinks that it is advisable to sell the entire undertaking as a going concern, it will do that. It will take the assets into its custody, it will sell off the assets, it will pay off the liabilities, it will settle the claims. All these are the powers and duties of the company liquidator. Okay, all these work have to be done by the company liquidator only, and the company liquidator, you will come to know about this in section number 330. Company liquidator cannot transfer the assets to any particular trust so that the trust pays it on later to the creditors. In case of liquidation, the CL only has to sell off the assets and has to pay off the liabilities to the creditors. It cannot transfer the assets to a trust and then tell the trust to distribute the assets to the creditors. That is not allowed as per section 330, because doing this is the power and duty of the company liquidator only. So this way you can connect section 290 and section 330. Then after that, as per section 291, company liquidator has got full powers that it can appoint either a CS or a CA or a cost accountant or a legal practitioner after taking the approval from the tribunal for assisting him during the process of winding up. But again, there should be no conflict of interest and there should be no lack of independence when any such professional person is appointed. That person will have to disclose if there is any such thing which is existing. Okay, then after that, going on to the next point, that is about the CL's power. Now listen, just try to understand one thing. CL had formed a committee called as advisory committee, right? So CL may conduct, okay, CL may conduct the meeting of the creditors or contributories to ascertain their wishes. If it wants to do suo moto, it can do. Okay, but if those people if the creditors or contributory mandatorily tell to the CL, please conduct our meeting, then the CL will have to conduct the meeting of these people when a request has been done by way of passing a resolution, or when a request has been done by the creditors holding a value of at least 10% of the total creditors. If these many people go and make an application to the CL, then the CL will have to conduct their meeting. Okay, now just try to understand. This advisory committee is having maximum 12 members, consisting of creditors and the contributories. So CL will have to listen to the advisory committee, but if other creditors and contributories say something, then that is going to override the advisory committee. Because in advisory committee there were only maximum 12 members sitting, but maximum chunk of people are sitting here. So if advisory committee says X, and if other creditors and contributories say Y, then Y is going to prevail. Okay, then just remember Y is going to prevail there. Then after that, the next one, books of accounts, books to be kept by the company liquidator. Now, company liquidator, along with maintaining the books of accounts of the company, can I say he will also prepare his own sets of accounts in relation to this particular company? That is, it will prepare the receipts and payment account, it will prepare, it will maintain all the necessary books, and it will make the necessary entries in this. As soon as any particular asset is sold, the entry is made. As soon as any liability is made, the entry is made. And these are the CL's book, okay? These are the CL's book, and this can be inspected. This can be inspected by the creditor or contributory, but subjected to tribunal's permission. Okay, but subjected to the tribunal's permission. And government authorities, etc., can they check the CL's book? Yes, government authorities can check the CL's book without even approval of the tribunal. But when the creditor or the contributory is going to check it, then they have to take the prior approval of the tribunal. Acha, these books which are maintained, okay, these books which are maintained by the company liquidator, these books will be presented to the tribunal at least twice a year. Okay, summary of these books or these books will be presented to the tribunal at least twice a year. Tribunal can even tell you to get the books of accounts audited. So the CL will get the books of accounts audited. One copy will be submitted to the tribunal, another copy will be submitted to the ROC. And if this pertains to a government company, if the accounts pertains to government companies, then it will also be additionally be submitted to either the central government if only CG is a member, or to the state government or governments if they are the members, or if both of them are the members, then the report, audit report, will be submitted to both of them, that is CG as well as the SG. Okay, then after that, going on to the next section, that is section number 295. Whenever you are doing any settlements, okay, or whenever you are doing any transaction with your creditor or contributory, you can set off the dues. Okay, suppose if you have to pay some amount to the creditor and you have to receive some amount from that particular person, then that can be set off. Only one thing that cannot be set off is when you are doing any transaction with the contributories, then any undeclared dividend cannot be set off. Okay, then any undeclared dividend cannot be set off, means the contributory cannot say that you should have paid me 30 rupees, so I am going to pay you 30 rupees less now. Only undeclared dividend cannot be set off, rest everything can be set off whenever you are doing any settlement between the company and the creditors or the contributors. Then after that, suppose if there is some unpaid amount, okay, suppose if there is some unpaid amount which is to be recovered from the contributories, then we can call that amount now. Or if there is any calls in arrears which is going on, then tribunal has got the powers that it can empower the company liquidator. Okay, tribunal has the power to give the authorization, then it will empower the company liquidator to make the calls in that case. Then after that, whatever amount is finally payable to the contributories, that will be distributed among the contributories, not as per the head count, but on the basis of their shareholding. The amount will be distributed amongst all the contributories. Then after that, next one, suppose if while doing all these things, whatever expenses are met, that is whatever winding up expenses are met, then that will be paid in the sequence that we are going to study as per section 326 and 327. Then after that, suppose if the tribunal is of the opinion that there is some particular person who is holding the company's assets or who is holding company's property, then we can summon that particular person, we can call that particular person, we can gather evidences about such particular person, and we will tell him that please you also come and meet me, and plus bring the assets of the company, bring the books of accounts of the company that you are wrongfully holding. Now if that person comes and he says that no, I don't have the asset of the company, I have sold it off, then we will tell that company to compensate, we'll tell that particular person to compensate us. If that particular person comes to meet the tribunal because of the summon, and he says that asset is kept with me but it is kept at home, then in that case we will tell that particular person, please deliver this asset back to the company or back to the company liquidator. So if any person is wrongfully holding the assets of the company, that person will have to give it back to the company. That person cannot hold it on behalf of the company. Then after that, the next one, suppose if the tribunal has come to know from company liquidator. Okay, the tribunal has come to know from the company liquidator that some fraud or some misconduct had happened at the time when the company was incorporated. So in that case, we will call that person, okay, we'll call that person, the tribunal will call that person before the court, and it will do the proceedings. At that time, CL can also be present in that examination, because on CL's because the CL told that so and so fraud has happened, then only the case initiated. So before tribunal, you are going to have that defaulting promoter and you are going to have the CL who is going to sit. This promoter will fight the case. Okay, it can take the help of CA, CS, cost accountant, legal practitioner, and it will file the case. Okay, we can even examine this particular person on oath. Now, suppose if the promoter puts a claim before the tribunal that, sir, I am not guilty. Sir, I am not guilty. There was no fraud that was done during incorporation of the company. Please free me from all the charges. So in that case, tribunal will pass an order, but only after giving an opportunity to the CL. Because CL was the complainant. You cannot simply free this particular promoter. So before you are freeing this particular promoter, please give an opportunity to the CL to at least put his points forward before the tribunal. And then only final decision will be taken against this particular promoter. Then if you come to know that there is some particular person who is trying to abscond or who is trying to leave India, then we can, tribunal has full powers, like that person was trying to leave because that person was trying to leave, or he was trying to abscond because he was trying to evade some liability, he was trying to avoid questioning from the tribunal, or he was trying to fraudulently flew away along with his property. Then in that case we have full right that we can detain that particular person and we can even seize the assets or the books and papers with which he was trying to abscond the country. Okay, this section is important. Section number 301 is specifically important. Then going on to next section, section number 302. As soon as this winding up and all these things are done, after that the company will be wound up. The CL will make an application to the tribunal that, sir, please pass a dissolution order. Tribunal will pass a dissolution order. Tribunal will give one copy to the ROC. Tribunal will give another copy to the CL and will tell the CL to submit it to the ROC, right? And this is how the dissolution is totally completed. 303 was a transition provision that can be totally ignored. That was talking about appeals under the old law, right? And then till section number 303, your part 1, the part 1 of the chapter gets over here. Next part was talking about voluntary winding up. This has been totally omitted from the Companies Act because now these have been introduced in your IBC, which we studied in section number 59, which is talking about voluntary winding up. And then going on to the next part, last part of the chapter, that is part number 3, which talks about the general provisions. Okay, first of all, whenever you are paying off any liabilities, okay, whenever you are paying off any debts, then that has to be admissible against proof only. Means you should be having some proof that yes, so and so liability is due, and then only you are going to pay to that particular creditor. Then after that, going on to the next two important sections, that is section number 326 and 327, where we are going to study the sequence, that is in what sequence are we supposed to do the payment. So the sequence that is mainly applicable is first section number 326 payment will be done, then winding up expenses will be met, then 327 payment will be done, then floating charge, other creditors, preference and equity. Okay, this always remains the same. This sequence always remains the same. Okay, the first 4 pointers are specifically important. Now let's try to understand what is going to come up in section number 326. In 326, first of all, any amount which is payable under Industrial Disputes Act for the last 2 years. That is wages, salary, compensation payable under this particular act. First of all, that is going to be paid, and all the accrued holiday remuneration. Okay, all the accrued holiday remuneration to all types of workmen for the last 2 years. First, that is going to be paid in priority over any particular debt. Okay, then after that, the next thing that we are going to pay is to the other workmen. To the other workmen we are going to pay, as well as to the secured creditors out of the asset which was secured with the secured creditors. Okay, we are going to pay this on pro rata basis. This is going to be the second thing. Okay, this was the first thing in 326 and this is going to be the second thing under section 326 that we are going to pay. This will be paid on pro rata basis, that is, this will be ranked equally. Then after that, you meet the actual expenses of winding up, and then you go to the preferential payments. Okay, when you go to preferential payments, there are going to be 7 points. Okay, 7 pointers are there which will be ranked equally. Okay, so it's not a particular sequence in which you are going to pay. You are going to pay equally to all of them. Okay, what are those 7 points? Now, government taxes will be paid for the last 12 months. Then other wages and salaries etc. will be paid for the last 12 months, but only of 4 months. That is of 4 months out of the last 12 months. Then after that, accrued holiday remuneration to employees. Earlier you paid holiday remuneration to the workmen. Then after that, you are going to make the payment of employers' contribution to different funds of the last 12 months. Then any amount which was due to the employees from the respective funds, that will be paid of the last that will be paid out of the funds. Then after that, investigation expenses, if it was to be borne by the company, that will be paid. And then compensation under the Workmen Compensation Act. These seven things will be paid under preferential payments, and these will be ranked equally. Suppose if you have deficit, then these will be ranked equally and proportionately they are going to be paid. Then after that, if there are any liabilities secured by floating charge, example can be debenture holders, then any other creditors which are left, any other outsider which is left, then preference shareholders, and then equity shareholders. This is going to be the order of payment that we are compulsorily supposed to follow at the time of payment under section 300 or as per section 326 and section number 327. Okay, if an unsecured creditor, now there is a note coming up here, if an unsecured creditor goes to the court and he just tries to prove his debt, okay, if he just tries to prove his debt that so and so amount he is yet to receive from the company, and if the court says yes, your debt is correct, then that does not make him a secured creditor. It's just that his debt has been proved, but that does not make him an secured creditor. He will still be treated as an unsecured creditor only. Then after that, going on to the next section, that is section number 328, two subsections are going to come up there. In the first subsection, where you're trying to give fraudulent preference to any of your creditors during the last 12 months preceding the winding up commencement date, that is, you're trying to put that particular creditor in a better position, maybe by giving him some fixed charge, or maybe by giving him some guarantee, or maybe by making some early payment to him, which is ordinarily not done in course of business. Then in that case, the tribunal, if it is satisfied, then it can declare the transaction as invalid and it can restore the position. Or if you're trying to get rid of your assets, if you're trying to transfer your assets, then in that case also tribunal has got full powers. The tribunal has got full powers to declare the transaction as invalid and to restore the position. Even that should be happening. Either you're putting your creditors in a better position during the last 6 months, or you're doing a preferential transfer of your property during the last 6 months. Then in that case, it will be covered under section 328, and the CL, if the CL comes to know about this transaction, it will satisfy the tribunal about it, and then the tribunal will declare the transaction as invalid and it is going to restore the position. Once the position is restored, then as per section number 331, the rights and liabilities of both the parties is going to remain unaffected. Means it is going to be same as before only. Okay, it is going to be same as before only. Similarly, when you go to section number 329, suppose if you're trying to transfer any particular property, movable property, immovable property, for inadequate consideration, or which is not done in ordinary course of business, then such transaction will be void against the company liquidator if such transaction was done during the last 1 year. Okay, if such transaction was done during the last 1 year before the commencement of winding up. Then 330 we have already covered along with powers and duties of the company liquidator, that you cannot transfer the assets to any particular trust. Okay, you cannot transfer the asset to any particular trust and then the trust passes it on to the creditors. No, that is not at all allowed. And 331 also we did it along with section number 328, that rights and liabilities of these people will be totally unaffected, means it is going to be same as before. Okay, then going on to the next section, that is section number 332. 332 talks about floating charge. If any floating charge is created against a proper debt of the company, and if as on the date of creation of debt, as on the date of creation of charge, if the company was a solvent company, then in that case, any charges created during the last 12 months will be treated as valid. Okay, if there was a debt against which you created a charge, but you are not able to prove your solvency, then in that case, the liability of the company will be restricted up to the principal amount plus interest at the rate of 5% per annum. But if you created a charge against no debt, then in that case the charge is totally invalid and the charge will be totally treated as null and void. This is given under section 332. Then going on to section number 333, where the company liquidator is disclaiming, okay, where the company liquidator is disclaiming certain property which are onerous property, which are burden property, which has some litigation involved in itself. So there the company liquidator is of the opinion that instead of selling this property, I will simply disclaim this. For this purpose, it can disclaim it within 12 months from the commencement of winding up, or within 12 months from the date when he becomes aware about all these things. Within so much time he can disclaim. Before disclaiming, he will go and make an application to the tribunal. Tribunal will tell him, okay, no problem, you can disclaim, but please give a notice to the interested party. The person who is interested in this particular asset, please give a notice to that particular person also. Okay, if he gives a notice to the interested person can question back to the CL that why are you disclaiming it? And whenever he questions back, then the CL has to reply within a period of 28 days plus the extended period that why is it disclaiming, or is it disclaiming or not. And if it does not reply within this 28 days, then in that case it will be deemed as if the company liquidator has adopted the property. Adopted the property means not disclaimed the property, means now it will have to sell off the property and will have to realize the money out of it. Okay, and vice versa. Suppose if it replies within a period of 28 days, then yes, the company liquidator has got full rights to disclaim that particular property. Once it disclaims the property's ownership, control, etc. gets away from our hand, but we are still liable. We are still liable towards that interested person. This we had studied in section number 333, that is disclaimer of onerous property. Then going on to the next section, that is section number 334, that suppose if as soon as the winding up starts, after that moratorium starts. So can you transfer any particular assets? Can you start dealing in any particular assets? Answer is no, you cannot deal in any particular asset except with the tribunal's permission, because moratorium is going on against you. Okay, you cannot deal into your assets, that is one section, and no one can attach your property also. No one can do the enforcement of your property also. Example, I had given some asset as mortgage to any bank, then the bank cannot sell it off except as per the tribunal's order. If tribunal says okay you can sell, then you can sell, but otherwise no one can take action against the assets of my company once the winding up has commenced, except that revenue, that is the government can sell off my assets for recovery of the taxes. It has full rights to do anything that it wants to do. Now, as per section number 336, if the officers of the company are found guilty of offences, means they are not giving all the properties to the company liquidator, they are not cooperating with the company liquidator, they are not giving the books of accounts to the company liquidator, they have fraudulently removed some property of the company during the last 12 months which belonged to the company, they have materially omitted some fact, they have altered the books of accounts, they have secreted the books of accounts, then in that case they will be liable for, then in that case they will be liable for punishment. Okay, they will be liable for punishment, that is imprisonment and fine is going to be applicable. Then after that, the next one, very important thing, that is procedurally it is very important that whenever the company is into liquidation, okay, or whenever the company's winding up is going on, during that time if the company is doing some businesses, then each and every document of the company, be it the invoices, be it the order copy, be it the letterhead, be it any particular document, that should contain a statement. Okay, that should contain a statement that the company is being wounded up, so that the other person has the knowledge about it, that yes, we are doing transaction with such a company which is undergoing winding up. Okay, if suppose it is not written, then the officers of the company as well as the liquidator, they will be liable for this particular non-compliance, because everyone should be aware about the fact that the company is going into liquidation. Acha, suppose if you want to prove that the company has so and so assets with itself, or so and so amount is payable to the creditors, then the prima facie evidence that is available with you is only the books of accounts. If we do not have any proof against any particular person, then whatever is written in the books of accounts, that becomes the final proof with you. Okay, so books of accounts of the company plays a very important role. If you do not have anything else to prove, then whatever is written in the books of accounts, that will be the truth. Okay, then that will be the truth. Then after that, the next one, about the inspection of books and papers. Okay, just try to understand one thing. Books of accounts of the company cannot be inspected by the creditors or the contributories, but can be inspected by the government. Okay, books of accounts of the company liquidator can be inspected by government. They don't have any restriction, and that can even be inspected by the creditors or contributories, but after taking tribunal's permission. Company's books of accounts cannot be inspected. CL's books of account can be inspected by the creditors or the contributories, but only after taking the permission or subjected to certain rules framed by the tribunal. Okay, then the next thing, whatever are the books of accounts of this winded up company, these books of accounts, these books of accounts can be disposed of. These books of accounts can be disposed of in the manner which the tribunal directs. Means the tribunal will tell you that for how much time are you supposed to keep it, and then it will be disposed of. But maximum liability can arise for a period of 5 years. That is, after 5 years, they say that no one will be liable for maintaining the books of accounts of the company or maintaining the books of accounts of the company liquidator. No one will be liable for that. But if say for example, central government is of the opinion that we should stop from destruction of the books of accounts, means we should preserve it for some more period, then the central government can pass such an order. It can make rules in that particular regard, and it can extend this time period. Beyond the period of 5 years also. Then after that, still if you destroy the books of accounts before the time specified, then in that case, that particular person will be eligible for fine up to rupees 50,000. Then now, whatever amount the liquidator is realizing, okay, these amounts, whatever assets he is selling off, whatever liabilities he is paying off, all these transactions are done in a separate bank account. Okay, now once you have done the declaration, etc., but still if there are some creditors who are untraceable, or if there are some contributories who are untraceable for a period of 6 months from the date of declaration, then whatever is the left out amount kept in the separate bank account, that will be transferred to an account called as company liquidation dividend and undistributed asset account in a scheduled bank. Okay, whatever, if the amount remains unclaimed for 6 months, then whatever is the unclaimed amount, that gets transferred to this particular account, and this account is under the control of ROC. Okay, this particular account is under the control of ROC, and if anyone wants to claim any amount from this account, then you will have to now go and make an application to the ROC, and you can take it from there. If there is some amount which remains unclaimed in this particular account for 15 years, now it gets transferred to an account called as General Reserve Account of the central government. And now if I want to claim any amount, I will have to go and make an application to the central government, and I can claim it from there. Okay, liquidator cannot retain any amount with himself. If he retains any amount with himself, then he will have to pay back to to these particular accounts along with interest at the rate of 12%. If he does any default, then he will be personally liable. That is, he will have to pay the principal amount, he will have to pay the interest, he will have to pay the penalty, he will have to meet any expenses that we would have incurred, and plus we can even seize his remuneration. So the liquidator cannot do the mistake of retaining the amount with himself. Okay. Then after that, whenever the tribunal tells the liquidator to file those returns, that is quarterly progress reports or submitting the accounts twice a year, etc., liquidator is supposed to do that. Okay, liquidator has to do that. That is the obligation of the liquidator. But if the liquidator does not do that, then in that case, CL will first give a notice to the liquidator that please do it. Then please do it within so and so time period. Okay, company liquidator will be given a time period of 14 days. Okay, as soon as the notice comes to us, company liquidator will be given a time period of 14 days to rectify the default. If it does not happen, then the tribunal will give a final date that by so and so date you have to rectify the default. And if you do not rectify the default, then in that case the liquidator will be liable, plus whatever expenses we are incurring, that has to be borne by the liquidator. So even liquidator can do the mistakes. Even liquidator can, mistakes can happen by the liquidator also. But CL is, the tribunal is giving opportunity to the liquidator to rectify those defaults before proceeding against that particular person. Acha, whenever we were calling the meetings of the creditors or the contributories, okay, at that time, in case of creditors, remember 10% of the creditors, 1/10 of the creditors were doing a request. Then in that case, we will check 1/10 of the value of the creditors. And whenever we check in terms of contributories, we check the voting power of the contributories. Then after that, this is a general section. Section 355 is a general section which says that whenever we are giving any evidences on affidavits, the affidavits can be sworn before whom? So in India, it can be sworn before any court, tribunal, judges, authorized persons, etc. When you have to give the affidavits outside India, then it can be sworn before any court outside India, any judge outside India, Indian diplomatic outside India, consulate officer outside India, or any authorized officer outside India. Before these people, you can go and swear, and that will be treated as a self-declaration that you have given. Acha, now say for example, dissolution order was already passed by the tribunal. If tribunal is of the opinion, either suo moto, or if any application has been done by the company liquidator, or if any application has been done by any interested person, then within 2 years from the date of dissolution, tribunal can declare the dissolution order as void. Okay, tribunal can declare the dissolution order as void, and everything will go back to the original position now. Okay, and once this dissolution order is declared as void, one copy will be submitted to the ROC, another copy will be given to the CL, so that CL again goes and submits it to the ROC, just like we did it in case of the dissolution order. Same thing we have to do it in case of, when the dissolution order becomes void. And the last one, a deemed date, that is, on which date does the winding up commences? The date when the petition is presented before the tribunal under section 272. The date of presentation of petition, or the time, time means not literally the time, basically the date when the petition is presented before the tribunal, that will be the date when the winding up has commenced. And this was all about your winding up chapter. I hope you are able to recollect the provisions more or less. Chalo, let's start with the super quick revision of appointment and remuneration of managerial personnel, which is going to range between section number 196 to section number 205. 3 important definitions to be done there. First one, managing director, which is there under 254, then manager, which is going to come under 253, and then whole-time director, which is going to come under 294. When we talk about a managing director, a few important points to be that we should be knowing here is, any person who is going to be appointed as a managing director, first of all, he should be a director in the company. Next, he should be entrusted with substantial powers of the management of the company. Means the activities which are done in administrative nature, those powers are not vested with the managing director, then that person cannot be called as the managing director of the company. Example, affixing common seal, then drawing checks, negotiable instruments, etc. These are of administrative nature. So these powers cannot be exercised. These powers cannot be exercised by a managing director. In a particular company, we can have 2 or more than 2 managing directors. Means we can have more than 1 managing directors as well in our company. Then whatever powers we have to give, or whatever scope we have to define in case of managing director, then in that case that can be done by way of an agreement, that is by either by writing it in the articles of association, or we can pass a resolution for that, or if the AOA requires, then we can even pass a special resolution for that, defining the powers which can be exercised by the managing director. But yes, most importantly, those powers should be only the substantial powers of management. Then after that, this MD, this managing director who was there, this person can be a rotational director or a non-rotational director. There is no fixed capacity which is given to this managing director. It can be decided by the company, between the company and the MD, that will he be a rotational director or will he be a non-rotational director. Similarly, we are going to have a person called as manager, which is defined under section 253. Manager, he can be a director or he need not be a director. Both is okay. Unlike your managing director, in managing director, that person had to be a director. But in manager, he can be a director or he need not be a director. Again, He is going to come under the, all the powers to him will be given by the board only. He will come under the superintendence of the board only. Again, he is going to have the substantial powers of management, just like your managing director. And in a company we can have only one manager, means a company cannot have two or more than two managers. Okay, both of them are having more or less similar powers. MD and manager are having similar powers. That's why when we go ahead in section number 196, we will study that either a company can appoint a manager or a company can appoint a managing director. Okay, either of the two is allowed at a given point of time. Then going on to the last definition of whole-time director, which is given under section 2 clause 94. He is such a director. Whole-time director is such a director who is given all the administrative powers of management, unlike managing director. He is entrusted with the day-to-day affairs of the company. Again, he can be a rotational director or he can be a non-rotational director. A company can have whatever number of whole-time directors it wants to keep, it can do that. Whole-time director should be in whole-time employment of the company. Means if there is a particular employee and if he is appointed as a director in the company, he will be deemed to be a whole-time director in the company. He can be rotational, non-rotational, just like I told you. And in a company, we can have whatever number of whole-time directors that you want to have. But if I am a whole-time director in one company, I cannot be a whole-time director in the other company. I can be an ordinary director in that other company. Then after that, going on to the next provisions of going on to the main provisions, that is section number 196 now. Section number 196 first of all puts a restriction that in a company at a given point of time, either you can have MD in the company or you can have manager in the company. Both cannot be appointed at same point of time. Whenever any managerial personnel is appointed, their tenure is going to be one term of up to 5 years each, and after that they can be reappointed. But reappointment can be done in advance also, but not earlier than 1 year before his expiry. Means 1 year in advance the reappointment can happen, not before that. Then after that, going on to the next subsection, that is 196 subsection 3, which is very, very important. 196.3 simply talks about the disqualifications. There are 4 disqualifications. If either of these points are attracted, then that person is not qualified to be appointed as a managerial person. First one, if that person's age is less than 21 or if that person has attained 70 years of age. Okay, but there is an exception here for 70 years of age, not for 21, but for 70 years of age. That if the company passes the SR, okay, and to call this particular to call this general meeting, we would have given a notice to the shareholders. In that notice, we should have attached an explanatory statement with a justification that why do we still want to appoint a person who has attained the age of 70 years. So either you pass a SR, or suppose if you are not able to pass the SR, then in that case, no problem. Check if you have got the votes casted in favor is more than the votes casted against it, and after that you can simply go and take the approval of the central government, and the appointment of such person who has attained the age of 70 years can be done. This was the first disqualification and the exception to that. Then after that, if there is any person who is an undischarged insolvent or who is adjudicated as an or adjudged as an insolvent, that person cannot be appointed. If any person has suspended payment to his creditors or done some composition with them, then he cannot be appointed. Or if any person has been convicted of any offense by any court, be it an Indian court or be it a foreign court, and if he has been sentenced to imprisonment for more than 6 months, then he can never be appointed as a managerial person. These were the 4 points which was talking about the disqualifications of a managerial person. Now, whenever this person is appointed, whenever a managerial person is appointed, his appointment will be first done by the board of directors. Then it has to be ratified by the shareholders in the general meeting. And in certain cases, we are going to take the approval of the central government. Which cases we are going to take the approval of the central government? That is going to be contained in the part 1 of schedule number 5. Then after that, whenever we call the meetings, like whenever we have to pass a ordinary resolution by the shareholders, etc., or whenever we want to call the general meeting, in the notice, everything has to be given in detail that why are we calling this particular meeting, that is for the purpose of appointment of managerial person. Everything has to be given there in detail. Then two procedures which are applicable here is, first one is, once the managerial personnel is appointed by the board, after that within a period of 60 days we have to go and file form number MR1 to the ROC regarding the appointment of a managerial personnel. And in the cases where we require CGCA approval, wherever we require CGCA approval, then in that case within a period of 90 days from his appointment we have to go and make an application to the central government in form number MR2 regarding his appointment, or for taking the approval for his appointment. And suppose if his appointment could not be, imagine he was appointed by the board of directors, but later the ratification couldn't be done by the shareholders in the general meeting, then whatever the intermittent acts that he had done in between, that will be by default treated to be valid, means those acts will be valid and those can be implemented in the company. Then after that, there are a few exceptions which are applicable here. The most important ones are, first of all, these three subsections not applicable to a government company and two subsections not applicable to a private company. Common ones, that is about the appointment, about the procedure of appointment, and about the acts becoming invalid. These are not applicable to both. This is not applicable to a government company also, and this is not applicable to a private company also. And then after that, the provision that we studied about 5 years, 10 years, one term of 5 years and then reappointment of 5 years, that provision is again not applicable for government company. For such people, that is for government companies and private company, wherever the provisions are not applicable, then in that case the provisions which are contained in their AOA, that will become applicable. Now let's understand the 4 cases where we are supposed to take the approval of the central government. First one, if there is any person who has been sentenced to imprisonment for any period, or if there is any person who has been subjected to any fine of more than ₹1,000 at any point of time under some specific acts, income tax, GST, excise, IBC, Fugitive Offenders Act, etc. They have given some specific acts, no need to by heart the name of the laws there. If you have been convicted and if you have been sentenced to imprisonment for any period, or if fine has been levied of more than ₹1,000, then if you want to appoint such a person, then first go and take the prior approval of the central government. Okay, or if you have been detained under Conservation of Forex and Prevention of Smuggling Activities Act for any period, you have just been detained, you have just been taken into custody, then in that case also you'll have to first take the prior approval of the central government, then only that person's appointment can be done as a managerial personnel. Or if that person has attained 70 years of age, which we had already studied, and we could not pass the SR, then no problem, votes casted in favor should be more than the votes casted against it, and go and take the approval of the central government. And the last one, if that person is not a resident of India, means just before his appointment he should be continuously staying in India for at least 12 months. If not, then take the approval of the central government. But this last point is not applicable to the companies which are established in SEZ, because their main purpose is going to be export, so it is not necessary for their managerial personnel to fulfill this requirement. This was all about your section number 196 and part 1 of the schedule 5. Okay, then going on to the next section where we are going to take up section number 197 and the other parts of schedule number 5. Now here in 196 we spoke about the appointment. In 197 we are going to discuss about the remuneration. Now, first case where the company is having adequate profits. Let's assume the case where the company is having adequate profits, that is covered in part 2, section 1. Okay, that is covered in the next part. Part 1 we already completed. Now we are going to part 2, and in part 2 also this is covered by section number 1. So now when the company is having adequate profits, then the total remuneration, total managerial remuneration which can be paid to the managing personnel and to the other directors in case of a public company, it should not exceed 11% of the net profits as calculated in section number 198. Okay, in that also, suppose now if your limit is going beyond 11%, then in that case, we'll have to take the authorization from the shareholders in the general meeting. What kind of authorization? So now, whenever the below mentioned individual limits are exceeded, if you want to pay more than that, then you'll have to pass a special resolution. What are those individual limits? Suppose if in your company you have only one managerial personnel, then to that managerial personnel you can pay 5% of the net profits. If you have more than one managerial personnel, then to all of them taken together you can pay 10% of the net profits. This is to the managerial personnel. Now how much to the other people? Now how much to the other directors? Now in that case, If suppose if you have MP in the company, then the other directors are going to get 1% of the net profits. And suppose if you do not have any MP in the company, then in that case, other directors are going to get 3% of the net profits. Whenever these individual limits are exceeded, then in that case, we'll have to mandatorily pass a SR. Plus, if we have done any default with the banks, with the PFIs, with the non-convertible debenture holders, or with any other secured creditor, then in that case, we'll have to first take their prior approval before we even pass a special resolution. So these two conditions are mandatory. Now going on to the other points of section number 197. First of all, this remuneration that we studied, this is not going to include any sitting fees, means sitting fees can be paid over and above. Okay, now suppose if the company has suffered any amount of losses, or the company is having inadequate profits to pay the remuneration, then in that case you will not pay as per section 197, you will have to pay as per the other provisions of schedule number 5, which we will study later on. Now, whenever we are determining the remuneration, like 5%, 10%, 1%, 3% is the remuneration that can be paid to these people. Now, say for example, let's take the example of 10%. 10% was applicable when we are paying to multiple MPs. So now how much will be paid to individual people? That will be determined either by the articles of association or by ordinary resolution, or if the articles requires me to pass a SR, then we can pass a SR and we can determine the amount of remuneration. But one very important thing here is, again here the remuneration will exclude any remuneration which is, or any fees which is payable in any other capacity. I always give the example of a person who is a doctor plus a person who is acting as a director in a hospital. Then in that case, the amount that can be paid to him in capacity of a doctor, that will be over and above the limits of the remuneration, means that will not form part of your remuneration, that can be paid extra. But provided, what are the two conditions for that? First one, the services that he is rendering should be of professional nature. Okay, and next one, it should be authenticated, or it should be, it should be opined by the NRC or by the board that the director is having those necessary qualification for providing this particular type of services. If these two conditions are fulfilled, then yes, over and above the remuneration, we can pay him other professional fees as well. Then after that, going to the point of sitting fees, we have already studied that the directors etc. will be eligible for the sitting fees for attending the board meetings, committee meetings etc. Maximum sitting fees that can be paid cannot exceed ₹1 lakh per meeting. Women director and independent director should not be paid anything lesser than the amount which has been paid to the other directors. Okay, and next one, the exact amount, 1 lakh is the maximum limit. How much amount are you going to pay to your board of directors? That will be decided by the board of the company. Then, in what manner are we going to pay the remuneration? It can be a monthly payment, it can be a monthly fixed payment, or it can be a monthly percentage based payment. You can pay an ad hoc amount during the year, and then you can make the final settlement at the end of the year. This discretion is left at the option of the company. Then after that, for the purpose of this particular section, for the purpose of paying the remuneration, we wanted to calculate that 11% and all on the net profits. So those net profits will be computed under section number 198. Suppose if there is any calculation error, or if we have paid any excessive remuneration to the directors, then in that case, by default, we have to get it recovered back. We'll recover it back from those people within a period of 2 years, and till the time we are not able to recover it back, those people will have to hold the remuneration or will hold the money in trust of the company, that is on behalf of the company. In certain cases, the company can even plan to waive off that amount, but before waive off, again, see, if it is waiving it off, means it is allowing me to accept that extra remuneration, means more than the limits. Then in that case, the company will have to pass a SR within a period of 2 years, and plus we'll have to take that approval from the outsiders with whom if we have done any kind of default. Then after that, if suppose the company is having inadequate profits, then we had already discussed that in case of inadequate profits, we will not pay the remuneration as per 11% and all those things. We'll go to the other provisions of schedule 5, and in that case, if we want to pay them any extra amount, any other amount, then even that will be determined by the other provisions of schedule number 5. Then listed companies are required to do, only listed companies are required to do certain types of disclosures in their board's report. That will be everything about the remuneration which is payable to the managerial personnel and certain types of ratios that you have to calculate, so that it so that the shareholders are able to interpret that, okay, how much was the amount of remuneration paid to them in the last year, how much amount of remuneration are we paying to them in the current year, what is the percentage increase, what is the justification regarding the percentage increase here. And three specific things that we are supposed to disclose here is, first of all, the name of the top 10 employees of the company and the name of even those employees who have drawn more than 1 crore 2 lakhs who were employed throughout the year, or who were employed for part of the year who is drawing more than or equal to 8,50,000 rupees per month, or if there is any such employee who is interested in the capital of the company, means who is holding more than or equal to 2% of the shares of the company and he is other than MP but drawing remuneration more than the MP, then there is no issue in that. He can draw, no problem, but just a disclosure should be done in the board's report of this listed company and his individual details will be given. Like when was his appointment, when was he appointed, till which date is he going to continue, his designation, his qualification, why are we paying this much amount, everything has to be given in the board's report of the listed company. Now, suppose if the company has taken any kind of insurance, okay, if the company has taken any kind of insurance where it is trying to protect itself from the liabilities which could arise because of any default done by its managerial personnel or CEO or CFO or CS, combined we can call it as a KMP, then in that case, generally the premium is borne by the company, means it does not form part of the remuneration. Okay, it has nothing to do with my remuneration because it is going to be borne by the company. But the moment I am held guilty, and after that, suppose if the company pays any premium, then that becomes part of my remuneration, means basically that will be deducted, or I am going to bear that particular insurance premium from my remuneration. Then after that, suppose if there is a MD, or if suppose there is a whole-time director, if he is working in my company plus he is also looking after some affairs of my holding company or subsidiary company, he can receive the remuneration or commission by whatever name called from the other company as well, but only after a disclosure in the board's report. It will be written in the board's report that so and so person is acting as a MD or WTD in our company as well as in this other company. If none of the provisions, or if there is any contravention of the provisions, then in that case, so and so penalty or so and so punishment is going to be applicable there. One extra point coming up here is auditor of the company, whenever he is preparing his report under section 143, he will have to certify one fact that whatever remuneration was paid to the people were as per the provisions of this section, that is section number 197, and if suppose excessive remuneration has been paid, then the reasons and the details of that has to be specified in the auditor's report as well. Last one was the transitional provision. Then after that, one very important exception is the entire section number 197 about remuneration, limits, etc. is not applicable to the government company. That is one important exception there. Now going on to the other points. Regarding remuneration, which is covered in schedule number 5. Now, we had already completed part 1 of schedule 5. In part 2, we had started with section 1, where we studied about that 11% of the net profits. Now, going on to the second section. Here, we are going to discuss about the case where the company is having inadequate profits or the company is having losses, then how much remuneration can be paid. So, here the remuneration first of all can be paid to managerial personnel, or the remuneration can be paid to any other director being non-executive directors, including independent directors. We can pay them maximum remuneration as per the limits given below. Now, by default, in such cases, remuneration will be paid on the basis of effective capital. Okay, how much amount can be paid to the managerial personnel? If you have got a negative effective capital, or if it is less than rupees 5 crore, then you can pay maximum 60 lakh rupees to per person per annum. If it is more than or equal to 5 crore, but it is less than 100 crore, then it will be 84 lakhs. If it is 100 crore and above, but less than 250 crore, then it is going to be 120 lakhs. If it is going to be more than or equal to 250 crores, the effective capital, then the remuneration that can be paid is equal to 120 lakhs, that is taken from above, plus 0.01% of the effective capital in excess of 250 crore. These are the maximum limits which can be paid in case of managerial personnel and in case of other directors. In case of other directors, that is non-executive director including an independent director, you can pay them respectively 12 lakhs, 17 lakhs, 24 lakhs and then 24 lakhs plus 0.01%. This is the remuneration that you can pay in case of inadequate profits or in case of losses. Suppose if you want to pay more than this, then in that case, one requirement is you will have to pass a special resolution if you want to pay more than the limits. And one very important thing, even if you are paying here within the limits, then also you are mandatorily required to pass an ordinary resolution. If the limits are getting exceeded, then pass the special resolution. Now, if there is any such managerial personnel or other director who is working in a professional capacity, and if he is not at all interested, if he is not interested in the capital of the company, means he is holding less than or equal to 0.5% of the share capital in the company, he is not even related to the promoters or directors of the company, and he is having some expert knowledge, and that's the reason we have kept this person in the company even during losses. Then also to such people, you can pay the remuneration as above. The limits that we have studied here, you can pay them the remuneration as above. You can pay even more than the limits. You can pay this much or you can pay more than the limits, but in either of the cases, you will have to pass a SR. Okay, even though you are paying them within the limits, then also you are required to pass a SR. That is given here in the conclusion table which I have written. Now, whenever you're paying them any amount, basically whenever you're paying any remuneration in case of inadequate profits or in case of losses, etc., first of all, the NRC or the board will have to approve the payment, and next, there should be no default with the outsiders. Okay, there should be no default with the outsiders, and if there is any default, then just take a prior approval before you pass the resolutions. These resolutions that can be passed, that is OR, SR, etc., this can be passed at a time for a period of 3 years. Means even for future we can pass a resolution and we can keep it. This was all about your section number 2. Now going on to section number 3. Section number 3 is going to have 3 main parts within it. The first part is a general part, that suppose if the company is paying any amount of remuneration, then if the company has passed the required resolutions, if the company is paying any amount of remuneration and if the company has passed the required resolutions, or if the company is a foreign company and it is approved by the payment, etc., is approved by the central government, then it will be deemed as if the remuneration has been paid within the limits as provided in the previous sections and there is no contravention there. Apart from that, there are 3 specific cases where in case of inadequate profits or in case of losses, you can pay whatever amount of remuneration you want to pay even without passing a special resolution. What are those 3 cases? First of all, if the company is a newly incorporated company, then for the first 7 years, pay whatever you want to pay. If the company is a sick company and its revival has been ordered by the BIFR, then for the first 5 years, during revival basically, after the order has been passed, for the first 5 years, pay any amount of remuneration. Or if the company had just undergone the CIRP and the NCLT has passed a resolution order, then for the first 5 years, it can pay any amount of remuneration without even passing a special resolution. And the last case is such that if the remuneration has been fixed, by the BIFR or NCLT in any other cases, then you can pay them whatever amount you want to pay. But in the last 2 clauses, that is in point B, that is these 3 points and the BIFR and the NCLT fixing the remuneration, in this case, you should not be receiving the managerial remuneration from any other company. Then only this benefit of not passing the SR will be available, plus the auditor or the CS will have to certify that there is no default done with any creditors or deposit holders and everything is being settled on time. Then going on to the next section, that is section number 4. Section number 4 simply says that managerial personnels can get something over and above the remuneration. Okay. 3 things that every managerial personnel can get over and above. One is any contributions to the employee funds like provident funds, superannuation funds, annuity funds, etc. Any gratuity that is payable, and the last one is the leave encashment. These are the 3 specific things which will be paid over and above to every managerial personnel, that will not be included in the limits. Then after that, to expand expatriate persons, three specific things can be paid over and above. First one is children education allowance, next one is holiday passage allowance, and the last one is leave travel concession other than India. These things can be paid to these managerial persons over and above. Okay, this can be paid over and above the remuneration. Now, how do we define remuneration? Remuneration means anything that is paid to the managerial personnel for the services that they have rendered, plus the perquisites as per the Income Tax Act, plus the reimbursement of direct taxes which is done by the company. These three things are included in the term called as remuneration. This has to be within the limits that we have studied till now. Now, a few important explanations which are coming up here is, first of all, the definition of effective capital. How do we calculate it for the purpose of the remuneration? So, effective capital is equal to paid up share capital, but excluding the share application money or the share advances, then the securities premium, then the reserves and surplus, excluding the revaluation reserve, then the long-term loans, but excluding the short-term ones, long-term loans and deposits repayable after 1 year, minus accumulated losses, minus preliminary expenses to the extent not written off, and minus investments. Okay, but not in case of an investment company. This way we are going to get the effective capital, and on the basis of effective capital we are going to calculate the remuneration that is payable. Okay, then after that, remuneration definition we have already covered. In remuneration, three things will be included: any amount paid for the services rendered, plus the perquisites as per Income Tax Act, and plus the reimbursement of direct taxes which is done by the company. These explanations are specifically important. Then going on to the last section of part 2 of schedule 5, which simply says that if there is a particular person who is withdrawing remuneration as a managerial personnel from two companies, then the total amount that I can draw from both the companies together should not exceed the highest remuneration which is eligible from either of the companies. That is the maximum total remuneration that I can withdraw from both the companies together. This was all about your part 2. Okay, in part 2 there were 5 sections. Section 1 was talking about that 11%. Section 2 was talking about inadequate profits, that 60 lakhs, 84 lakhs and all that. Section 3 was talking about the exceptions that where without passing SR we can pay whatever amount of remuneration we want to pay. Section 4 was extra things that can be paid to managerial personnel and expatriate managerial personnel. And section 5 was when we are drawing remuneration from two companies, managerial remuneration from two companies. Now going on to the last two parts, that is part 3 and part 4. Part 3 simply says that whenever we are talking about appointment and remuneration of these people, then first of all that should be subjected to the approval by the shareholders in the general meeting. And next thing is auditor or CS, whenever they are filing any returns with the ROC, they have to certify that yes, the company has complied with all the requirements of schedule number 5. This is mandatory. And the last one, that is part number 4. Part number 4 simply talks that if central government wants to provide any kind of exemption to a particular company or to a class of companies from any of the provisions of schedule 5, then central government has full rights and full powers to provide that. With this, we are totally done. With our schedule 5. So till here we are done with section number 196, section number 197 and everything about schedule 5. Going on to the next section, that is section number 198, whose reference we had already seen in section 197. In section number 198, we are going to calculate the profits for the purpose of calculating the remuneration. We'll start with the net profit as per the books of accounts. In that, we'll add all the revenue income should be included in that net profit. Plus, we'll even include the subsidies and the bounties which have been provided by the government of India. Okay, then there are certain profits which are to be excluded. Example, securities premium, profit on reissue of shares, capital profits will be excluded, super profits will be excluded in case of sale of fixed assets. Then all the allowable expenses will be deducted and all the capital nature of expenses will be disallowed, means those will have to be added back to the net profits. By doing this, we are going to get the net profit under section 198, which will be used for the purpose of calculating the remuneration under section number 197. Then after that, going on to the next 3 simple and small sections. That is, first one is section number 199. 199 talks about the cases when we have restated our financial statements. And in that case, if any excessive remuneration, if suppose any excessive remuneration has been paid to any of the managerial person, then we have got full rights to recover it from those people, even though they have left the company, be it past one, be it present one, we can recover it. Okay, but this is in case of restatement, not in case of mistake in the calculation. Then going on to section number 200, that whenever the company is having inadequate profits or in case of losses, the NRC or the board of the company will use certain bases, will see certain bases to determine the amount of remuneration. What are those bases? It will see the professional qualification, knowledge, experience, how much remuneration we are drawing, how much was the past remuneration that we were drawing, etc. Then at the same time, it will even check what is the financial position of the company. Are we capable enough of paying that much amount of remuneration? And then we will check how much amount of remuneration are we drawing from some other company, or how much amount of remuneration are we drawing in some other capacity, example doctor. On that basis, we are going to fix the remuneration in case of losses or in case of inadequate profits. Then after that, going on to the next section, that is section number 201. 201 ideally should be done after part 1 of schedule 5, that is wherever we are supposed to go and take the approval of the central government. So in those 4 cases, when we were going and taking the approval of the central government, in those 4 cases, there is a formality that we have to comply. That first of all, before you go and make an application to the central government in form number MR2, make sure that you first intimate your shareholders, you give a public notice in 2 newspapers, and then proof of all these things should be attached along with MR2, and then only go to the central government. So before basically you go and make an application to the central government, everyone else should be knowing that we are going and making such an application to the central government for appointing of such a person as a managerial person. This is the extra procedure that is applicable here. Going on to the next section, that is section number 202, which talks about compensation for loss of office of managerial personnel only. Okay, the thing on which I stressed upon, that is very, very important. Now, just try to understand, provision says that compensation for loss of office can be paid. Okay, it can be paid. If suppose there is a loss of office or if there is a retirement from the office, then compensation can be paid to the managerial personnel. No issues in that. But there are 6 such circumstances where the compensation will not be allowed. What are those? First of all, if there is a reconstruction in the company and MP has resigned from this company and he has got a similar position in the next company, then there is no loss of office. Or if, say for example, he himself voluntarily resigns, then it is not due to the mistake of the company. Then suppose if his office is vacated under section 167, which we will study in the directors chapter. Or if, say for example, winding up has happened because of his mistake, or if he was himself involved in his own termination of office, or if he was found guilty of fraud, misconduct, etc., a breach of trust in this company or in its holding company or subsidiary company. In these cases, either there is no loss of office or the loss of office has happened because of his own mistake, then obviously no compensation would be payable. In all the other cases, compensation can be paid. How much is the maximum compensation that you can pay is, first of all, let's decide the tenure for which you will pay the compensation. So it is the remaining tenure or 3 years, whichever is shorter. Okay, for this much tenure you can pay. And on what basis will you pay? You will pay on the basis of average remuneration that person has drawn in the last 3 years or any shorter period if he was there in the company for a shorter period. This is the maximum compensation that can be paid. But suppose if as soon as he left the company, within 12 months, the winding up started. Okay, and if winding up started and now if the company is having insufficient money in the company, then in that case, we can waive off his dues, means we need not pay him the dues that he was eligible as compensation, but you can waive off only his dues, you cannot waive off any other amount that was payable to him. Okay, similarly, if that person was found guilty, or if that reconstruction etc. happened, okay, you can decide whether to pay the compensation or not. But this point is not applicable to other payments. Whatever was his remuneration, whatever was his statutory dues, that he will still be eligible to receive. Then, if there is any allegation on the managerial personnel, he is still eligible to receive the compensation. Okay, because still now he is not convicted. Acha, now suppose on the basis of allegation you paid, that person was, he resigned from the company or he went out of the company or whatever, and now later he is proved guilty. then in that case, that compensation cannot be recovered back from him. Okay, this was decided in Bell versus Lever Brothers case law. And when it comes to compensation, for loss of office, before paying the compensation for loss of office, make sure that there is no default done with the outsiders, any kind of outsiders, banks, PFI, creditors, government taxes, declared dividends, etc. There should be no default in that respect. Then only you can pay the compensation. Till that time you cannot pay any compensation for loss of office. This was covered in section number 202. Going on to the next section, that is section number 203, which talks about appointment of KMP. KMP includes three category of person. First one, managerial personnel, that is MD or manager, or in their absence, a whole-time director, and CS, that is company secretary, and a CFO. These people together come in the term called as KMP, and some companies are required to mandatorily have whole-time KMPs in the company. Okay, which are those companies which should have mandatory KMPs? So every listed company should be having. Every other public company whose paid up share capital is more than or equal to 10 crores, that should be having. These companies should be having whole-time KMP. And when we simply talk about CS, then every private company whose paid up share capital is more than or equal to 10 crores, then that company should be having a CS in the company, right? Now, MD and chairperson cannot be the same person. Okay, but there are two exceptions. Suppose if the AOA says okay, then no problem. Or if the company is not carrying on multiple business, then also it is okay. But if a company is a big company, okay, if a company is a big company means if its paid up share capital is more than or equal to 100 crores and if its annual turnover is more than or equal to 1000 crores, then it becomes a big company. And if a big company is carrying on multiple business, and for every business, if we have appointed different MDs, then the same person, one of the MDs can act as the chairperson. This was given in two provisos, that is first and the second proviso. Acha, whenever we talk about appointment and remuneration of these KMPs, this will be done by the board of directors by passing a board resolution. Okay, and in that board resolution, everything about their appointment, everything about their terms and conditions, everything about their remuneration will be provided for in the board's resolution. Okay, now let's study a few restrictions. What are the restrictions? If there is a whole-time KMP, in the company, he cannot hold the office of a whole-time KMP in the other company. Except in its subsidiary company, and but if there is a person who is a whole-time KMP in one company, he can be appointed as an ordinary director in the other company with the permission of the board of the first company on hand. Then after that, similarly, whenever a company wants to appoint MD, a single person can be a MD or manager in maximum 2 companies, not more than that. Whenever this MD is appointed, again you have to pass a board resolution, and that too it has to be a super unanimous resolution. That is, all the directors who are present in that meeting should say yes. They should vote in favor of that person being appointed as a MD. And this has to be done in a meeting, and that's why resolution by circulation is not at all allowed. And whenever you're calling this board meeting, make sure that the notice has been given to all the directors who are present in India. Then after that, suppose if the office of KMP becomes vacated due to any of the reasons, then the board will have to fill that vacancy within a period of 6 months from the date of such vacancy. And the provisions that we studied about the managerial personnel, these were not applicable to the government companies. And if there is any contravention of the provisions, then this is the punishment that is applicable. Going to the last part, that is about company secretary. And secretarial audit, which is covered in 2 sections, that is section number 204 and section number 205. 204 talks about secretarial audit. 3 very, very important pointers here. There are certain companies which are required to get the secretarial audit done. Secretarial audit's report, the report which is prepared by the CS in practice, that is going to be in a form called as MR3. Okay, and then after that, if there is any non-compliance by any company or officer in charge or by the CS, they will be liable for a flat penalty of rupees 2 lakhs. Okay, now which companies are required to get the secretarial audit done? So every listed company, it is going to be always there in the league. and then every other company, okay, every other public company whose paid up share capital is more than or equal to 50 crores or whose turnover is more than or equal to 250 crore, or every other company, not public, every other company whose outstanding loans or borrowings from banks or PFI is more than or equal to 100 crore. As per these figures, everywhere the figures have to be checked as per the latest audited financial statements. If this condition gets fulfilled, then you have to compulsorily get the secretarial audit done. Whenever they are coming for the secretarial audit, we have to provide all the necessary assistance and the facilities to conduct this particular audit, and this report will be attached to the board's report. And if there is any qualification or observation which has been put up by the CS, then the board will have to compulsorily put a comment on it. This was all about your section number 204, and now going to the last section, that is section number 205, which is a very general section which talks about functions of the company secretary. Now the company secretary's responsibility will be to ensure compliance, to do the reportings to the board and to other regulatory authorities, to conduct meetings, to call for meetings, to maintain the minutes, to provide the agenda for the meeting, to assist the board in compliances of all the regulatory requirements, to take the necessary approvals from the required authorities, SEBI, ROC, any other regulatory authority from whom we are supposed to take the approval, then that has to be done by the CS on behalf of the company. Then to advise the board regarding the compliances, to ensure that it follows the secretarial standards as set up by the or as issued by the ICSI, Institute of Company Secretaries of India, and which are approved by the central government. And suppose if the CS fails to perform its activities, then it's not that the company or the board or the chairperson or the directors etc. are relieved from the liability. No, they are not relieved. Their duties, their functions, their powers will remain unaffected. This was all about the appointment and remuneration of managerial personnel. I hope you are very, very clear with this. Okay, so let's start with the super quick revision of directors chapter, that is appointment and qualification of directors. Chapter ranges from section number 149 to section number 172. First of all, they have given you certain basic definitions of director. Director is any person who is appointed to the board of directors of the company. Then on various basis, we can do the classification of the types of directors. It can be executive directors, it can be non-executive directors. Executive directors are the one who are into the employment of the company, full-time involved in the management of the company, etc. Non-executive directors are the ones who are not in the employment of the company, just like your nominee directors, just like your independent directors. Then after that, going on to the most important section and the most lengthiest section of the chapter, that is section number 149, where we are going to discuss about many types of directors and related provisions of directors. Now, in any particular board of directors, you are going to have the directors sitting there. These directors would be individual persons. Directors in a particular company, there can be certain number of minimum directors, there can be certain number of maximum directors. A company can have maximum, any type of company can have maximum 15 directors in the company. In case of minimum directors, a public company can have minimum 3 directors, a private company should have minimum 2 directors, and a OPC should have minimum 1 director. This is the minimum and the maximum number of directors that should be there in a particular company. If any company wants to go more than like above 15 number of directors, then in that case the company will have to pass a special resolution and it can appoint directors more than 15 also. But in case of a section 8 company and in case of a government company, if these companies are non-defaulting, then even if it wants to go beyond 15, then in that case a special resolution will not be required. Then after that, going on to the next type of director, that is woman director. There are certain prescribed companies. There are certain prescribed companies in which we are mandatorily supposed to appoint at least one woman director in the company. Which are those companies? First of all, every listed company should be having one woman director, and then every other public company, that is unlisted public company, whose paid up share capital is more than or equal to 100 crore or whose turnover is more than or equal to 300 crore as per the latest audited financial statements. this company should be having a woman director, at least one woman director in its board of directors. And suppose if there is any vacancy that arises in the place of woman director, then that will be filled by the board of directors either before the next board meeting or within 3 months from the date of vacancy, whichever is later. Within this time, the vacancy in case of woman director should be filled. Then going on to the next type of director, that is your resident director. Every company, not only the prescribed companies, every company should be having at least one resident director. How do we define a resident director? A director who is staying in India in that current financial year for a total period of at least 182 days. It can be any director, but at the end of the year, at least there should have been one director in your company who has stayed in India for a period of at least 182 days in that particular financial year. But suppose if the company has been incorporated somewhere during the year, then in that case, while calculating this number of days, we are going to do it pro rata. Okay, example, if the company has been incorporated during half of the year, then in that case, like it got incorporated on 1st of October, then in that case, that person should be staying in India for a period of at least 91 days, that is half of 182 days. Then that particular director will be treated as a resident director. Then going on to the next type of director, which is very, very important, that is your independent director. Independent director is going to go from mainly 149.4 to 149.12. It is going to go till there. Now, there are certain companies which are required to appoint an independent director. Let's see which are those companies. First of all, every listed public company. Okay, every listed public company should be having some number of independent directors, and then some other companies which are mentioned in rule 4 of these director rules. That is your unlisted public company whose paid up share capital is more than or equal to 10 crore or whose turnover is more than or equal to 100 crore or whose total loans, outstanding deposits, debentures, etc. Is more than rupees 50 crore. If any of these three conditions get fulfilled in case of unlisted public company, then in that case, that company is required to have an independent director. Now, how many number of independent directors are required? In case of listed public company, you should be having at least 1/3 of the total number of directors should be independent directors. If you get any fraction there, then we'll always round it off to the higher side. Suppose if we talk about the unlisted public companies, then in that case, in such companies, at least 2 independent directors should be there in the company. So this way, this required number of companies or the specified companies are required to have the specified number of independent directors. Okay, now in case of unlisted public company, 3 companies will always be excluded even though they fulfill these limits of 10 crore, 100 crore and 50 crore. Okay, which are these 3 companies? A joint venture, a dormant company and a wholly owned subsidiary. These companies are totally excluded from there. Now, if suppose there is a vacancy in the place of independent director, it is going to be filled just like we filled the vacancy of a woman director. That is, it will be filled by the board of directors before the next board meeting or within 3 months from the date of vacancy, whichever is later. Suppose if any time there is a clash in appointing the number of directors between section number 149(4) and between section number 177, that is your audit committee. Suppose if independent director section require that you should appoint at least 2 independent directors, and 149(4) says that 177 says that you are required to appoint, say for example, 4 independent directors. Then in that case, we will have to appoint a higher number of independent directors. That is section number 177 can override section number 149(4). Okay. Now, suppose if there is any particular unlisted public company, which is not fulfilling any of these conditions for 3 consecutive years, it has not fulfilled any of these conditions, then in that case, from the next year, it can stop appointing independent directors in its company till the time it next meets the requirements of this particular section. Then going on to the next section, that is section number 149(6). 149(6) can be just read once, which talks about qualifications of the independent directors. There are going to be in all 6 pointers in this particular qualifications. First of all, independent director cannot be a MD, or he cannot be the WTD, or he cannot be the nominee director. It has to be some person other than these people. First point is a very general point, that he should be having the necessary expertise, experience, and he should be a person of integrity, that is ethical person, etc. Then next point is this person should not be the current promoter or the ex-promoter of this particular company or its group company, or he should not even be related to the promoters or the directors of this particular company or its group company. Okay, just to ensure the independence. Then after that, the third point is this person should not be having any pecuniary relationship. This person should not be having any pecuniary financial relationship with a company or its group company or their directors or their promoters during the last 2 years or during the current year. But two transactions are allowed. One is remuneration payable to this particular director is going to be allowed, and next one, any other transaction up to 10% of the total income of such independent director, this transaction is going to be allowed. So these are the two things which are specifically allowed in case of pecuniary relationship between the independent director and between the company. Then the fourth point was putting a restriction that if I am going to be appointed as an independent director, it puts a restriction on my relatives. My relative should not be holding any securities or interest in this particular company or its group company during the last 2 years or during the current year. But they have given one exception that he can hold maximum up to shares up to face value of rupees 50 lakhs or 2% of the paid up share capital of the company or its group company. It can hold up to this. Then my relative should not be indebted to the company or its group company or to their directors or to their promoters for 50 lakhs or more. Even 50 lakhs is not allowed there. Then my relative should not have given guarantee to this particular company in respect of debt of any third person. It should not have given guarantee to the company, to its group company, to their promoters, to their directors, again of 50 lakhs or more during the last 2 years or during the current year. And the last one is it should not be having any other transaction either singly or in totality with the above three transactions amounting to with the company or its group company of 2% or more of the gross turnover or 2% or more of the total income of the company. This is a restriction which has been put on my relative. If my relative violates this condition, then in that case, I will not be eligible to be appointed as an independent director. Then the fifth point is the restriction is there on me also as well as on my relative also. First of all, we should not have held the position of KMP or we should not have held the position of the employee in this company or in its group company in the last 3 years or in the current year, we can interpret it that way. But they have put an exception here. My relative, if he was an employee during the last 3 years, then in that case, I can be appointed as an independent director. That was put up by way of a proviso. Then similarly, we, that is me and my relative, should not be an employee, proprietor or partner in the last 3 years of any CA firm, CS firm or any cost auditor firm of the company or its group company. Plus, we should also not be the employee, proprietor, partner of any legal consulting firm of the company or its group company if the transaction between the company and the legal consulting firm is more than or equal to 10% of the gross turnover of the firm. Then the next point, me plus my relative can hold voting power in this company, but that should not touch 2%, means it should be less than 2% of the total voting power of the company. That is my voting power plus my relative's voting power. And the last one, me or my relative, if we are the chief executive officer or director of any NPO. Which NPO? Any such NPO which receives majority of its funding, that is at least 25% of its total receipts are received from this company or its group company or its promoters or directors. Then in that case, I cannot be appointed as an independent director in such company which is funding the NPO, or we are a CEO or director of such a NPO which holds at least 2% of the voting power in the company. Then in that case, I cannot be appointed as an independent director in such company in which the NPO is also interested or to whom the NPO is also related. And the last point was that independent director should be possessing the required qualification, skills, whatever is required as per the company's nature of business. This was given in section 149 subsection 6, which was talking about qualifications of an independent director, and we have to make sure that these qualifications are met there. then every time an independent director is supposed to give a declaration. Okay, every time an independent director is supposed to give a declaration, he has to give a declaration at the first board meeting of the company, which he is attending as a director. Then every year's first board meeting, he has to give a declaration. And then whenever there is any change in situation, at that time he'll have to give a declaration that yes, he still fulfills the requirements of section number 149 subsection 6. Then after that, more pointers about independent directors, that is his disqualification, his functions, his duties, his remuneration, etc. Those are given in schedule number 4. Just like in managerial remuneration chapter, we did schedule number 5. So here it is given in schedule number 4. But anyway, we do not have the detailed contents of schedule number 4 given there. Then after that, going on to section number 149.9, which is important again, which talks about remuneration of an independent director. Independent director's remuneration, ESOP is specifically not allowed in form of remuneration. Apart from that, he is eligible for remuneration, he is eligible for sitting fees, he is eligible for reimbursement of certain expenses that he has incurred on behalf of the company. Right? And suppose if the company is suffering any amount of losses, then also independent directors can withdraw some amount of remuneration. This we had studied in managerial remuneration chapter, schedule number 5. Then whenever an independent director is appointed, his term can be of maximum 2 terms, which can go up to 5 years each. So one term of 5 years each first, then after that he can be reappointed by passing a special resolution. When he is getting reappointed, at that time also he can be reappointed for one term of maximum up to a period of 5 years. So maximum he can serve for a period of 2 terms. After his 2 terms are completed of maximum 10 years total, then in that case, after that he has to serve a cooling period of 3 years. During this cooling period of 3 years, he cannot be associated either directly or indirectly with the company at all. Right? Then after that, when we talk about the liability of the independent director, an independent director, or for that matter any other non-executive director also, even they will be liable if we have found out that they have done any such acts in the company, if there is some act of commission or if there is some act of omission which is done in the company, which is specifically attributable to that independent director. That is, we are able to see that this mistake has happened because of that particular independent director or any other non-executive director, then yes, such independent director is going to be liable for such things. Okay, then one very important thing is independent directors are not liable for retirement by rotation. Okay, because their tenure is anyway specifically given by the provisions of section number 149. So retirement by rotation provisions, which we will study in section number 152 subsection 6, those are not applicable to an independent director at all. Okay, another thing is Section 8 company, very important exception. Independent directors clauses or independent director provisions are not at all applicable to a Section 8 company, provided there is no default of section number 92 or section number 137. Okay, then after that, this was all about your section number 149. Now going on to section number 150, in which we are going to do section number 150 and rule number 6. Rule number 6 is corresponding to the section number 150, which can be read once. Now in section number 150, we are going to maintain a data bank. Okay, we are going to maintain a data bank of independent directors. The central government is going to establish this facility called as maintenance of data bank of independent directors, from which the company can select their persons. So the data bank is maintained by a particular institute under the Ministry of Corporate Affairs, that is the central government. The name, their eligibility, their past experiences, qualifications, etc. everything will be written in this particular data bank, and this will be made available to the companies. If they want to choose one, they can definitely choose one from there. But exercising due diligence while choosing an independent director, that lies with the company itself. That is basically, if the independent director is not a good person, then for that matter we cannot blame the central government that we chose this person from your data bank. Okay, now once you choose this person from the data bank, after that, that person has to be appointed in the general meeting. For general meeting, we'll have to give the notice. Along with that notice, we'll give an explanatory statement for our shareholders that why have we chosen this particular person. Okay, so every detail about that independent director will be given to the members, and then so that it becomes simple for the members to appoint the independent directors in the general meeting. Okay, more pointers about this data bank. Okay, more pointers about this data bank are given in the rules, and CG can at any point of time prescribe the procedure that how are we supposed to, include the name in the data bank, how are we supposed to choose the person from the data bank. For that, the central government will prescribe the rules from time to time. Then after that, going on to rule number 6. Rule number 6 was just talking about the extra points about the data bank. So any person who is willing to get appointed as an independent director, that person will have to first apply to an institute. That person will first apply to an institute that please include my name in the data bank. That can be either for a period of 1 year, or that can be for a period of 5 years, or that can be for lifetime, depending upon the fees that you are paying. The fees have been already prescribed for that. If you want to put your name, get your name, entered in this particular data bank, then in that case you can go and make an application to this particular institute, and your name will be put up in the data bank. Okay, now once your name has been put up in the data bank, then after that, after a period of 1 year or after a period of 5 years, then in that case, whenever the period expires, you can make an application to that particular institute for the purpose of renewal. Okay, and if you do not apply for a renewal once your this thing has expired, once the tenure has expired, then in that case the name will be removed from the data bank, and then again you'll have to go and make the exercise of including the name in the data bank there. Okay, then whenever any particular person was giving a declaration, that independent director was giving a declaration, remember 3 times, his first board meeting, every year's first board meeting, etc. He was giving a declaration that he is fulfilling all the requirements of 149 subsection 6. At the same time, he will also give a declaration that his name has been included in the data bank, his name has been put up in the data bank, and the name, putting the name in the data bank is still valid. That is, that period has not yet expired. So that declaration also we are going to give, that our name is included in the data bank. Then once your name gets included in the data bank, then after that you can just clear the examinations by giving that online self-assessment test, that is the examinations of independent director, within a period of 2 years. That is, once your name has been put up in the data bank, after that within a period of 2 years you can give that particular examination and clear the examination. Obviously, if you say for example do not give this examination within a period of 2 years, then in that case your name gets removed from the data bank. But if there are certain experienced persons sitting, okay, or if there are certain experienced person who have served a period of 3 years, in some specific companies, it can be some listed company, it can be some big companies, it can be in some government organizations, etc., then in that case they need not pass the online examinations which have been conducted by the this particular institute. Then in that case their name will still remain in the data bank. Okay, then after that, again similarly, there was a proviso which was inserted there. That whenever you are checking this experience for a period of 3 years, that is, he has worked for a period of 3 years, then in that case his experience of 3 years will be counted, and not his experience in multiple companies together. Now, say for example, if I am working for 3 years simultaneously as a KMP, say for example in 2 companies, then that will not be counted as 6 years experience. That will be counted as 3 years experience only. This was the new proviso that was inserted there. And this data bank provision again is not applicable to section 8 companies. Reason being, we had already studied in section number 149 that 149 was not applicable to section 8 company, that is about independent directors, if there is no default of section number 92 or section number 137. This was all about your section number 150. Then going on to the next section, that is section number 151, super duper important section, which talks about the small shareholder directors. Now, every listed company only, they may have one director called as small shareholder director in their company to basically be a representative of the small shareholders in the company. Okay, now what do you mean by the term small shareholders? Small shareholders is such a person whose nominal value, who is having shares whose nominal value does not exceed rupees 20,000. Face value does not exceed rupees 20,000. So to represent such small shareholders, we are going to have one director called as small shareholder director. Okay. Now, any person who is, if we decide that If the company suo motu decides that you should be having a small shareholder director, then in that case, company can appoint. Or if some number of small shareholders can go and make an application to the company that we wish to get the small shareholder appointed, then in that case, the company may appoint a SSD. Okay, now how many of them should be going and making an application? At least 1,000 small shareholders, or 1/10 of the total number of small shareholders, whichever is lower. At least these many of them should go and make an application to the company at least 14 days before the general meeting, that we wish to appoint so and so person as a small shareholder director. We are going to submit his details. If at all is holding some shares in the company, we'll submit that details, his qualifications, his consent, everything will be submitted to the company at least 14 days before the meeting. Then he'll have to give his consent, that is mandatory for getting appointed as a director, plus we'll have to also submit his DIN because that is the basic requirement of getting a person appointed as a director. Okay, then one very important thing is this SSD is deemed to be an independent director. That is, he will have to fulfill the requirements of section 149(6) as well as section number 149(7). 149(6) was talking about qualifications of the independent director, and 149(7) was talking about the declaration that he has to keep on giving in every year's first board meeting, in his first board meeting, and all those things. Okay, now even this small shareholder director, since he is an independent director, even he will not be liable to retire by rotation. Okay, even he will not be liable to retire by rotation. Then this particular person can be appointed for one term, only for one term, that too for a maximum period of 3 years. After that, there is no reappointment that is possible. He will have to serve a cooling period of 3 years if you want to come back again in the company. And another thing is, this person, even this small shareholder director, he will have to vacate his office if suppose any of the disqualifications is attracted under 164, or if his office becomes vacated under section 167, or suppose if he ceases to be an independent director, that is 149(6) criteria ceases to get fulfilled, then in that case he will have to vacate his office of the small shareholder director. And a person can act as a small shareholder director in maximum 2 companies at a single point of time, but provided these two companies should not be in any conflicting interest or any competing business. They should not be in that at all. This was all about your section number 151. Going on to the next section, that is section 152. Again, very important section. 152 talks about various things, that is about appointment of directors, retirement of rotation by directors, reappointment of such directors, and all those things. When we talk about first directors, who will be the first directors of the company? If the AOA specifies the method, if any particular method is given in the AOA, then as per that particular method, the first directors of the company will be appointed. If the AOA does not specify any method, then in that case, first directors of the company would be the subscribers to the MOA, and then subsequent directors will be appointed in the general meeting of the company. In case of one person company, if AOA is totally silent about it, then in that case, that single member would be the first director of the company. And just like I told you, subsequent directors will be appointed by the company in the general meeting, just like the AOA has provided, or just like the law provides. If any particular person has to be appointed as a director, he should be having a DIN with him, because now the DIN provisions are mandatory. So before you get appointed as a director, either DIN or any other number which is the central government may prescribe, you should be having that number, and that person should even furnish his DIN to the company before he gets appointed. Otherwise, he becomes disqualified to be appointed as a director. Right? Whenever a person is going to get appointed as a director, giving his consent is mandatory. That yes, at least he is willing to get appointed as your company's director. He gives his consent to the company, and the company files a consent with the ROC within 30 days of his appointment. So he will have to give his consent to the company in form number DIR 2 till maximum till the date of his appointment, and then the company is going to file this consent in DIR 12 form with the ROC within a period of 30 days of his appointment. Right? This way a particular director is appointed. Then after that, going on to the last 2 subsections of section number 152 subsection 6, which talks about retirement by rotation. Okay, now as we had already seen that independent directors and small shareholder directors in 149(4) and in 151, we had seen that independent directors and small shareholder directors, these are not at all liable to retire by rotation. Okay, now apart from that, suppose if the AOA is totally silent, okay, if the AOA is totally silent, then in that case, whatever are your total number of directors, from that we will subtract the independent directors, we'll subtract the small shareholder directors, will subtract certain nominee directors who are regulated by certain act of parliament, etc. Will remove those nominee directors. Now whatever number of directors are left with you, will do 2/3 and and the balancing figure. While doing 2/3, if you get any fraction, then we'll always round it off to the higher side. These 2/3 are those directors who are liable to retire by rotation. Rest, balance one, are not at all liable to retire by rotation. Then out of this 2/3, we are going to take 1/3. Okay, out of this 2/3, we are going to take 1/3. These 1/3 would be those directors who are actually going to retire from the company. Okay, and these 1/3 would be the directors who have been longest in the office. Okay, those directors will be removed. And suppose if you have all the directors who are longest in the office, they were appointed on the same day, then in that case, first we will try to remove them, we'll try to give them the option to decide this mutually. If that is not possible, then in that case, we will draw lots, and by that way, we are going to select the directors who are going to retire by rotation. Okay, then after that, if we talk about certain additional directors that we are going to study in section number 161, these are the directors who are appointed by the board of directors, and they are non-rotational directors because their tenure is fixed till the general meeting. So they will come in that balancing part, that is balancing of the 2/3 part, they will come in that. They are included in the total number of directors, don't forget that. Okay, they are included in the total number of directors, but they come here in the balancing side. Acha, when you did that 2/3, if you get any fractions, then in that case, that will be rounded off to the higher side. If you do 1/3, the next step, that is 1/3 that you do, in that case, if you get any fraction, then you'll have to round it off to the nearest number. This is how retirement by rotation takes place in case nothing was given in the AOA. Okay, or if suppose AOA provides that all the directors are liable to retire by rotation, then whatever are the total number of directors minus the eligible directors, we will directly do its 1/3. Okay, we will directly do its 1/3, and those are the number of directors who will be liable to retire by rotation in case the AOA provides that all the directors are liable to retire by rotation. Okay, now whenever some directors go out from the company, like when some directors were retired by way of rotation under section 152(6), then there is a vacancy that is arisen in that particular place. So we will try to fill the vacancy in that particular meeting itself. Okay, if it is not possible, and we have not decided that we don't want to fill the vacancy, then you adjourn the meeting. In the adjourned meeting also, you try to fill this vacancy. If it is not possible to fill the vacancy by bringing a new person in the company, and still if you want to fill the vacancy, then in that case, the directors who just now retired by way of rotation, those directors can be reappointed in the company, provided he has not expressed his unwillingness, provided he is not disqualified for a reappointment, provided that a resolution was passed for it, but say for example, we could not get the required voting on that particular resolution, that is, the resolution was lost, then in that case, he cannot be reappointed. Or if, say for example, section number 162 has become applicable to this case, means you are appointing many directors by way of a single resolution. Then in that case, that becomes a void appointment at all. If any of these pointers get attracted, that is the unwillingness, resolution got lost, then in that case, that same person cannot be reappointed. Otherwise, we can appoint the retiring director in the place of the we can appoint the new director in the place of the retiring director. Now similarly, just try to understand section number 152(6) and 152(7), that is about this retirement by rotation of directors and their retirement and vacancy in the place of this retiring director. This provision is not applicable to an unlisted company where at least 51%, unlisted government company where at least 51% is held by the government and a subsidiary of such government company. To them, the provision of rotation of retirement of directors is not at all applicable. That is one of the important exceptions which is coming up there. This was all about your section number 152, which was talking about first directors, which was talking about subsequent directors, which was talking about DIN provisions, and which was talking about retirement by rotation of any particular directors. Then going on to the next section, that is directly jumping after the DIN provisions, directly jumping to section number 160. 160 is a very simple and a very important section which talks about bringing a new face in the company, that is to appointing a new person in the directorship of the company to stand for the position of directorship of the company other than the retiring director, not the one who just went out of the company. We are talking about the new face who is coming here in the company. So if a new person wants to get appointed as a director in the company, then a notice about this should be left in the company at least 14 days before the general meeting that we wish to get appointed as a director in your company, along with the deposit of rupees 1 lakh. Okay, along with a deposit of rupees 1 lakh, which can be reduced to 10,000 in case of Nidhi companies. You have to submit this in the company so that your matter can be considered in the general meeting, and then it will be decided whether you will be appointed as a director or no. Okay, now what about this 1 lakh rupees? Is it a refundable deposit or a non-refundable deposit? So suppose if you win, okay, suppose if you get appointed as a director, then in that case you get your money back. Suppose if you lose and you lose badly, that is you couldn't even get 25%, you couldn't even get 25%, up to 25% of the votes also, then in that case the entire amount will be forfeited. Okay, and suppose if you have lost, means you did not get the position of director, but the votes casted, you have got at least more than 25% of the valid votes which have been casted, means you lost but you did not lose it very badly. Then in that case that person can be appointed, that person will not be appointed as a director in such case, but at least he will be eligible to get his refund back. Okay, and in case of appointment of independent directors, and in case where your name was recommended by the NRC, then in that case deposit requirement is not at all applicable. See, because for independent directors anyway you have been fulfilling so many qualifications and you have come up here, and in case of recommendation by the NRC, already an insider person knows about you and he is recommending your name. So in that case also the deposit is not going to be required at all. Then once all these things are done, we have left the notice with the company at least 14 days before the general meeting. Then the company is going to intimate to its members that we have received candidature of so and so person and we are planning to get this person appointed as a director of the company. Either you serve individual notices on the members of the company by electronic mode or by physical mode, whatever, and you'll have to place it on the website of the company. If you don't want to give individual notices to the shareholders, then simply you can give the notice in 2 newspapers, one English and one that regional language newspaper. You can give the notice that you are planning to appoint so and so person as the director of the company. Right? Then in case of, one very important point is, in case of section 8 company, if suppose you lose badly, if you lose badly, then in that case in ordinary companies that 1 lakh rupees was getting forfeited. Right, but in case of section 8 company, they are telling that let the section 8 company only decide whether it wants to keep that amount with itself or it wants to refund this amount back to that particular candidate if that person has lost badly. Right, this was about section number 160. Now going on to the next section, that is section number 161. 161 is containing 4 subsections in that which are very, very important. Subsection 1 to subsection number 4. 161.1 talks about additional director. The Articles of Association may give the powers to the board of directors to appoint any person as an additional director in the company. This additional director comes for a temporary period actually. Whenever he is appointed, his tenure is going to be till the next general meeting. Okay, he is appointed by the board. Remember that he is appointed by the board. His tenure is going to be till the next general meeting or the last day when the AGM should have been held, whichever is earlier. Means even if we are not able to hold the AGM, then in that case he cannot continue his office. He'll have to leave his office on the last day when the AGM should have been held. This person is a non-rotational director. Remember, he was coming in that balancing part. So he is not even liable to get retired by way of rotation. If this additional director wants to come back in the company, like his tenure has got over, he cannot be reappointed in the company. His tenure has got over altogether. If he wants to come as a director in the company, he may apply as per the provisions of section number 160 and then this person can become a normal director in our company. That is the provision which is applicable for an additional director. Then going on to the next portion, that is your alternate director. In case of alternate director, In case of alternate director, whenever again the powers is conferred on the board of directors of the company, it can appoint a director called as alternate director if the original director has gone outside India for a period of more than or equal to 3 months. Then in that case we can appoint some person as an alternate director in place of the original director. If suppose we are appointing an independent director's alternative, then even the alternative director should fulfill the requirements of 149 subsection 6. If we are appointing someone in the place of a sole woman director, then even such a replacement should be a woman director to fulfill the requirements of the law. This alternate director has all the rights to do the voting on behalf of the original director, etc. Suppose if it is such a meeting, where the original director can participate, then in that case, and if he can vote, then in that case the original director can attend it by way of that audio visual conferencing mode, etc., and he can attend the meeting. And suppose if the original director is not able to do, then in that case the alternate director can easily do so. Then going on to the next section, that is 161 subsection 3, which talks about your nominee director. In case of nominee director, the powers will be conferred in the AOA of the company. The board may appoint any particular person to represent someone else's interest. Okay, it can be LIC's interest, it can be government's interest, it can be any bank's interest. For that purpose, we can appoint a person called as nominee director in the company. Okay, then after that, going on to the next section, that is section number 161 subsection 4, which talks about casual vacancy. Suppose if the place of a director gets vacated before his tenure could get over, then that leads to casual vacancy. Casual vacancy will be filled as per the AOA if AOA specifies. If AOA does not specify anything about that, then in that case this particular casual vacancy will be filled by the board of directors in the board meeting, and then it will be ratified subsequently by the shareholders in the immediate next general meeting. Now, casual vacancy can be filled in place of only those directors whose appointment was done by the company in the general meeting. So, if there were any directors who were appointed by the board of directors, then in that case, that vacancy cannot be filled by the virtue of section number 161(4). So, that person should be appointed in the general meeting. His tenure has got over before the decided date, then that vacancy can be filled by the board. So now if you filled the vacancy, can I say filling of vacancy is done by the board of directors only? Now in place of the second director, suppose if there is again a casual vacancy which has arisen, then in that case you cannot fill it as per section 161(4), because now the appointment was done by the board of directors of the company. Again, it is not mandatory to fill the casual vacancy. If the company wants to have new directors, or if the company wants to have more directors, then only it will fill the casual vacancy. Otherwise, the place can remain vacated as well. Okay. Another thing, suppose if whenever the board is filling the casual vacancy, the new person who is coming and filling the vacancy, his tenure will be till the original tenure of the initial director. Till whatever time the original director was going to work, till that time this casual vacancy director is going to work in the company. And now after that he'll have to leave his company. And suppose if he wants to come back in the company, then he can come as per the provisions of section number 160, that is as if a new face is coming in the company. This was all about your section number 161. Then going on to the next section, that is section number 162, which is which was important because here we studied a specific point about unanimous resolution. First of all, they say that all the directors should be appointed by separate resolutions. Okay, whenever in the general meeting any directors are appointed, everyone should be appointed by separate resolutions. And suppose if you want to appoint everyone by way of a single resolution, then that should be agreed beforehand. Okay, that should be agreed beforehand. And in that case, whenever a voting is done on this particular matter, then no votes must be cast against such a resolution. If someone wants to abstain from voting, they can abstain from voting, but no one should be saying no for this particular proposal of appointing multiple directors by way of a single resolution. If this gets met, that is, if no one is voting in against to this particular resolution, then it will be assumed that the proper voting has been done, and now all the directors can be appointed by way of a single resolution. Then after that, going on to section number 163, where once in every 3 years, our company may appoint some directors by way of the concept of proportional representation. That is, you give weightage to the minority shareholders. You give weightage to the head count of the minority shareholders and you appoint those number of directors. Otherwise, generally the directors are appointed by the shareholders in the general meeting by way of for a resolution, etc. That is, we give the weightage to the share capital, that is to the shareholders who are holding a proper amount of share capital. But here in this particular case, one of the examples is the directors can be appointed by the head count of the minority shareholding. So here the interest of the minority shareholding, or shareholders get reflected, and the section is not applicable to a government company. For to them, this particular proposal is not applicable. This type of appointment can be done once in every 3 years, and out of the total number of directors, at least 2/3 of the directors can be appointed by this method. This was all about your section number 163. Then going on to section number 165 first, we'll do disqualification and vacation together. Going on to section number 165, which talks about number of directorship. That is, a particular director can be a director in how many companies? So he can be a director in a maximum 20 companies at any given point of time. Out of that, 10 public companies is the maximum limit. Okay, out of that, 10 public companies is the maximum limit. Private can be any number, but public can be 10 only. While calculating this 20 companies, then in that case, dormant company, section 8 company and foreign company will be totally excluded. That is, we can be director in such companies over and above. Also, along with that, if some company wants to put a restriction on its directors that you cannot be a director in 20 companies, you can be a director in maximum 15 companies, means the company is putting a restriction on that directors. So they say that yes, this is allowed. Okay, the companies can put restriction on the directors that you can be a maximum director in so and so number of companies. And here in this particular section, in section number 165, the amount of penalty is very, very important. That is 2,000 rupees per day after the contravention happens, which can go up to a maximum of rupees 2 lakhs. Okay, 2,000 per day, which can go up to a maximum of 2 lakhs. Then going on to the next section, which talks about duties of the director, which is a very general section. What are the duties of the director? To act as per the AOA, to act in good faith, to see all the compliances, to exercise due diligence, not to involve in any conflicting situation, not to gain any, not to earn any wrongful gains from the company, not to assign his office to someone else. These are the basic duties of a director which is there. Then after that, going on to section number 168 and section number 169. 168 talks about resignation of the director and 169 talks about removal of the directors. In case of resignation, a director can give he'll have to leave a resignation notice with the company. The board will take the receipt of the same. The board cannot reject you. It cannot say that no, you cannot go and apply for this resignation, etc. No, that is not possible. And then the company, we will go and intimate it to the company that we want to resign from so and so day. Either we will write the date in the notice that we are going to resign from so and so date, or the day on which the company, if we have not written such date, then in that case, the date when the company receives my resignation notice, that will be the date of my effective resignation. You can also, the director may also go and forward a copy of resignation to the ROC within 30 days. That will be in form number DIR 11. And the company will go and file it with the ROC in the same form, that is DIR 12, within a period of 30 days. Right? And this way, the resignation of the director can be accepted. Resignation will be effective either from the date which was written in the notice or the day when the company received the notice of this resignation. Either of these dates, whichever is later. Right? Suppose if all the directors resign, then in that case, the promoters will step in between. If the promoters are also not available in the company, then in that case, the CG will interfere and the CG will appoint the required number of directors in the company for its efficient working. Then after that, going on to the next section, that is section number 169. 169 talks about removal of the directors. Now, the director can be removed for any XYZ purpose. It's not necessary that somewhere a fraud, etc. should have happened, but we can even simply remove a director, but only after giving reasonable opportunity of being heard. So, a director can be removed. By passing an ordinary resolution. But for passing an ordinary resolution, can I say we'll have to call the general meeting? If we want to call the general meeting, then in that case we'll have to give the notice for that meeting. Along with the notice, we have to give this particular notice will be called as a special notice, okay, in which you are going to remove a particular director and maybe you are going to appoint a new director in the place of this removed director. Okay, you cannot remove a director who was appointed by the tribunal under section 242 in case of oppression and mismanagement. Plus, you cannot remove a director who was appointed by the proportional representation method, that is by giving weightage to the minority shareholders. Those directors cannot be removed by way of an ordinary resolution. Similarly, when you are removing any independent director during his second tenure, then in that case, before removing this particular independent director, you will have to pass a special resolution. Okay, normally for other directors we required an ordinary resolution, but when an independent director is removed from a second tenure, then in that case we'll have to pass a special resolution there. We give the notice to the director, the company gives the notice to the director that we have proposed your removal, okay, that you are going to be removed. If you want to make any representations to the company, you can make the representation to the company as early as possible. If we receive his representation on time, we will circulate it to the members along with the notice. If that representation is received late, then in that case, we will say that we will read out this particular representation in the general meeting in which you are going to be removed. But suppose if in the general meeting we come to know that it contains some defamatory matter in this particular representation, then we can go and make an application to the tribunal, and the tribunal will say that no need to read it out and the game is over then and there itself. Okay, now if suppose in a particular general meeting some directors are removed, and if you had given a special notice of this thing, then in that case in the same meeting new director can be appointed in the company. Okay, now the new director who comes in the company, his tenure will be till the tenure of the earlier director who was getting removed, and the person who is getting removed here, or the director who is getting removed here, will be eligible for compensation for loss of office, provided definitely he has not done any kind of defaults there. Then after that, going on to the last two sections, that is section number 170 and 171. 170 talks about maintenance of a register. Okay, the company is going to maintain a register about the directors and their KMPs, their full details, their name, address proof, your age proof, your address proof. It is going to contain all these details, plus it is going to contain the details about the nationality, email address, personal details of such particular directors and the KMPs in the company. This will have to go and file it with the ROC also. Whenever there is any change in this particular register, then in that case we'll have to go and intimate it to the ROC as well within a period of 30 days from this particular change. Then after that, in 170, we were maintaining this register in the company. In section number 170, we were maintaining these registers. In section 171, we give the rights to the members that they can come and they can inspect these registers. Okay, that they can come and inspect these particular registers. That can be done free of cost. And suppose if inspection can always be done free of cost, and suppose if they require some copies, then even these copies can be provided to them free of cost. And suppose if it is not allowing us to do the inspection of this register, then we can go and make an application to the ROC that, sir, they are not allowing us to do the inspection of this particular register, and then the ROC will pass the necessary orders. Okay, the last section here was section number 172, which talks about if in the entire chapter, right from section number 149, suppose if there is any section where there is a contravention and for which no penalty or punishment has been provided, then for that purpose the punishment has been provided in section number 172, which has been amended for you, right? Then going on to section number 164 and 167. 164 talks about disqualifications of the directors, which is going to have some 9 pointers within it in section number 164 subsection 1. It says that if there is any person of unsound mind, if there is any person who is adjudicated as an insolvent, if there is any person who is an undischarged insolvent, if there is any person who have been convicted by any court and sentenced to imprisonment for at least a period of 6 months, okay, then in that case he becomes disqualified to be appointed as a director till what time? Till the expiry of 5 years from the day when he got released from the jail. After he got released from the jail, after that also for a period of 5 years he is ineligible to get appointed as a director, and there is one case where he gets permanently disallowed. Okay, there is one case where he gets permanently disallowed or disqualified. That is when he has been sentenced to imprisonment for a period of at least 7 years. Then in that case, he will be totally disqualified to be appointed as a director any time during his life. These were the 4 points. Then after that, going on to the next 5th point, if any particular order of any court or tribunal has been passed of disqualifying this person as a director, then the person gets disqualified. Suppose if he has not paid his call money, and if 6 months have elapsed, from that particular date, if 6 months have elapsed from that particular date of due date of repayment of the call, then in that case he is disqualified to be appointed. If he has been convicted of any related party transactions, like he has done the related party transaction in contravention of the provisions of 188, then in that case he will be disqualified for a period of 5 years. Okay, then he will be disqualified for a period of 5 years. Then after that, suppose if he has not obtained DIN, which was required under section 152, then he becomes disqualified. And suppose if he has not complied with the pointers relating to number of directorship, that is, he is holding more than the required number of directorship, or whatever is the contravention of section number 165, then in that case he becomes disqualified to be appointed as a director. These were the 9 points where the person cannot be appointed in any particular company. Okay, he cannot be appointed in any particular company, or if after appointment, if he attracts these points, then in that case he will have to vacate his office under section 167. Then after that, going on to the second subsection of section number 164, which is very, very important. 164 subsection 2 says that if there is any particular company where this particular director has not filed the financial statements or annual returns for the last 3 consecutive years, or if that person has done some default in repayment of deposits accepted by it, or to pay interest on it, or to redeem any debentures, or to pay any interest on such debentures, or if they have done any default in payment of declared dividend, and if such default continues for a period of 1 year, means still a period of 1 year also that person has not rectified it, then in that case such director cannot be appointed in any new company for a period of 5 years, or he cannot be reappointed in this particular company also for a period of 5 years. This is one of the biggest disqualification that is getting attracted. And then after that, suppose if there is a new director who has come in the company, then by default he does not become a defaulting director. We'll give him a time period of 6 months. Okay, we'll give him a time period of 6 months, and then only this particular person will be disqualified, not as soon as he enters the company. Okay, similarly, a private company will also be, it will also have section 164(1) and 164(2) applicable to it. But if it wants to provide more pointers about disqualification, it can do so. It can provide more pointers about that disqualification. And suppose in case of court, we wanted to go and file an appeal, then just because we have filed an appeal in the court, that does not mean that we are qualified. We will still remain disqualified as per the provisions of section number 164 subsection 1. Right? Now, if any particular director has been disqualified, then in that case, he cannot be reappointed in the same company for a period of 5 years. Okay, but he can act till his tenure. Okay, he will act till his tenure. After that, he will not get reappointed. And suppose if he later rectifies his default, then in that case also 164(2) will still remain applicable. That is, he will still remain disqualified even though he rectifies his mistake at a later point of time. This was all about your section number 164. Now jumping to section number 167, which talks about vacation of office. Now, if any of the disqualifications get attracted under section 164, that is the one that we just did, then in that case, that person will have to vacate his office, right? But if any person has done any disqualification under section 164 subsection 2, then in that case, he will have to vacate his office in all the other companies. Okay, he will have to vacate his office in all the other companies except the company in which he has done the default, because in this company, he will continue till his tenure, but he will not be eligible for reappointment. Okay, that is one point. Then after that, if he has absent himself from all the board meetings, either after taking the permission of the board or without taking the permission of the board, then in that case, another point is if he has done any kind of contraventions under section 184, either of disclosing his interest, that is under section 184(1) or 184 subsection 2, then in that case, he will have to vacate his office. If he is disqualified by any order of court or tribunal, then he'll have to vacate his office. If he has been convicted of any particular offense and sentenced for more than or equal to 6 months, then he will have to vacate his office. If he has been removed as per the provisions of section number 169, then he will have to vacate his office. Or if his appointment was done in our particular company because of his appointment in some other company. He was appointed in my holding company, so this company also appointed him. So if he vacates his office from the other company, he'll have to vacate his office from this particular company as well. Okay. Then after that, whenever in case of court or tribunal, whenever court or tribunal comes into picture, and if we decide to go and make an application, if we decide to go and make an appeal application to the court, then in that case they say that vacation of office will not apply for a period of 30 days. Okay, it will not apply for a period of 30 days. Means whenever the vacation order was passed, whenever the vacation of office order was passed, or whenever the disqualification order was passed, from that day within a period of 30 days, we have got the right that we can go and file an appeal. So no vacation of office is attracted for a period of 30 days. Now suppose if the appeal is filed within a period of 30 days, then we'll wait for the appeal to get disposed of plus 7 days. Plus 7 days, till that also we are not supposed to vacate our office. Why plus 7 days is given? So that we can go and file a second appeal, and till the time the second appeal is disposed of, till that time you are not at all required to vacate your office. Okay, after that, depending upon the decision which has come up in case of court or tribunal, depending upon that, your vacation of office is going to apply. This is how vacation of office is done. If there is any default there, then there is a fine that is applicable there. Suppose if all the directors' places get vacant. Okay, if all the directors' places get vacant, then in that case the promoters will step in between, and if suppose the promoters are not there in the company, then in that case the central government will come into picture, and the central government will appoint the required number of directors for efficient working of the company. And if a private company wants to put more grounds for vacation of office, then it can do so. So this was all about your section number 167, and with this the directors chapter gets completed in all respects. It started from section number 149. And it is going till section number 172. Only the important penalties have to be remembered there. Important penalties or punishment, as the case may be, has to be remembered there. Some very important sections are about women director. It is about independent director. It is about resident director. Then small shareholder director, additional director, alternate. The types of directors, the different directors which are coming in the company are super duper important. Apart from that, 164 and 167 is again very, very important. Number of directorship, that section is important. Resignation and removal of director, that section is important. So there are these certain specific retirement by rotation, 152.6 and 152.7 is very, very important. So these are certain sections which have to be compulsorily done, which have to be compulsorily revised before your exams. I hope you are very, very clear till here. Start with the super quick revision of meetings of board and its powers. Starting from section number 173, which is going to go till 195. In that case also 194 and 195 have been omitted. So ultimately we are going to study from 173 to 193 in this particular chapter. Section number 173, which talks about the meetings. First thing, frequency of the meeting. The first board meeting has to be held. In case of a company, the first board meeting will be held within a period of 30 days from the date of its incorporation. In case of subsequent years, in a particular calendar year, we are supposed to hold at least 4 meetings, and the gap between 2 meetings should not be more than 120 days. It should not be more than 120 days. In case of COVID, this gap was increased to 180 days. Then after that, whenever the central government thinks fit, it can make certain additions or deletions in the provisions of conducting this first meeting and the subsequent board meetings. in the board meetings, only the directors are going to participate. So when we talk about participation, the meeting can be conducted either physically, or the meeting can be conducted by way of audio visual mode or by video conferencing mode. Whenever it is conducted by way of audio visual or video conferencing mode, then in that case we should be having proper facilities of recording the meeting, conducting the meeting, holding the meeting, storing the recordings of the meeting. We should be having facilities for all these things. And for that matter, central government has prescribed a list of matters which cannot be done by audio visual or the video conferencing mode, and rest everything can be done by either ways of board meeting. In that particular list, there are going to be some 5 transactions which cannot be done by way of audio visual. First one is whenever we are conducting any meeting for approval of financial statements, whenever we are approving the board's report, whenever we are issuing any prospectus, whenever we are conducting the meeting of audit committee for adoption of our financial statements, and whenever we are going to discuss about the reconstruction of the company, that is for merger, amalgamations and all these things. These are the 5 matters. These are the 5 matters which they said that you cannot discuss in any video conferencing or the audio visual meeting. But then they said that if you are conducting the meeting physically, and if you have got the quorum in the physical meeting, then these matters can be discussed in the audio visual thing also. That is, the access to the audio visual meeting can be given to the directors who are not able to attend the meeting physically, because anyway you have got a quorum in the physical meeting there. That is the point that is given there. Then after that, when we talk about the notice of the board meeting, for board meeting we'll have to give the notice to each and every director. Okay, to each and every director of a company, at least 7 days notice must be given to their registered office. Okay, and if any particular director is outside India, then to the Indian address, that notice has to be delivered. That can be by hand delivery, that can be by postage, or that can be by electronic means. If ever you want to call any meeting at a shorter notice, okay, if you ever want to call any meeting at a shorter notice to transact any urgent business, then that can be done, but provided that at least one independent director should be present in the meeting. Now assume if one independent director is not present in the meeting, then in that case no problem, call the meeting at a shorter notice. Then whatever things you discussed in the meeting, get those things ratified by one independent director at a later stage. In such cases, the meeting which is called at a shorter notice will be treated to be valid. Okay, in case of original director and in case of alternate director, the notice has to be served. There is no legal provision given for that, but as a matter of prudence, the notice must be given to both the directors for this particular meeting. Then after that, going on to a few specific points about which we should be studying. In case of one person company, in case of dormant company, and in case of small company, there is no need to conduct 4 meetings in a year. In each half of a calendar year, even if one meeting is conducted, then that would be sufficient, but the gap should be not less than 90 days. The gap between any 2 meetings should not be less than 90 days. This was for OPC, this was for small company, and this was for your dormant company. When we go to section 8 company, there also similar provision applies, that is 1 meeting in each half of a calendar year would be sufficient, provided that it is a non-defaulting section 8 company. Okay, and similarly for a startup private company, also, if in each half of a calendar year, even if one meeting is conducted, then that would be sufficient, provided that it should be a non-defaulting startup private company. Right? And if suppose you have one person company which has got only one director, then the provisions of board meeting will not at all apply to such companies. Right? Now, when we talk about the audio visual method, there are certain provisions which we have to keep in our mind. Whenever you're conducting some meeting by audio visual mode, first of all, you have to make proper facility so that there is no disturbance in the meeting in between, so that there is no failure in connection in the meeting in between. The chairperson of the company or the chairperson of the meeting, or the CS, if there is any company secretary in the company, they will be responsible for all these things. They will have to make sure that security things are met. They will have to make sure that proper equipments are available for telecasting or broadcasting this particular meeting. They will be responsible for recording the proceedings of the meeting and to make the minutes out of it. Then the recordings of these meetings have to be properly numbered, have to be properly dated, and then that will be stored in the data of the company, just like minutes are stored. Then after that, notice for this will be sent to each and every director. In the notice itself, it will be written. In the notice itself, it will be written that the directors have got the right to attend the meeting by way of that they have got an option, not right. They have got an option to attend the meeting by way of audio, visual, or video conferencing mode of the company. And if they wish to do this, then they will have to give a declaration to the company at the beginning of the year itself, that in this year they might attend some meetings by way of audio visual mode or video conferencing mode. Okay, that cannot be done at the end moment. Okay, that cannot be done at the end moment. So suppose now if he has given a declaration that he would be attending the meeting by way of audio visual mode, but then later he decides to attend by physical mode, then no problem, he can sufficiently intimate the company in advance that he wishes to attend the meeting in person, so he can do so. But vice versa thing cannot happen. Okay, for attending the meeting electronically, for that purpose he has to give a declaration at the beginning of the year. That is mandatory. Suppose if he does not give any declaration, then in that case it is by default assumed that he is going to attend the meeting in person. Quorum has to be checked, quorum has to be met, quorum has to be present throughout the meeting. Okay, statutory registers will be kept open in this particular meeting. Those who are attending the meeting by way of audio visual or video conferencing mode, if they just give their consent, then yes, it will be deemed as if these registers have been signed by them and they have agreed to these particular registers. Suppose if whenever in a meeting, in a audio visual meeting, if the chairperson of the company thinks that too much of chaos is happening because too many of the people are speaking at the same time, then the chairperson can get that meeting conducted in a disciplined manner, and it will tell each of them to identify themselves that okay, I am so and so person, I want to speak on so and so matter, so that everyone would be knowing first of all who is speaking, and the meeting will be conducted in an effective manner. Okay, the place where the board meeting is conducted, the place where either the physical board meeting is conducted or wherever you are sitting and watching or attending the meeting by way of audio visual mode, then in that case no other person should be given the access to that particular place, because this is a private meeting. Okay, this is not a general meeting, this is a board meeting. So every outside person, okay, every person other than chairperson, other than your CS and other than your directors, apart from this there should be no one present, except in one case. Suppose if either of the director is a handicapped person or if he is a disabled person, then one person can be allowed to attend along with that particular director. Okay, as soon as every matter is discussed, the chairperson is going to announce the conclusion. Okay, we discussed so and so matter, this is the conclusion, and then it is recorded in the minutes. The draft minutes will be circulated. The draft minutes will be circulated to each and every director. Then whoever attended the meeting, they are going to certify that yes, so and so things we discussed in the meeting. And after that, we will circulate. The company will circulate within a period of 15 days. And once the directors start receiving this, they will have to give their approval within a period of 7 days. And after that, the draft minutes gets converted into the final minutes, and the minutes will be entered in the minutes book then. Okay, this was the pointer. This was the pointer which was talking about your conducting of meeting by audio visual or video conferencing mode that is given there. Then these were those 5 matters which were not allowed to be dealt with in a audio visual mode, but we had got an exception that if you have the quorum present in the physical meeting, then in that case you can give the access of this particular meetings by way of audio visual mode or video conferencing mode to the other directors as well. Okay, now along with the notice, should we always attach the agenda? Is it mandatory to attach the agenda along with the notice of the meeting? Answer is no, it is not mandatory to attach. It is not mandatory to attach a agenda along with that, but as a matter of good secretarial practice. Okay, as a matter of good secretarial practice, it is advisable if you attach the agenda along with the notice of the meeting. Then after that, going on to the next section, that is section number 174, which talks about quorum for the board meeting. To the companies to whom section 173 was applicable, to them 174 is also going to be applicable. Quorum means the minimum number of people. Okay, quorum means the minimum number of people who should be present in a meeting so as to make the meeting as a valid meeting. Okay, in case of normal companies, it will be 1/3 of the total number of directors or 2, whichever is higher. In case of section 8 companies, it will be either 8 members or 1/4 of the total number of members, whichever is lower, with at least 2 members, with at least 2 directors present there. If you get any fraction, then that will be rounded off as 1. Okay, if you get any fraction, then that will be rounded off as 1 always. Okay, no nearest, no highest, etc. Always on the any fraction will be treated as 1 itself. Now, say for example, if you do not have the proper composition in your board of directors, means the number of directors have fallen below, then in that case, the remaining number of directors will continue in the company. They can appoint new directors in the company, maybe by way of additional directors, or they can call a general meeting, where in the general meeting we can appoint some new directors, so that the required number of directors are met in the company. Suppose if in the company you have majority of the directors as interested directors, suppose if you have at least 2/3 of the directors as interested directors, then in that case, the quorum would be the non-interested directors. Okay, the non-interested directors who are present in the meeting, they will be forming part of the quorum, because we cannot allow the interested directors to vote in the meeting. Suppose if the meeting could not be conducted because of the quorum thing, okay, then the meeting gets adjourned to the next week, same time, same place, same day, etc. That day should not be a national holiday. Okay, that day should not be a national holiday. If that day is a national holiday, then it goes to the next day. Original meetings can be conducted on national holidays, don't forget that. Okay, then any kind of meetings can be conducted on Sundays, because Sundays are not a national holiday. Then we had studied a very important exception here about the private company, that in case of private company, the directors who are interested, even they can participate in the meeting and they can vote in the meeting, provided they have disclosed their interest in the particular meeting, that they are interested in so and so matter. Then going on to the next section, that is section number 175. Again, very, very important. 175 talks about passing of resolution by circulation. Whenever the company does not want to call a board meeting, but it wants to take the approval of directors on a particular matter, then one method that is available to this particular company is it can circulate the draft resolution papers and the supporting papers to all the directors at their Indian addresses. The directors get their papers, they read it, they check everything, and then they give their approval, either yes or no, or whatever it is, they give their approval, they send it back to the company, and then the decision is taken on that particular matter. Okay, this is called as passing of resolution by circulation. But if at least 1/3 of the directors raise an objection, that no, this is such a matter which cannot be conducted by way of resolution by circulation, then in that case we will have to pass. Then in that case we'll have to call a board meeting, and there we'll have to discuss the matter. Means it cannot be done by that circulation of draft papers at their home. Achha, suppose if you could successfully pass the resolution by circulation, then it will be forming part of minutes of the next meeting, because today there was no meeting which was conducted. So whenever the next board meeting is going to be conducted, at that time we are going to make it the part of the minutes of the meeting. Then after that, going on to section number 176, which is very, very simple. Whenever any particular director was appointed and later we come to know that there was a defect in appointment of this particular director, or this director shouldn't have been appointed, etc., then in that case, the day when he comes to know about the defect in the appointment, till that day, whatever were the acts done by this director will be treated as valid, because that was done unknowingly. And the day when he comes to know, about the defect in appointment, after that, ideally the director will have to vacate his office. But suppose if he still continues in the office, then none of the acts which have been done by the director will be treated as valid from that particular day. So till the day we are unaware about all these things, then in that case all the acts will be valid. Okay, once we are aware about it, then too if the director is acting in the company, then the acts will become totally invalid. This was all about section number 176. Then going on to the next section, that is section number 177. Section number 177 was talking about your audit committee, as well as it is going to talk about the vigil mechanism. The companies which were required to have an independent director, same companies are required to appoint an audit committee also. Totally same to same. Audit committee should be having at least 3 members within that, and majority of them should be your independent directors, and majority of them, as well as the chairperson of the audit committee, should have the ability and the integrity to read and understand the financial statements, right? Then there were certain responsibilities of the audit committees, certain important responsibilities of the audit committee. It will check or it will tell us everything about the appointment of the auditors, recommendation of the name of the auditors, their appointment, their remuneration, their terms and conditions will be specified by the audit committee. Then they are going to review the independence of the auditors, because that is very, very important. Then they will examine the financial statements, and very important thing is they are going to ratify the transactions which we would have done with the related parties, and they can give omnibus approval. They can give one blanket approval for all the related party transactions for a period of 1 year. These were the four important responsibilities. These were the four important responsibilities that we had done in case of an audit committee. Okay, these were the four very important responsibilities of audit committee. Apart from that, some other transactions can be ratified by these audit committees. It can do the scrutiny of intercorporate loans and investments. It can help in appointment of valuer for the purpose of valuation of assets, etc. And it is going to evaluate the internal financial controls as well. And the last point, which is there in Caro also, whenever you raise any money by way of public issue, then the end use of funds will have to be monitored by this particular audit committee. These were some extra responsibilities of the audit committee. Then it will have a discussion with the auditors of the company, with the internal auditors or with the statutory auditors of the company. It will look after the problems which have been faced by these particular auditors. The issues which the auditors have with the management, that will be dealt by the audit committee. These are the duties, functions, responsibilities of the audit committee. Whenever audit committee meetings are conducted in which the auditor's report is going to be discussed, there the auditor will have a right to speak. Okay, he won't have any right to vote, but there he can participate in the meeting and he'll have a right to vote in the, he will have the right to participate in the meeting, not to vote. He can just speak on the matters, because the report which is prepared by him is going to be considered in this particular meeting. Then every company which is a listed company, or any company which has accepted deposits from public, or any company which have borrowed money from banks, whose banks or PFI of more than rupees 50 crore. Okay, either a listed company or other companies which have accepted deposits from the public, or whose outstanding loans or borrowings from banks or PFI is more than 50 crore, they have to establish a mechanism called as vigil mechanism in the company. Vigil mechanism is such a mechanism where the lower level employees and the directors are given an opportunity that they can directly go and knock the doors of the chairperson of the audit committee if they want to report any genuine issues which are happening in the company. Otherwise, because of hierarchy, we are never able to file the complaint against our seniors, just because of the hierarchy. But if your company has vigil mechanism in the company, then in that case you have a direct access to the audit committee's chairperson. If any particular person is doing this frivolously, then that person will be punished. Okay, if we are simply going and filing nonsense complaints with the chairperson of the audit committee, then we will ourselves will be punished by the audit committee. And the fact that the company has a vigil mechanism, this should be known to all the employees. Okay, so this should be written in the board's report also. This will be put on the website of the company also. This will be put in the notice board of the company also, so that at least the employees know that if they know that something wrong is happening, they can at least come in the company and they can report the complaints or report the genuine issues and concerns to the audit committee. Then going on to the next section, which talks about section number 178, that is NRC as well as the SRC. NRC stands for your Nomination and Remuneration Committee. SRC stands for your Stakeholders Relationship Committee. Again, the companies which were required to have audit committee, again the companies which were required to have an independent director, same companies are required to have Nomination and Remuneration Committee also. So NRC is also the number of the limits that we had studied for independent director under section 149(4). Same limits we are going to use here also. Same limits we used in case of audit committee also. Okay. Then after that, what is the work? What is the work of this particular Nomination and Remuneration Committee? Achha, before going to the work, let's see what is the composition of this. So this is going to consist of at least 3 non-executive directors, and out of that, at least half, not the majority, at least half should be the independent directors. The person who is the chairperson of the company cannot be the chairperson of the NRC, but he can be a member of the NRC if he has been co-opted as a member of this particular committee. Then after that, functions. What is the main work of this NRC? Just like for audit committee, we studied the responsibilities. Similarly, for NRC, their work will be to identify the people who are eligible to be appointed as a director in the company, their remuneration, their their qualifications, what qualifications is required for us, what qualifications do they possess, are they eligible to become director in the company, do they have the particular qualifications that is required to be appointed in our company, then what are their positive attributes, what will be the basis for their increment, all these things, or what will be the basis for fixing the remuneration, the bifurcation of variable payments and the fixed payments, all these things will be determined by the nomination and remuneration committee. As the name suggests, to appoint. Nomination means to appoint and remuneration means to fixing things about their remuneration. All these things are the functions of the nomination and remuneration committee, and whatever basis we decide that which type of director will we accept in the company, or what type of director is preferable in the company, all the policies of this NRC should be put up in the board's report of the company, or if you want, you can even put it up on the website of the company as well. Then going on to the next type of committee, that is SRC, that is Stakeholders Relationship Committee. If there is any such committee where there are more than 1000 security holders, okay, means equity shareholders, debenture holders, etc. If there are more than 1000 security holders in the company at any given point of time, then that company is required to have a Stakeholders Relationship Committee. Its main purpose is going to redress the grievances of the security holders, not only equity shareholders, equity shareholders, debenture holders, or any other security holders for that particular matter. Right? These were the most important points about the NRC as well as the SRC. Acha, in SRC, if SRC is not able to solve the problem in good faith, if it is a genuine case where the SRC is not able to solve, then there is no contravention which is done by the SRC. The SRC's constitution is still going to be treated as valid only. Then going on to the next section, that is section number 179. Section number 179 talks about powers of the board. First of all, the board is going to exercise all the powers on behalf of the company, means it acts as a custodian of the company. So whatever things have been assigned to the board of directors, that has to be completed by them. But the things for which we require the approval of the shareholders, that cannot be done solely by the board of directors. That will be first approved by the board of directors, then we'll have to go and take the approval of the shareholders as well, right? Then after that, suppose if any regulation has been passed, then that regulation, either be it in board meeting or be it in general meeting, that will be applicable prospectively and not retrospectively. Okay, then there were certain matters which have to be compulsorily approved by the board of directors in a duly convened board meeting. Okay, means for this, resolution by circulation is not at all allowed. Either call a meeting by physical mode or call a meeting by way of audio visual mode, and by that way the board will have to give its approval by passing a board resolution. Now, what are those matters? Whenever we want to call the call money, whenever we want to make calls on the shareholders, whenever we want to do buyback up to a certain limit, whenever we are accepting loan, whenever we are granting loan, or whenever we are doing any sorts of investments, whenever we are talking about approval of financial statements and the board's report, whenever we are talking about merger, amalgamations, etc., whenever we are talking about expand to diversify the company's business, then after that, whenever we are doing any kind of contributions, political party contribution, charitable trust contributions, etc., these are those matters. Okay, these are those matters where the board will have to compulsorily pass a board resolution first, and then only the matter can be taken up. Okay, now there are three pointers. That is D, E, F in this. That is granting of loans, accepting of loans, or doing investments. These three matters can be delegated. Okay, these can be delegated to a certain director or to committee of directors, to the MD, to the manager, to the principal officer of the company, or to the principal officer of the branch, etc. It has to be delegated that way. Okay, it can be delegated, but subject to the provisions of section number 186, which we will see now. Acha, similarly, suppose if when we talk about accepting of loans or granting of loans, if any company is doing it in ordinary course of business, then obviously every time the board resolution is not going to be required. Example, if we are taking loan from the bank, Think from the bank's point of view. For bank, it is an ordinary course of business. So bank is not going to pass a board resolution before it grants you the loan in that particular thing. Then after that, generally they are telling that the powers which are there with the board will have to be exercised by the board only until unless all the directors have vacated their office, or all the directors have been acting malafidely, or if there is a deadlock in the management, then in that case the board cannot exercise its powers. Then only the shareholders will interfere in between. Okay, otherwise the things which have to be done by the board will have to be compulsorily done by the board itself. Okay, these were in section number 179. These were certain things on which the powers have to be exercised by the board of directors only. Okay, now there are four such matters where the board's powers have got the restriction. Means if you want to get these four things approved, then in that case the shareholders will have to pass a special resolution for that. What are those four matters? Just try to recollect. First one, whenever you're selling off, leasing off, or disposing of any particular undertaking or a substantial part of the undertaking, then it can be done only by passing a special resolution. Right? Then second one, if you want to interest otherwise than in trust securities, the compensation that you had got in case of merger or amalgamation, you can do that in other than trust securities, you can do, but only after obtaining the approval of the shareholders. Then where the loan already borrowed plus the loan to be borrowed, when it exceeds the paid up share capital plus the free reserves plus the securities premium, then as soon as the limit gets exceeded, then in that case we'll have to take the approval of the shareholders. We'll have to take the approval of the shareholders in the general meeting by way of a special resolution. But here in this case we are going to exclude the temporary loans. We are going to exclude the temporary loans which are taken from the bankers of the company. Okay, temporary loans taken from the bankers of the company will be totally excluded. Temporary loans means which are repayable within a period of 6 months. But if there is any loan which has been taken, which is in capital nature, okay, which is taken for meeting any expenditure of capital nature, then that will not be treated as a temporary loan, even though it is repayable within a period of 6 months. These were the pointers. And one more, last one. When we want to give more time for repayment of loan given by the company to its directors. Okay, if it is given by the company to its directors and the directors need more time for its repayment, then in that case more time can be given to them, but only after passing a special resolution in the company. So these are 4 pointers where SR is required, where simply board resolution is not going to be sufficient. Okay, then whenever you are passing any resolutions, special resolutions, you'll have to call so many of the shareholders. So wherever required, you can get the voting done by way of postal ballot. Okay, postal ballot means the shareholders will be sitting at home, and by sitting at home they can vote in this particular matters. Okay, then suppose if the company, that loan point, the third point, suppose if the loan limits have exceeded, but then too we have accepted any particular loan, then in that case, if that person has given the loan in good faith, then no problem. Means if the bank was not aware that SR was required, or if the SR was not passed, then okay, then no problem in that. But otherwise, the loan which has been accepted by our company, that will not be treated as valid loan. Okay, if you haven't passed the SR, then that will not be treated as valid until unless the loan which has been given by that person is done in good faith. Right, now undertaking means what? Undertaking, remember we were selling the whole of the undertaking or substantially the whole of the undertaking. So first of all, undertaking means such an entity or such a part of the entity in which we have done investment of more than 20% of the total net worth, or any such part of the undertaking whose income is more than 20% of the total income. So that becomes a crucial entity for us, and substantially the whole of the undertaking means that entity has got a value of more than or equal to 20% of the total value of the undertaking. So if you're selling this particular undertaking, or if you're leasing it off, then there is a major chunk of the value which is going to go out. So for that purpose, we'll have to pass a special resolution in those cases. Now, another thing is section number 181 to section number 183, which talks about 181 to 183 talks about your donations. 181 talks about contribution to the charitable funds or to the bona fide charitable trusts, etc. The board has got the powers. Okay, simply the board has got the powers that whenever it wants to whenever it wants to do any contributions to the charitable trust, it can do so by simply passing a board resolution at a board meeting as per section number 179. Okay, if it wants to do any contribution more than 5% of the average profits of the last 3 years, then in that case, they will have to pass a resolution. They will have to pass an ordinary resolution in the general meeting. Okay, even if in the current year, if you have got losses, no problem, you can still do the donation of whatever amount. First and foremost, board resolution is mandatory and ordinary resolution is going to be mandatory only when the amount that you are going to donate is going to exceed, that is more than that is going to be more than 5% of the average net profits of the last 3 years. This was about section number 181. Then when we go to section number 182 talks about contributions to the political parties, electoral trust or advertisement in any souvenir of these political parties. First of all, contribution to the political parties cannot be done by a government company and it cannot be done by a newly incorporated company for a period of the first 3 years. First 3 financial years it cannot do. After that it becomes a normal company, so it is no more a newly incorporated company. Then whenever you want to do any kind of political party contributions, etc., you can do it. You do not require an ordinary resolution at all. Simply pass a board resolution. Okay, simply pass a board resolution and the contribution can be done either directly to the political parties or by way of advertisement in the newspaper, pamphlet, souvenir of the political parties. Means either you can do it directly or you can do it indirectly. Here there is no limit. Okay, in 181 also there was no limit. It was just that the procedure was applicable. In 182 also there is no limit which is to be applicable for donations to the political parties. That is, whatever amount you want to donate, you can donate, but it has to be by way of account paid check, draft, ECS, etc. It has to be by those modes only, mandatorily. Okay, then after that, the next thing that they are telling you here is in your PNL account, whenever you are writing that you have donated so and so amount to the political parties, you have to write it in detail that you cannot club it with the miscellaneous expenses. It has to be a separate line item that so and so contribution has been done to political parties. Writing the name of political party is not required, but contribution has been done to political party, that you have to write. But that is not necessary when the contribution is done to the electoral trust, because the electoral trust anyway does those type of reportings. Okay, so it need not do. So we have to do it only in case when we are donating it to the political parties and not to the electoral trust. This was all about your section number 182. Then going on to the next section, that is section number 183. 183 talks about National Defence Fund or any other fund where the money is going to be utilized, for the purpose of defence activities. Here anyone can authorize. Okay, either the board can authorize or the shareholders in the general meeting can authorize, or any particular person or any particular committee, if they think fit that some contribution should be done to this particular National Defence Fund or any fund from which the money is going to be utilized for the defence activities, you can contribute whatever amount you want to contribute to this particular defence fund. Respectively, board resolution or ordinary resolution respectively can be required in such cases. Okay, and whenever you are doing this contribution to the National Defence Fund, at that time also it should be shown as a separate line item, means it should not be clubbed. It should not be clubbed with any other expenditure. This was till all the donations under section 183. Okay, this was about all the donations under section 183. Now going on to the next section, that is section number 184, which is important. 184 talks about two types of disclosure. One is your general disclosure and the other one is a specific disclosure in case of interested director. Okay, first let's try to understand the meaning of interested director as per section number 184. Now, in case of interested director, a director becomes interested in a body corporate when he is holding shares of more than 2% of that body corporate, or if he is a CEO promoter or manager of such particular body corporate, or if a director becomes interested in any other firm when he is a partner or a member. He becomes interested in any particular firm, association, etc. when he is a partner, member, owner of such particular other firm or entity. So he is deemed to be interested in such other company, right? Now, general disclosure will be done under section 184(1) 3 times, just like your independent directors. That is his first board meeting, every year's first board meeting, and whenever there is any change in the circumstances, he has to simply disclose his interest that I am interested in so and so different companies or so and so different firms. Okay, then when we go to section, that is done in form number MBP1. Okay, that is done in form number MBP1. We go and submit it to the company checks it, the company it keeps it, it maintains it, it will have to maintain it for a period of 8 years, and the company secretary or the board of directors, as the case may be, will be responsible for maintaining these disclosures under section 184(1). Then going on to the next section, that is next subsection, that is section number 184 subsection 2, which talks about specific disclosure. In case of specific disclosure, whenever my company is entering into the transaction with that other company or the other firm in which I am interested, then in that case, before I attend this particular meeting, I will have to intimate, or in that particular meeting, I will have to intimate the company that I am interested in this particular transaction. So they will not allow me to vote. Okay, they will not allow me to vote unless it is a private company. They will not allow me to vote. Okay, now suppose if you entered into any particular contract or arrangement without doing the disclosures, then it becomes voidable at the option of the company. Means now the company, that is the shareholders, are going to decide. Now the shareholders are going to decide that should this contract or arrangement be treated as valid, or will this be treated as void. Right, this was all about your section number 184. Subsection 1 was talking about general disclosure. Means here I am just disclosing that I am interested director in so and so companies. In 184(2), you have to give this disclosure when your company enters into a transaction with the interested companies. At that time, you are supposed to do the disclosure under section 184 subsection 2. Then after that, going on to the next section, jumping to section number 187. 187 talks about investments to be held in its own name. By default, since company has a separate legal entity, it can hold assets in its own name. It can be property, it can be shares, it can be any particular other assets of the company that can be held in its own name. But there are certain exceptions. Where for the time being, the holder of these assets becomes some other person, but we still remain the beneficial owner of that. Okay, example, in case of wholly owned subsidiary company, if you have appointed some more members to meet the statutory requirement of law, then they are holding the shares for the time being, that is okay, but ultimate beneficiary is you only. Okay, similarly, whenever you want to get some income collected on your securities, you can temporarily transfer it to some other person to collect the income on that. That is one of the pointers. Or if, say for example, if you want to sell off your securities or shares at the best possible price, and you had transferred it to some person who is going to sell it at a very good price, then that person does not become the owner. Okay, the owner is going to be still me only. Then suppose if we have given any particular asset as mortgage, then we have simply given it as a mortgage. We have not sold that particular asset. So if at any time I plan to do the repayment, then in that case, the securities or the assets which I had given as mortgage will come back to me. Okay, then after that, similarly, when the securities are held in demat format, holder will be the demat, but we will treat it to be as beneficial owner. Right, these were some 4 to 5 pointers. Where holder can be any person, but we still remain the beneficial owner of those particular assets. This was given in section number 187. Then going on to section number 190. Okay, directly going to section number 190. I have left 189. Sorry, I have left section number 188 in between. Before that, I have left 186 and 185. 186, 188, we can take it at the end. Now going on to 189, which talks about maintenance of registers. Okay, not at all important, just a one-time read section. Every company will have to maintain registers for 2 things specifically. One is contracts or arrangements in which our directors are interested, that is 184 subsection 2, and we'll also have to maintain registers for the purpose of section number 188. that is your related party transaction. These are maintained in MBP4. These have to be kept at the registered office of the company. These will be open for inspection. Copies of this can be obtained on payment of the required fees. So this is how the registers are to be maintained there, and whenever there is any change in the details of the KMPs or the directors, whenever they come in the company or whenever they relinquish the company, their details are also supposed to be maintained in form number MBP4 itself. Then after that, there are certain transactions which are done by the bank in ordinary course of business, or if there are any sale purchase transaction where the value does not exceed rupees 5 lakh in a year, then for that purpose this section maintenance or this section's record maintenance in MBP4 will not be required. So this is one kind of a relief which has been provided, that in case of small transactions, even if you don't maintain the registers etc., that would be absolutely alright. Okay, that was your section number 189. Now going on to section number 190, which is a very simple section. 190 simply says that whenever you have your MD or the WTD in the company, then in that case you should be having a legal format with them, that is, which describes the terms of conditions. If you do not have a legal agreement with such MD or WTD, then in that case no problem, just make sure that you note down these terms and conditions in rough in the memorandum, and this has to be maintained in the company. This will be open for inspection, and this has to be compulsorily there in writing. If it is not in a legal proper format, no problem, at least maintain it in a rough memorandum. And the section is not applicable to a private company. Private company need not maintain these terms of conditions in a separate agreement at the registered office of the company. That is not mandatorily required. Then going on to the next section, that is section number 191. 191 talks about compensation for loss of office other than 202, other than the provisions of section 202, which we had already done. Compensation under section 202 was payable only to the managerial personnel. Okay, in section number 191, loss of office is happening in case of other directors because of any particular reason. It can be due to transfer of shares, it can be due to transfer of assets, it can be due to transfer of undertaking, it can be due to transfer of property. Loss of office of these directors can happen for any of such reasons, and whenever this loss of office happens, by default they are not eligible for any amount of compensation. Okay, by default they are not eligible for any amount of compensation until unless it has been agreed by the shareholders in the general meeting. Okay, until unless it has been agreed by the shareholders in the general meeting, they can approve it, that what amount of compensation can be paid to them. To whom are you paying? How much amount are you paying? How did you calculate this amount? Why are you paying, etc. All these details have to be written in the resolution where we are going to approve in the general meeting. Then after that, section 202 is not going to get affected. Okay, 191, just remember it is applicable. Section number 191 is applicable to other directors, and section number 202 was specifically applicable to the managerial personnel. So that section is going to remain unaffected there. Okay, that is going to remain unaffected there. Now suppose in case of this general meeting where you wanted to approve this compensation for loss of office, suppose if we could not get the quorum, then in that case by default it will be assumed that the compensation has not been agreed. Okay, adjournment of meeting does not mean that the matters have been decided. Okay, especially in case of compensation for loss of office, if your quorum is not met, then it will be deemed as if no compensation can be paid, at least as per that particular meeting. So there is no deemed approval of payment of compensation. Then going on to the next section, that is section number 192 and 193. In section number 192, we talk about the non-cash transaction which happens between the company and the director of the company or director of our holding company or the associate company. Whenever any non-cash transaction happens, means say for example, if the director acquires any assets from the company for non-cash consideration, or if vice versa thing happens, that the company acquires any assets from these directors of the company or its holding company etc., holding company or subsidiary company etc., then in that case, okay, first of all they had told that these transactions are not allowed. Then they say that these transactions can be done, but only after passing a resolution in the board meeting. Okay, only after you pass a resolution in the in the general meeting, not in the board meeting, in the general meeting, if you pass a resolution, then in that case, these transactions can be done. These non-cash transactions can be done. But most importantly, since these transactions are done between the company and the director, then in that case, the transaction should be valued. Okay, the transaction should be valued by a registered value so that there is no dispute in the amount at which we have done this particular transaction. Right? Suppose if the transaction has been done by the company with the director of its holding company, then a resolution has to be passed in the holding company as well. Like we will pass a resolution in our company, plus one more resolution has to be passed in the holding company. Because our company has done the transaction with the director of the holding company, so even they should approve entering into such type of transactions. Then going on to the next one, that is section number 193, which talks about one-person companies or contract by one-person companies. Whenever a one-person company enters into any kind of contract with the sole person who is the member of the company, plus who is the director of the company also, then in that case you have to make sure that this matter is presented before the board of directors, and the board of directors have taken the note of this particular contract, because here the transaction has been done between OPC and that sole member who is also one of the director of this company. So discuss it in the board, and the board will take a note of the same. Okay, suppose if once this is done, once you submit it to the board, after that go and submit it to the ROC as well. Okay, go and submit it to the ROC as well, so that the ROC has a control that the transaction is not done in a fraudulent manner. Suppose if you are the sole director in the board, then in that case board meeting won't be conducted. Then just go and intimate about these facts to the director, so that to the ROC, so that the ROC can take a note of the same. This was given in section number 193 days. And yes, to the ROC you go and submit it within a period of 15 days. Okay, once the board approved it, from that day, within a period of 15 days, you can go and make an application to the ROC, so that the ROC can take a note of such type of transactions. Then going on to the next section, that is section number 185. In section number 185, they talk about giving of loan to directors and to other persons. Okay, now loan cannot be given to the director of the company, loan cannot be given to the director of the holding company, loan cannot be given to the relatives or partners of the directors, and loan cannot be given to any firm in which our director or the relative is a partner. To these 5 people, we cannot give the loan at all. Okay, but there are certain intercorporate loans which can be given. Okay, there are certain intercorporate loans which can be given to whom? To any such company in which our director is interested. Example, to any private company where our director is a director or a member. To any particular company or body corporate where at least 25% of the voting power is exercised by the directors of our company. Or to any particular company whose board is accustomed to act as per the directions given by our company. To these intercorporates, to these intercompanies, or to these other companies, the provisions is going to apply, and we can give loan to them. But only after passing a special resolution. Plus, whenever you are passing the special resolution, you have to call a general meeting. Whenever you are calling this particular general meeting, to the notice, a justification statement is going to be attached about the full details of loans that is going to be given, and the loan should be utilized by the other company for its principal business activities only. Mandatorily, it should be utilized for its principal business activities only. These were the 5 first transactions for which no loan was allowed to be given, and then the 3 intercorporate transactions to whom the loan can be given. Okay, then section number, these 2 subsections are not applicable to 4 cases. Okay, these are not applicable to 4 cases, means loan can be given. Loan can be given to MD or WTD if it forms part of the service conditions, and if it is not forming part of service condition but the shareholders approve by way of a SR that loan can be given to this MD or WTD, then we can give the loan. Okay, another thing is, if the loan is given in ordinary course of business, then you can give the loan to any particular person, provided make sure that the interest clause is met, that is the interest nearest to the government yield should be received on these particular loans. Then loan or guarantee can happen in case of holding company and its wholly owned subsidiary. But guarantee, acha, loan cannot be given to other than wholly owned subsidiary, other subsidiaries other than wholly owned subsidiaries, but guarantee can be given by holding company in favor of any particular subsidiary company, provided the loan has been given, provided the loan has been given, the guarantee has been given in respect of a loan which has been given by banks or financial institutions. Okay, so in case of wholly owned subsidiary, it can be any kind of loan, it can be any kind of guarantee. In case of other than wholly owned subsidiary, the loan has to be compulsorily given by any person other than, it has to be given only by banks or financial institutions. They are very particular about it. So in this section, in section number 185, 5 people were prohibited, 3 people were allowed subject to special resolution and that principal activities, and after that 4 of them or 4 transactions were put in exception. For these 4 transactions, you need not even pass the special resolutions. This is given in section number 185. 185 is not applicable to certain government companies and to certain small private companies. It is not applicable to them at all. That is, loan can be given to them bindas. Okay, then going on to the next section, that is section number 186, which talks about loans and investments. In that, one very important point was, no company can do investments through more than 2 layers of investment companies. That is not at all allowed, but it will be allowed in 2 circumstances. If any other law, if any other country's law permits it, or if any other Indian law permits it, then later on it will be allowed. But as of now, investment beyond 2 layers is not at all allowed. Okay, apart from that, whenever we are giving any kind of loan, or whenever we are, giving any kind of guarantee, or whenever we are doing any investments, then the total of it should not exceed 60% of the paid up share capital plus the free reserves plus the securities premium, or 100% of the reserves. That is 100% of free reserves plus the securities premium, whichever is higher. The loan amount should not go, the loan investment guarantees total should not go above this. Whenever you are calculating this limit, then the loan to the employees is to be totally excluded there. That can be given over and above the limit there. Whenever the limit is exceeded, the company will have to pass a special resolution, and then only it can give the excessive amount of loans, or it can give the excessive amount of guarantees, or it can do excessive amount of investments for that particular matter. And whenever you're passing any special resolution, then if suppose in case of bigger companies, it is not possible to call all the number of directors, then the voting can be done by way of postal ballot as well. Okay, then just try to understand one thing. SR requirement is not applicable whenever any loan, guarantee, security, etc. is given to by a holding company to its wholly owned subsidiary. SR requirement is not there. Okay, even though the limits are exceeded, normally whenever the limit got exceeded, we had to pass SR. But if the limits are getting exceeded because we are giving more loan, guarantee, security in our wholly owned subsidiary to our wholly owned subsidiary company, then in that case, SR requirement is not at all there. Okay, then whatever loans we have given, whatever investments we have done, whatever guarantees we have given, etc., for that particular matter, each and every detailed disclosure has to be done to the shareholders by way of the financial statements. Achha, one very important thing was, whatever loan, guarantee, investments we are doing here, that will that requires board resolution primarily, because this we had studied in section number 179. Right? So now here, whenever you're passing the board resolution, it has to be a unanimous board resolution. Okay, your unanimous board resolution means whoever is present in the meeting should be saying yes. Okay, whoever is present in the meeting should be saying yes. There should be no, or there should be no abstaining thing also. Whoever is present, everyone should say yes. If any one of them says no, then in that case, this resolution cannot be approved in the board meeting. Okay, that is one requirement, that is you need to pass a unanimous board resolution. And another thing is wherever in any particular public financial institution, wherever the term loan is pending, wherever your term loan is pending, that particular approval, that particular PFI's approval should be obtained before you grant the loans, investment guarantees, etc. But yes, their approval won't be required if we are doing this within the limits and we haven't done any default with this public financial institutions. Okay, whenever it comes to the members of the SEBI, or whenever it comes to any person relating to the SEBI, that is your stock exchanges, portfolio advisors, managers, then your underwriters, etc., whenever they want to do anything, then for them the specific regulations will be provided in the SEBI one. Acha, now here, since you are having idle funds, that's the reason you were doing investments, that was the reason you were giving the loans and all those things. Then in that case, you have to be sure about one thing. You have to be sure about one thing, that the interest that you collect, on these particular securities, that should be nearest to that government yield interest. Okay, because your idle funds are lying with you, which are ultimately the shareholders' funds. So at least the return that you expect on government tenure, at least that much return should be, we should be getting on these loans in form of interest or in form of dividends or income in case of securities. Then another thing is, all the details about the loans, investments, guarantees, etc., have to be maintained in form number MBP2. Okay, that have to be maintained in form number MBP2. It will be maintained at the registered office of the company. If anyone wants to take the copies, they can take the copies by paying the required fees. If they want to take the extracts, then they can simply go and take the extracts of these particular registers. And the entire section except for subsection 1 is not applicable to companies who does all these things in ordinary course of business. Okay, that is investment companies, or your insurance companies, banking companies, housing finance companies. For them, doing investment, giving loans is happening in ordinary course of business. So the entire section is not applicable to them, except for 186.1, that is 2 layers. That is still applicable. Rest, none of the sections would be applicable to these types of companies. Then going on to the last section. Acha, in that, one important exception is there is certain specific government companies. One is your unlisted government company, and the other one is any such government company which is engaged into defense production. To them, section number 186 is not applicable. That is, can they do investments, can they give loans, etc.? Answer is yes, they can do it as per their own provisions. They did not go and check the provisions of section number 186. Then after that, the next section, the last section, that is section number 188, which talks about your related party transactions under section 188. In case of related party transactions, compulsorily you have to pass a board resolution. If at all you want to enter into any related party transactions, you have to compulsorily pass a board resolution if you want to enter into those 7 specific transactions, which can pertain to goods, which can pertain to properties, which can pertain to leasing of property, which can pertain to services, which can pertain to appointing of related party as an agent for any of these things, or if appointment of any related party to the office, or appointment of appointing that related party as an underwriter. These are the 7 pointers. These are the 7 pointers which can be treated as a related party transaction if the company enters into them. For this, you'll have to compulsorily pass a board resolution. If there are certain limits, if these limits are exceeded, okay, if they have specified certain limits and if those limits are exceeded, example, in case of goods transaction, either directly with the related party or as an agent, where the related party is appointed as an agent, where the value of the transaction goes more than or equal to 10% of the turnover of the company, then in that case ordinary resolution will be required. In case of property, if the value of transaction is more than or equal to 10% of the net worth of the company, then OR will be required. If, say for example, we are engaged into leasing of any property, then rent transaction would be there. Then if the transaction value is more than or equal to 10% of the turnover of the company, or if services relating transaction is there, or along with that agent services relating transactions are there, then again the limit is going to be more than or equal to 10% of the turnover of the company. If your aggregate transaction value exceeds these limits, then in that case ordinary resolution would be required. Okay, similarly, if the monthly remuneration that you are paying, if that is more than 2.5 lakhs, or if in case of underwriter you are paying a commission of more than 1% of the net worth, then also your OR would be required. Okay, whenever the OR is required, just remember one thing, you call the meeting. Now in this meeting, there can be some related parties, there can be some related members who are sitting. So should they be voting on that? The related party, if they themselves are sitting, then they cannot vote on their own matter. But if there is any such company where majority of them are related parties only, where at least 90% of them are related parties only, then we are left with no choice. We'll allow everyone to do the voting in that case. Okay, if the related party transaction is entered in ordinary course of business, that is at arm's length price, then the entire section not applicable, because the law says I don't want to interfere here in between. Okay, the law says that I don't want to interfere here in between, and these transactions, to these particular transactions, section number 188 is not at all applicable there. Acha, similarly, remember, whenever the limits got exceeded, we pass the ordinary resolution. But in that case, whenever the transactions are done between holding company and wholly owned subsidiary company, and if it is exceeding the limit, then in that case, the passing of OR is not at all required. They have been exempted from this particular type of transactions. And then whenever any particular contract or arrangement has been entered under section 188, we maintain the details in MBP 4 also in section number 189. Plus we are also supposed to intimate it to the shareholders, consolidate it and intimate it to the shareholders by putting it in the board's report, that why so and so value of transaction was done, what was the purpose of doing these transactions, and all those things. So basically, for the purpose of section 188, we are supposed to take two types of approvals. First one is your board approval, and second one is your shareholders approval. Suppose if board approval is not taken, it becomes voidable at the option of the board. Okay, and they have to ratify it within a period of 3 months. Suppose if it is approval of the shareholders in the general meeting was not taken, so it becomes voidable at the option of the shareholders, and the shareholders will have to ratify it within a period of 3 months. And accordingly, suppose if we have done any transaction with a related party of our director, then in that case, if that person does any default, or if the company suffers any amount of losses due to that particular person, then the director would be liable for that. Okay, then the director would be liable for that. And if suppose there is any contravention which is done under section 188, this penalty was very, very important. If the company has done any contravention under section 188, then the employees of the company, directors of the company, etc., they would be liable for a penalty of flat rupees 25 lakhs if the company is a listed company, and if it is any other company, then the flat penalty of rupees 5 lakhs will be applicable in that regards. This was all about your section number 188, which was talking about your related party transaction. So section 173 to section number 176 talks about meetings. 177 and 178 talks about your committees. 179 to 193 talks about all the miscellaneous things about the powers of the board, restriction on the powers of the board. Then after that, your miscellaneous provisions about compensation for loss of office, contracts in case of one-person companies, and all those things. And three specific sections here, that is section number 185, which is talking about giving of loan to the directors and to other persons, 186, which talks about loans and investments, and 188, which talks about related party transactions. For these three have to be always done at the end, and all these three can be taken up together and done. Right, this was all about your meetings of board and its powers, and I hope you are able to recollect the provisions and you are very, very clear with that.